Where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Well, hello, hello, hello. Happy Thursday, everybody. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. Hi, you guys. I know that currently the Karen Reed motions and limine hearings are happening, so that always kind of throws things off. So I was trying to catch up on what was happening there, and it's just a whole nother nightmare. It's just a whole nother nightmare over there. So let me say hi to you guys real quick, and then we're going to continue with the post-conviction relief hearings for Iowa versus Todd Mullis in the case of his conviction from 2019 for first-degree murder and killing his wife, where he's been sentenced to life in prison. And we left off yesterday right towards the end of day 3, which of course I closed it down, and then when I opened it back up, it was not in the exact same spot that I left. So we're gonna have to make sure that we find that spot again. I think I found it, but didn't have a lot of time to check it out. Indiana Girl says, I think Bev is going to regret not doing the continuance. I don't. I disagree. She doesn't like continuances. I don't think she's gonna. She doesn't live with a lot of regret, Indiana Girl. I don't know. She's kind of like a Judge Gull. They just don't care. They just do it how they want to do it, and that's how it goes. Silly Goose says, I don't know, man. I'll get hate for it, but I can't handle the narrative that someone is speaking the truth for it to just be over the top with junk. Okay, hold on. I don't know, man. I'll get hate for it, but I can't handle the narrative that someone is speaking the truth for it to just be over the top with junk. I think I probably should read up first. So I know what you're saying, but I think I know what you're talking about, and I think I agree. I didn't realize it wasn't a headset he was wearing until T pointed it out. Oh, Mr. Comeover. Comeover gives me a headache. Yes, he does. He's like, meh, 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 meh. Oh, you know what? Let's check and see if I've gotten anything this morning. I got nothing else yesterday on the FOIA, but let me pull up my email and we shall see. No, it does not appear so. Does not appear so. No more on the FOIA. What's up, Rexy? And can I start by thank you for being a breath of fresh air by not gaslighting the fuck out of us? Okay, I didn't know that's where you're going, but you're welcome. I mean, I I think. Oh shit, Silly Goose, you're funny. Hi, Amy. These appointments do good holding their ground. I'm a little upset that Nye doesn't have more trial experience, though. Yeah, but she's like a peer reviewer. Hey, Shaz. Hey, Lacey. Hi, Post-Punk Mama. Hey, Haywood. Hey, Laura. Let me see. Yeah, I was picking up what you were putting down. Yeah, so I was stupid Delphi. I do have some stuff I want to talk about with Delphi. It's not impaired. It's not like needs to be done right this second. So I actually made the decision yesterday with all the drama that I'm like, I don't want to feed more into that. So I think I'm just gonna kind of hold off on that for right now. Plus yesterday, oh my gosh, you guys, I don't know, for all of you that follow the Idaho 4 case, so much dropped yesterday that I'm going through. And so that's why I was actually sitting in my at my desk last night going through all the Idaho 4 documents, why Delphi Live was happening. And there are so many documents that came out. And then we've got the Karen Reed stuff going on. I'm just like, there's just a lot. There's just a lot happening. We were at the part where the come over asked her about range of motion. That's where I figured we were too. You really do some of the best coverage of all the cases. It's appreciated by so many. Well, thank you. At least 24 of you appreciate it. Did y'all say there was a big fire explosion in Delphi last night? Yes. Yes. And I was trying to find the exact location of it because it seems sus. But you left Twitter, so you don't see my Twitter post now. I adore T. When I'm having a crap day, she honestly brightens it and makes me laugh, and I love her. Aww. That's how I feel about you guys. And I'm like, I can't handle it. I don't want to do anything. And then I come on here, and at least I feel better when I'm done. And then I'm like, okay, I'll stand here for 7 hours so I don't have to go deal with life. Hi, Ninja Blue. Okay, all right, let's bring this bad boy up. We have, I am waiting to hear from my husband. Let me clarify this first. I'm waiting to hear from my husband if he will be out of the meeting in time to pick up the little, because little has minimum day. If he is not out in time to pick up the little from his meeting, then I will have a short day today. If he is, then we get to do a long day. So as soon as I know, you will know. Oh, I started to get a little feisty last night in that chat because I felt like I felt like I wasn't being heard, or maybe I wasn't getting the response that I wanted. I don't know, like from the, I don't know, but I did feel a little feisty. I also was, like I said, I was trying to read the Idaho 4 documents at the same time, so I was kind of like let's go. Mabhawk actually had some of the best comments while I was watching that live. It was on North Street somewhere, but someone said near the marathon and filmed near the marathon, filmed it so close by. And Thomas, yeah. Oh, yeah. So, and I don't want to spend any time really talking too much Delphi, but there is down the street from the marathon gas station is an automotive place that is currently owned by somebody who was tipped in as a suspect in Delphi, who was moving from he had his shop at home and was moving it to the shop there, which is by Marathon. So if you guys are on Twitter and you saw that post where I was like, is it the car place? It is not that place, as far as I think, as far as I know. So that's what I was trying to figure out, if it had anything to do with the automotive place, because I was kind of being I made a post on Twitter kind of being facetious, like, you know, how another fire like in Indiana, of, you know, how so what a surprise. And so, like, how many people involved in the Delphi investigation, or items involved in the Delphi investigation, pertained or happened to be involved in this fire? Like, that was kind of like my Twitter post, because as we know, Indiana, and specifically that area, has an abundance of fires. Yes, I understand that this was probably due to the weather, but I don't trust anybody. So then we become, becomes an issue. Okay, so here we are. I think I found the right spot. I'm gonna play it. Thomas, do I need to come in like a WWE wrestler swinging a chair? No, I don't think so. My headphones died, and so my husband had to hear some of it. He said under his breath, "Crack is still whack." I see. Good old Whitney Houston, never letting us down. Never letting us down. Amy, that is honestly, that's kind of where I'm at. I don't think there's any maliciousness whatsoever. I really don't. I just think that I just I don't know how to say this. I think the emotions are really high, and everybody kind of just needs to take that step back and just go, all right, like, chill. Mav, York, I was rolling. I was rolling because I don't think a lot of people were picking up what you were putting down. And I was picking up what you were putting down. And I was rolling. I was like, I can't even focus right now. Hi, Andy. And I love Case's channel. So I don't mean I have no issue with any, I have no issue with any of those people. I just feel like it's very emotional. There's a lot of different things happening that I think is causing the confusion, and it didn't really clarify the things. And so I just kind of feel like it's probably best to just chill, wait it out, get your shit together, like mind, soul, spirit, all the things, and then go, okay, now I'm ready to say what I got to say. The spirit of chat was very much about unity, which I appreciate. Then I was like, Live led me to another channel. Woof, what a mess. Oh, really? I don't know. I had to be done. I had to leave. Yeah. Nigga, we got to talk. Okay. All right. I'll reach out. Okay, so let's get back to this case, because like I said, Delphi the last 2 days, it's just, I don't like the drama. I don't want to fight with all these people. I don't want to fight with I don't want to fight with anybody. I just want to talk about true crime with people. That's all I care about. And I'm like, I don't want to do it, but I think it's hard because I think there's just a lot of emotion on a personal level and then also on the professional level of the case. And I think it just becomes overwhelming for certain people, and it probably is best to just take a breath. Yeah, let's talk murders, corn rakes in Iowa. Let's do it. Let's do it. All right, I guess I should play and make sure you guys can hear it.
Touching her, against her.
Lilith. Hi, MB.
Despite one of the wounds coming through her chest.
So she's grabbing, yes, she can reach back and grab the handle. It's just right.
We're at the range of motion. I don't know if you heard this part. Yeah,
in some
it's not farm stuff, MB.
10 feet above her head kind of location.
Well, you would agree that there would be some force necessary for her to be able to pull it out of her body after being impaled through and through, right?
Yes, that leveraging, again, grabbing the handle and pulling
it sounds right?
Down by her left hip
and
the handle forward, that creates leverage, which causes time 3 to come out.
But you would agree that there's a calculation or a way to evaluate leverage as it relates to the human body, right?
I don't need that. That's not necessary.
But my question was...
Well, Andy, we've done a lot of hair shaming around here, so I don't think I've done any hand shaming, though. But a lot of hair shaming has happened. Because somebody's got to send this guy a hat. This seems right? Oh, yeah, I do. You know what? I haven't shamed the hand, but I do know exactly what you're talking about. His baby hands. And then he points them. And he squishes them together. Okay, I just need somebody who... Indiana girl, I know you'll know because I think you said you're caught up. Am I at the right spot? Because my stream stopped and I had to go back and try to find it. I think I'm at the right spot.
That there is a way in biomechanics to evaluate that, correct?
You can evaluate torque, sure.
And you did not include any mention of torque as it relates to her ability to rotate, correct?
Because it's unnecessary.
And yesterday, though, when you testified, I believe, you mentioned torque and the ability to twist and the inability for you disproved whether or not she was able to push the rate out. Is that fair?
You know what? Give me just a hot. You know what? I figured out that I can. I know what I can do. It was dumb for me just to not do it. Why don't I just go look at the fucking stream from yesterday? Like, wouldn't that make more sense? Like, I could just go look and see exactly what the timestamp was when we end it. Sometimes it's just like, keep it simple, stupid. All right, let me go see what was the timestamp we ended at. Well, that is not the one I want, so that doesn't work. Dude, that was actually like I mean, I'm almost on the money. It was 5 hours and 18 minutes, and this was I started at like 5 hours and 19 minutes. Okay. All right. I don't know why I didn't think of that sooner. You're such a hand hair snob. You can't be holding everything over and expect the comb over's not going to wave at you with its little hand. Give that man some glittery gloves so he can do jazz hands. He would do really good jazz hands. You ended, and I hopped over to Bob, and he was in the exact same place we stopped. No, really? Okay, all right, here we go.
And someone doing, the splits or something, but this is not what we're talking about here.
Is it a relevant human factor as it relates
Something at a gymnast
is range of
relative to or reoriented. That essentially, because the rake is stiff, it creates a leverage to pull out one of the tines, and the time that it pulls out is not deep,
Yeah,
relatively speaking. Or so, yes.
here,
and
her gel
the
body.
image shows that it's being impaled by a model corn rake. Is that fair?
A purchased coin rake, yes.
And that corn rake was used to be of similar shape or spacing of the tines as it relates to the one at issue in this case?
Yes.
So when the impaled wound trajectory is done on the gel torso here, that's to mirror the initial strike or the initial fall, as you would say, for Ms. Mullis?
Yes, it was to try and replicate or demonstrate.
It was. You were right,
here,
silly.
wound A.
And it was wound A, if you recall, the one that came out the other side of her chest?
Yes.
Your report nor any of your data collection references her range of motion, though, correct?
Her range of motion?
Correct.
No.
Here we go.
It doesn't factor in as more of a dynamic variable, whether or not, I guess, the range of motion of her shoulders or arms. Fair?
It does not talk about what her range of motion is.
In fact, your report doesn't evaluate what would be necessary or how she would be able to remove the corn rake at issue here by reaching behind her. Is that correct?
So you're describing the rake. You're not trying to grab the tines, but I don't.
So in the theory in question here, your posited way that this occurred, Ms. Mullis reached behind her and removed the rake. Is that correct?
She did not remove the entire rake, no.
But she was able to generate enough leverage or force to remove part of the rake. Is that fair?
That's what happens when you grab the rake handle, which is essentially right at her buttocks. So just reaching, touching, even scratching your hip.
After it had gone through her full chest cavity.
Yes, that's what I showed you in that previous diagram.
But you didn't evaluate her range of motion specifically, correct?
Your Honor, I don't know that the witness had finished her answer.
There's a question pending. The witness can answer that. Please, counsel, just let's try to let the witness finish her answer before you ask your next question.
Is that okay?
Sure.
Okay. So as that diagram previously showed you, when the rakes are lined up with the horizontal trajectories, the rake handle essentially is against her body or against her buttocks. So essentially you're just kind of scratching. You can reach back and grab it, it's touching you. And pulling it in that manner of the second diagram where you grab the rake or reoriented, that essentially, because the rake is stiff, it creates a leverage to pull out one of the tines. And the time that it pulls out is not deep, relatively speaking. That's why A and B stay in.
Is range of motion an important factor as it relates to biomechanics?
It depends. If I'm talking about a gymnast and someone doing, the splits or something, but this is not what we're talking about here.
Is it a relevant human factor as it relates to the evaluation as per the sources you've included in your report?
It wasn't something that was questioned because I don't have information that she's a manual laborer. She was doing manual labor that day. She can reach down and tie her shoes. So
I apologize. And I understand that, but you didn't evaluate from whether or from what perspective the ability to reach behind her or her range of motion to be able to reach or contract, correct?
It did not seem like a far-fetched ability to be able to reach back and scratch her hip.
Despite it being an instance where she was already impaled.
Yes, it's essentially touching her against her buttocks.
Despite one of the wounds coming through her chest.
So she's grabbing, yes, she can reach back and grab the handle. It's just right by her body. It's not in some obscure, 10 feet above her head kind of location.
Well, you would agree that there would be some force necessary for her to generate, to be able to pull it out of her body after being impaled through and through, right?
Yes, that leveraging, again, grabbing the handle and pulling it down by her left hip and the handle forward, that creates leverage, which causes time 3 to come out.
But you would agree that there's a calculation or a way to evaluate leverage as it relates to the human body, right?
I don't need that. That's not necessary.
But my question was that there is a way in biomechanics to evaluate that, correct?
You can evaluate torque, sure,
And you did not include any mention of torque as it relates to her ability to rotate, correct?
because it's unnecessary.
And yesterday, though, when you testified, I believe, you mentioned torque and the ability to twist and the inability for, you disproved whether or not she was able to push the rake out. Is that fair? Or I'm sorry, or pushed onto the rake. Is that correct?
I'm not quite sure what you mean. You have to clarify for me, please.
You testified yesterday that you considered the hypothesis as to whether someone pushed her onto a rake somehow, and you said you disproved it. Do you recall that?
Yes, if they forcibly pushed her, yes.
And you said because of push on the shoulders, it wouldn't be a possible solution or scenario here because of torque and twisting, and it would flip the rake.
Because of rotational acceleration and horizontal velocity.
But you did not include that scenario as I mentioned in your reports either, correct?
I did not write that in my report.
And so when torque was relevant to disprove a hypothesis, it was a relevant consideration?
I didn't need to calculate it. What do you mean?
How would it flip the rake?
Because the rake is top heavy, and when you have horizontal motion and rotational, when you impact the rake in that position, it's going to cause the rake to flip upward, meaning the handle comes up to the ceiling.
Even when the handle is flush against the ground?
When you impact that rake with that kind of force, that kind of horizontal and rotational motion.
Well, I guess I'm confused here. So she can fall back onto it, right?
Yes,
But she can't be pushed with equal force at the shoulders onto that rake and cause to fall on it.
so again, this is talking about a push, an external load applied to your top of your body. When you fall from standing height, you don't have an additional external force applied to the top of your body.
So here, let's talk in the hypothetical then. Let's say equal force was applied to both shoulders at the top part of a person's body. Oh, I apologize. Let's say equal force was applied to both shoulders by an external force, or person, let's say, to the top part of their body, causing them to fall backwards. Would that flip the rate?
So this is an aggressive push that would generate a horizontal and rotational acceleration.
But merely falling back on it in the presence of an object, causing it, say, an auger, wouldn't cause that imbalance?
No, again, this is not a external force applied to the body above the center of mass.
Does anybody else have an issue with the word auger at this point? Because now I just want it to be auger all the time. I'm like, it's not auger. It's auger. But they're really talking about actual augers. But every time I hear it, I'm like,
Forcing it to horizontally travel and rotate.
And those calculations, again, aren't in your report or in your notes, right?
They're unnecessary. I don't need to calculate that.
Well, there is nothing documented noting you considered that from a perspective of a hypothesis to rule it out if you were just reading your report and notes, correct?
That is correct.
So going to, again, demonstrative J. This is something you created, correct?
oh,
Yes,
MB, this prosecutor could never work on a farm. He couldn't even hold a corn rake. Maybe that's what happened to his hair.
This would be the likely wound scenario of A, B, and C per your testimony in 2D format, right?
ND.
In D, in the two-dimensional format, right?
In the two-dimensional format, that is correct.
But, so this is your probable statement as to what occurred here.
This is what happened. She fell on the rake.
If I rotate this image 180 degrees,
Sure.
does this not supposedly generate the same injuries in question?
Yes.
It does.
Well, you have to look at force, but that is the mechanism.
Strength is a component of force evaluations in biomechanics, correct? One's strength when acting upon an object, for instance.
Yes.
Did you test or have any outside information about Mr. Mullis' strength patterns? or his ability?
No, that's why I use the maximum forces available, so such as a push in literature.
And again, despite it not being documented there, taking you at your word for that, what is his maximum strength ability?
So again, it's in literature, the very maximum reported force for a two-handed push for males is reported in literature.
What is that?
It's 138 pounds.
130.
How many pounds of pressure or force are required to be exerted to puncture the skin?
For one time, is that your question?
Sure.
So one time for skin on the back is approximately close to 75 pounds.
So one time in this instance, Mr. Mullis would have the force capabilities to be able to puncture the skin with one time.
With a push, but we know that the rate can't be entered one by
rate
one
can't do
to
that.
cause this injury pattern.
What's required for 4?
Well, it's 3 that goes in,
What's required for 3 then?
and you consider the clothing. If you consider the clothing, then we're up near between 300 to 340-ish, depending on the conservativeness.
And again, what was his strength pattern or ability that you say you considered at a maximum scenario?
138 pounds for a two-handed push.
And does that evaluate any sort of measures like, I believe, something more dynamic like acceleration?
Yes, that's what we talked about. That is an accelerated push.
I'm sorry, an accelerated fall combined with it too.
So the fall actually, what do you mean an accelerated fall? So talking about a push, if you're pushing someone over, this is an acceleration, not just a static push. So we talked about having the rake against someone's body and you're statically pushing it at a constant pressure, or you're applying acceleration. So when you apply acceleration, it's a more severe scenario. So that scenario has a maximum two-handed force of 138 pounds.
And what would be required if constant pressure was applied?
Less than that.
So less force would be required.
Less force would be required to puncture, that would be generated. Less force would be generated when you apply a constant push.
So it's your testimony that if Ms. Mullis was, say, face down on the ground, for instance, and someone pushed the corn rake into her back, that's not possible?
You would not penetrate the clothing and the skin, no.
And you hold that opinion to a reasonable degree of certainty?
Absolutely.
You also, though, didn't factor in her other wound patterns, correct? I believe yesterday you said you were only retained to consider the penetration wounds specifically, right?
I was asked to focus on them because there are explanations for the other wounds.
Well, you provided no explanation in your report for anything else, right?
Right, I was asked to focus on the penetration wounds.
So you didn't consider it from the perspective of the wounds on Ms. Mullis's knees, hands, or chin?
Right, so actually they fit my scenario. So going up on her knee.
He is so fucking snooty, and I'm not even great at physics, but I can understand exactly what she's saying versus he's just trying to mix shit up.
Is trying to extract the rake, being on a concrete gravel type ground as in the shed is available, that would generate the mechanism to cause those injuries.
Just pushing onto her hands and knees?
Well, crawling, she's crawling.
And the strike on her chin, how was that caused?
So again, that was from Dr. Hammers and to discuss.
And I believe, though, the standards for biomedical or biomechanical evaluations say that you're supposed to accept
Hey, Dom.
the treating physician's diagnosis?
That I do not, I don't diagnose and treat, therefore I don't dispute diagnosis.
I apologize. In your report, I believe it's noted specifically that you're supposed to look to the treating physician or treating provider's diagnosis. Is that fair?
That's usually where the wound pattern is, but autopsy, you're not treating anybody because they're gone. It's the medical professionals that I'm looking for that provide a diagnosis.
Just to quick summarize your evaluation and opinions here as it relates to this instance specifically. Your calculations are not noted in your reports.
The conclusions of my calculations are in my report.
I'm asking about the facts and data that would lead you to those conclusions are not specifically enumerated in your report. Fair?
So the calculations, the foundation for them are included and the conclusions are included
You took no measurements specifically of the location of space.
because it had changed and I had a diagram from the police department right after the incident.
And you did not document specifically, you're assuming that the rake where it was discovered by law enforcement or noted by law enforcement was in fact where the rake was to begin?
No, I did not assume that. I had no other information to indicate that the incident happened anywhere else other than the shed.
Despite knowing that the rake had been pulled out by Mr. Mullis, right?
Because that was what's available in information, that the incident happened in the shed, but if it didn't, it wouldn't change my opinions.
The location inside the red shed where the incident occurred and the physical limitations of the space wouldn't change your opinions?
if they happened elsewhere outside the sheds. That would not change my opinions. I'm not exactly, maybe I'm confused at what you're asking. It seems like you're questioning whether the incident happened in the shed, and I'm just a little confused by that question.
If the incident did not occur in the shed, would your opinion change?
No,
And if the
I guess the question is, if the incident didn't occur in the shed, would your opinion change, sir?
location of where the incident occurred wasn't near the pet carrier, for instance, would your opinion change?
I do like to kiss myself. It's true.
no, because it's again based on the physical evidence of the injuries and the rake. Everything else is supportive.
So no environmental condition would change the opinion of your statements here.
I'm saying that I considered the spacing, but even in that limited spacing where I know that a lateral swing can't happen, I still analyzed it. And I analyzed an overhead, and I analyzed different positions. And all those positions can happen in a location other than the shed. So I considered alternative locations as well. But what comes down to it is the physical evidence and including the rake and the injuries themselves.
With the assumptions that you knew where it occurred in the shed, or no?
There's no
Doesn't matter.
assumptions here.
Yesterday, I just want to confirm, your testimony was that you can't analyze every scenario or every incident in a case. Is that correct?
That would not be reasonable to do. Again, there's, like I said yesterday, there was no information that there was a trapeze available. You know, if there's something that gives me more information, I'm happy to analyze that scenario. It's my job as a neutral party to consider, analyze, and evaluate new evidence.
And the last thing I want to talk about, I understand the statement was that you're salaried by Robson Forensic, true?
True.
But you've been compensated by Mr. Mullis' team or the fund for which is providing for him?
No.
You've received no compensation?
My salary stays the same whether I'm here or not.
Well, I will re-clarify. How much has Robson Forensic been compensated to provide for your testimony and your ability to be here?
I have no idea.
What's your hourly billable rate?
I think it started at, I believe Robson billed me out initially at $640.
And that's $640 an hour?
That is correct.
And based upon an estimate even, how much has Robson Forensic been paid for your testimony here today? How many hours of work have you conducted?
I have no idea.
You have no rough approximation of how much work you've done in this case.
She's not a paid expert like that. Her company was hired. And she gets paid based on her salary. So she gets paid the same salary whether she's in this courtroom talking to your tiny ass or whether she's working in her home office. It doesn't matter. So like this is not, again, relevance to what we're here for. Nothing.
I do not have an idea of the number of hours or the amount. I have a lot of cases, and those are not things I keep track of. That's something accounting keeps track of.
Well, my understanding is that you bill your time and enter that time to be billed, correct?
Yes, if you would like Robson, you can ask Robson for that information. That's completely fine. I just don't have it on memory right now.
And you don't have any approximation of the hours?
I mean, it's definitely more than 10. I mean, but I don't have I didn't count.
Is it $640 an hour to have you be present in travel for trial, for instance?
They bill me hourly, flat rate, yes.
So you being here present for trial over the course here, I believe we had previously discussed that you've been here since Sunday, is that right?
I arrived Sunday night.
Since arriving on Sunday night, have you been, do they bill for every hour you've been present, or how does that
Who
work?
gives a shit?
No, I bill for time that I'm in trial.
So for the rough 7 hours or 8 hours a day, you've been billed at $640 an hour by Robson?
So they bill me hourly, and I bill for the time that I spent here, yes.
There is no point. It's irrelevant. The judge does not give a shit about how much they paid her.
Taking you back to the investigation here, I believe you're present for Dr. Cruz's testimony, correct?
For the trial testimony, this trial testimony, yes.
And do you recall the noted absence of additional bruising or any sort of identified wound or mark as it related to the handle of the rake against Ms. Mullis' back?
You mean on her
What?
buttocks?
Her back, lower spinal column, lumbar spinal area, abdomen, etc.
Abdomen. I mean,
Rexy, they typically want to bring it up in front of a jury because the jury, like, oh, like, she's only saying what she's saying because she was paid $640 an hour to say it or whatever. That's her travel time. That's her being here. She's getting billable billable hours, but it's all through the company. She's not getting paid by the defense. Company got paid by the defense. Why is he bringing it up? I don't know. This is why I don't know why the judge isn't telling him the same thing that she was telling his attorneys. Like, hey, there's no jury here. Nobody cares. I like, as a judge, I don't care how much she's paid. Like, let's move on.
I'm sorry, the backside of her oblique.
So
Her buttocks as well, yes.
her buttocks land on the handle. That
What was that? I'm sorry. I
her
didn't-
buttocks land on the handle, which prevents it from flipping.
Was there any mark
No, there's no
noted
bruises.
during the autopsy, to your recollection or knowledge, to her buttock or back of her leg?
I would not expect that there would be a buttock mark, a bruise on her buttocks from landing on the handle.
Do you recall of any noted abrasion or other marking on her lower back?
No.
Would you expect, like you had testified earlier as it related to abrasions around the wound patterns, for instance, there to be any marking or indication of laying or falling on the handle of the rake?
No.
So her buttocks that contact the rake, and I would not expect an injury there.
Asked and answered.
In this scenario, though, her buttocks would have hit the concrete as well, correct?
Right, a distributed load, so the handle and concrete.
And her arm, I believe, as you mentioned, which the location of where her arm would fall would potentially show some sort of injury to her elbow or the back of her arm. Is that fair?
Objection, Your Honor. I mean, I think the state has said this witness can't provide, medical diagnoses. I think that's what they're asking her to provide.
Sustained.
I don't have anything further.
Any redirect?
I do have some regret, Your Honor.
Hold on. So I don't know if you guys watch these videos or not, but I think they're fucking hilarious. And this tiny hands giant pen thing just reminds me of these videos. So I gotta do it. I'm sorry, you guys. I know it takes away from the case. I apologize, but if I don't do it, then it's just gonna stay in my head until I can let it out. So I just have to. So like I said, I don't know if you guys watch these videos. No, this is because it's really tiny. It's Look. They're so funny. This is how I feel about him with his giant pen. Like, I think that I think that we could. Here's another one here. Hold on. Oh my gosh, this is too funny to me. They're too funny. Hold on. I want the one with the cars, but I can't seem to find it. Maybe it's this one. It might be this one. And I'm not turning the sound on because I have no idea if they have music and we, copyright wise. So you guys see his hand. You guys see his hand with the with the giant pen. This is what I think. This is what I think of. Well, where's the one with the dang car? Oh, this isn't it. Oh, maybe this is it. This is it. This is it. I think it's this one. It's so bad. Okay. All right. Sorry. Okay. So I just a little peek into my brain as we're going through this. This is what my brain sees. So I know I'm terrible. Hi, holy shnikes. We're all going to hell. I know. Well, you know what? They make the videos, so they're doing it for funsies. They're making it fun. It is what it is. It's not like, I mean, maybe we're going to hell because he's got tiny hands, but with his big pen. I love you, Rexy. Oh, shit. Do you know the SNL skit with Kristen? No, I don't think so. Maybe I do. Yeah. When I just start randomly giggling, now you know. My BFF is married to a dwarf. We have a lot of jokes about where to hide things she buys and doesn't want her husband to find. Oh my god, this is awesome. Oh, I'll look up Doreen. Okay, I will. I'm going to Odin. Do you know the name of the blonde attorney that talked to Trooper Idiot yesterday? I think I've seen her in another case. I will tell you right now, if you hold one moment. One moment, please. Did I move it to the other file yet? So many documents now on here that I need to go through. Hold on, let me see if I moved it to his file. If I took it out of my downloads. I did. Where the fudgeolio is it? Here, found it. Okay. Let me see. It's Dory's. Okay, hold on. Let me look it up real quick so I can have it up here. Okay, her name is Erica Nichols Cook. Erica Nichols Cook. Oh, I don't think I moved them. Oh, I am like that. Yeah, Erica Nichols Cook. And then
I'm Janice. I'm Holly. I'm Nora. And I'm Janice. Sisters always stick together even when they fall in love. Like with my boyfriend. With my husband. With my fiance, with my by myself, even though
the forehead and the hands. It's, how did she know? Do they know this? Do they know Duden? They are. That's such a tiny hands. That would be like those little hands that they flip you off. Oh shit. Oh, we have the same dark sense of humor. It's true. That's what's going through your mind when you see him. See, now we know. The more you know. Okay, here we are. Let's go back to now we're on redirect.
Dr. Knight, you were asked whether you testified in a criminal case before. Is there a different set of engineering principles that you apply to an insurance matter versus a criminal matter?
No.
Are engineering principles the same regardless of the type of client who's asked you to look at a particular situation?
Nope, they're all the same.
You talked a little bit about the investigation that you yourself conducted to perform a site visit of the shed in this case.
Yeah, I did a site visit of the farm.
Of the farm. When did you go to the farm?
I don't remember.
Would you rely on any information in your report about when it was that you conducted the site visit? And let me ask you about a question. When looking at your report, refresh your memory about when you conducted a site visit.
Let me take a look.
And let me direct you. We'll see who gets there first.
Oh, September 18th, 2023.
Does that sound right?
Oh, that's the clothing.
Yeah, okay.
Oh, I know the great Kazoo, the little Martian dude from the Jetsons. Is it from the Jetsons? I think it's from the Jetsons. I know who you're talking about.
June 30th and July 1st, 2023. That's in my report.
And when is it that you looked at the clothing and the rake in this case?
September 18th, 2023.
And is that when you took photographs of those objects as well?
Yes.
You were asked a number of questions about information that's in your, and I'm gonna have while I'm asking this question, I'm gonna have our colleague plug back in our computer here. You were asked some questions about information that's provided in your notes versus in your report, and without publishing this document. So I'm gonna ask my colleague to turn the television off for a second, just so we have a clear record of what the document we've been talking about. I'm gonna show you what we've marked as Exhibit 976. And I know there are some that we've addressed some questions, Your Honor, about the admissibility. I just want to establish with the witness that the document that applicant has marked as 976, just what that document is. So without publishing this document, I'm just going to ask you.
And right now, just the witness and myself can see it. It won't be displayed on the big TVs.
Correct, Your Honor. That's what I'm seeking to do.
I see it.
All right. I'm going to have my colleague just scroll through what's on the monitor in front of you. And the question I'm going to ask you is if the document that appears in front of you that's been marked as Exhibit 976 is a complete copy of your additional notes that you provided related to your work in this case.
It appears to be, yes.
All right. And if you need to count these pages, you can, but if I represented to you that that's a 14-page document, does that sound correct to you?
Yes.
Between your reports and Exhibit 976, do those, and I guess your two reports. So between your two reports, let me start this question again. You have photographs that you have provided in this case reflecting your inspection of the clothing and the rake. Is that correct?
Yes.
And did you take photographs that included a ruler in them to measure that demonstrated your measurements of the tines and the length of the rake and the tines of the rake?
Yes.
So you have photographs that show those measurements. Is that right?
That is correct.
Okay. And you took photographs that documented your understanding of her clothing. Is that right?
Yes.
You provided photographs. You provided those photographs as well as the notes that we've been describing that are Exhibit 976. Is that correct?
Yes.
And then you have your two reports.
Yes.
And that is all information that you made available to counsel to provide to the state, reflecting your opinions and the bases of your understanding of the information in this case?
Yes.
Just briefly, since 976 is still in front of you, I'm going to have my colleague direct you to the last page of that document, which is page 14.
I'm here.
All right. You have a references section on the last page of 976.
Yes.
And I think you were asking questions about reference 5. Is that a complete citation for the reference material that you're alluding to in reference 5?
I didn't allude to it. I stated it. But all my references are complete, even with page numbers.
I appreciate that clarification. If I was going to go to a journals database, a medical journals database, using the information you've given for reference 5, I could pull up that article.
Objection reading.
I'll withdraw the question, Your Honor.
Okay.
Using the information that you've provided for reference 5, could you pull that cited reference up in a medical journals database?
You could, but you can just go to Google. If you just type in Nolan and then forces generated, it would pop up. It's widely available to the public.
Is that true for the other references that you've identified on page 14?
That's why I provide complete citations so someone can go get them. Anybody can get them.
It's like asking somebody, what is pi? Like, it doesn't change. So she's not writing all this down because it's the same number. The max force is max force. It doesn't, max force in XYZ is always max force in XYZ. until a scientist comes in and proves otherwise, it's going to be the same. So just because Mr. Comeover doesn't know what max force in XYZ is, doesn't change the fact that it is still what it is. So if she didn't write like the entire pi number in there and just said in her references refer to pi, would nobody know what the fuck that meant? And he'd be like, but you didn't cite that number. You didn't cite the number in your report, right? Like, you didn't put it in there. Like, you just wrote pi. Like, why does it say that? Why does it say pi? I agree, Silly Goose.
You were asked some questions about torque calculations, about the torque, about the consideration of torque in pulling out tine C while pulling a tine out of wound C while tines of this rake remained in A and B. Do you remember those questions?
Yes,
Why is it that you did not need to do a calculation for torque in making that determination?
because we know what came out. That it has to be out to be able to make wound E and F. So that third tine 3, has to come out to be able to make wound E. I didn't need to question whether or not it was out.
You were also asked some questions about why you did not conduct experiments on Ms. Mullis's clothing. Why did you not conduct any experiments on her clothing?
So when you say experiments, that's a little confusing to me, because I think for people not in my field, when you think testing or experiments, it has to be physical, like you're breaking something or, doing something. But looking at the holes, considering them, looking at the location, comparing them to the wound location, that's all part of the investigation process, which is essentially a whole big experiment.
Under your definition of an experiment that you just provided, did you give consideration to the properties of Ms. Mullis's clothing in reaching your opinions here?
Yes, absolutely.
You were asked some questions about the shed at issue in this case, and I want to show you a photograph that we looked at that has been admitted into evidence, Your Honor. You can. While my colleague's doing that, because I want to keep us moving, let me ask you about another issue, and we'll come back to that when it's ready. You were asked some questions about the medical diagnoses in this case, and just some general questions about Dr. Cruz. So I want to direct your attention back to those questions. Did you rely on the information that was provided by Dr. Cruz as to Ms. Mullis's injuries in this case?
Did I rely on Dr. Cruz for the injury pattern?
Yes.
Yes.
Were you in giving your opinions, were you disagreeing in some way with what Dr. Cruz said about that issue?
That is not my role. I don't disagree with medical diagnoses.
You were asked some questions on that issue specifically about the chin injury that there was some testimony about with both Dr. Cruz and Dr. Hammers. Were you present here for their testimony about that issue?
Yes.
Did you hear some testimony from Dr. Cruz that the injury to Ms. Mullis's chin could have been caused from falling and striking an object?
Yes, I heard Dr. Cruz say that, yes.
Is that testimony in some way inconsistent with your opinions in this case?
I mean, it's not consistent or inconsistent.
It's
Are you
irrelevant.
here to
to
offer
her.
opinions one way or another about Ms. Mullis's chin injury?
No.
And has any of the testimony that you've heard about that chin injury as between Dr. Cruz or Dr. Hammers, does any of that contradict your opinions in this case in some way?
No, not at all. Yeah, when I talk about injuries, it's about mechanism. I don't diagnose.
I think we have this photograph up that I asked you about a second ago. And just for the record, what exhibit number is this? 311. All right. So I'm showing the witness what's been marked as 311. The photograph that you're looking at, this exhibit 311, is that a photograph that you took, Dr. Nye?
I don't think so.
All right. And do you recognize what's depicted in photograph 311?
What's depicted is the dog or pet carrier that it was claimed that Ms. Mullis was going to retrieve in the shed at the time of the incident.
Is there anything about the way that the shed appears in Exhibit 311 that contradicts any of the opinions that you've provided in this case?
No, absolutely not.
Did you rely on, I think you can take this exhibit down now, did you rely on the photographs and descriptions of the shed as it appeared at the time of the investigation into Ms. Mullis's death in reaching your opinions?
They were supportive of my opinions.
I mean, you were not assuming that the shed appeared the way it looked when you visited the site?
No, I don't. I don't make assumptions, and no, I did not do that.
You've been asked a number of questions about your calculations, and a couple additional questions I have on that topic in particular. Could another expert perform the kinds of calculations that you performed here in reaching your opinions?
Objection, relevance, and speculation.
This goes to whether her methods are repeatable in her field, Your Honor. That's maybe an artfully posed question, but that's the issue I'm going into briefly.
With that clarification and narrowing of the question, the witness may answer.
Sorry, could you read that back? Thank you.
She might want to
Asked
just
a number of
rephrase it.
questions about your calculations and a couple additional questions I have on that topic in particular. Could another expert perform the kinds of calculations that you performed here in reaching your opinions?
Yes, absolutely, and they did.
Are these methods are the methods by which you performed your analysis and performed these calculations, are they accepted in your field?
Absolutely, yes.
And specifically as to your discussion about clothing, the concepts that you relied on here of the tear force of clothing and the tactical strength of clothing are the methods by which you considered those issues generally accepted in the field of biomechanical engineering?
Yes, absolutely.
Okay, you were asked some questions about this gel torso, and the photograph's not up, but do you recall the photograph that you were showed by the state as to that issue?
Yes.
First of all, does anything about that photograph contradict your opinions that you've testified about here today in any way?
No, not at all.
And I just want to know for the record, it looks to me that you are looking at a copy of that exhibit. So if you're relying on it to answer the questions, I just want to make sure the record's clear since you have it there. The particular gel torso that's depicted in the state's exhibit, why is there a reason that you did not use that gel torso to illustrate your testimony today?
Objection, Your Honor, based upon our prior motion practice and history. We're happy to approach the bench if that's easier. But certainly the question calls for something that has been the subject of much litigation and motion practice previously.
Well, obviously, I'm assuming, of why the gel torso isn't here.
So I asked
I
the
don't
question.
know that. I guess, Ms. Thompson, what kind of record do you want on this? Again, this is a bench trial, not a jury trial.
She already had these answers.
I'm aware of what the procedural history is. Do you want some additional record at this point, or?
I do, and I'm happy to do this in front of the witness because I think this can be brief. But honestly, it was confusing to us to have it marked as an exhibit because it was our understanding that the issues here are what they are. And to the extent that I'm not trying to lead the witness, but you've asked me, so the court's asked me, so I'm going to answer. I mean, I think there's been a suggestion in the questions that somehow this object contradicts the opinions that the expert has provided here, that Dr. Nice provided. And so I think some explanation to clarify that issue is necessary for us to make our record. I think the history of this object is well documented, and it's not our intention to dispute, obviously, the pleadings that have been made, but I think there is additional information that goes to the issue that we didn't raise, that the state raised.
Your Honor, if I may.
Go ahead.
We can read back the specific question if we'd like to, but my understanding was the question was, why didn't you use this specific gel torso? Or what was the specific question may be important here, but the reason this specific gel torso wasn't used in the litigation after this portion has been held out to be not a scientific issue at all. As the court knows from our prior litigation, that's certainly been disputed.
Well, Ms. Thompson, if it is helpful to you, for me to tell you at this point that I didn't find anything with regard to Exhibit D to contradict the earlier testimony of this witness, I think we can just move past that in terms of where we're at.
He's like, oh, I won. What are you going to do
appreciate the
now?
court making that a record. And I think for us, obviously, we want to represent our client zealously. We want to make sure we've made our record. obviously, if that's I think the court has given us some direction in terms of how it is viewing this evidence, and with that understanding, I agree that we can move on.
Okay, yeah, I'm looking at my notes, the questions that were asked with regard to Exhibit D. That's where the questions about evaluation of range of motion, things of that nature were asked. I mean, I guess certainly if you want to ask some follow-up questions about that topic, that's fine. But specifically with regard to the use of gel torso, I don't think there is any need or reason to follow up on that. That particular topic is not going to be useful to the court in making any finding of fact.
I understand, Your Honor.
So essentially, the gel torso was not allowed to be used as an exhibit for some type of motion in limine or something that happened prior to now. And now Tara's trying to bring it up to create a record on why and have clarification on the record of why this witness was not allowed to use it. But we're not really getting there. So yeah, the gel torso, it was that like yellowy thing that they show in the picture. It's just made of gel, and then you can manipulate it. And so they had recreated the penetration wounds. So I don't know what the court's reasoning was, but I agree here. Like, once again, there's no jury. So the judge already knows the answer to this question.
And obviously, again, we want to make sure that we're representing our client in the way that he deserves to be represented. I have two other questions about gel torsos more broadly, not this particular gel torso, that I'd like to ask. And I don't intend to disregard what the court just said. Again, I want to make sure that we're doing what we need to do for our client, Your Honor. But obviously, there may be an objection to this question, but I don't believe it's covered by what the court just told me.
Go ahead.
From an engineering perspective, in terms of the force calculations that you've been testifying about here today, Dr. Nye, does a gel torso accurately represent the human body?
As far as force is concerned, no.
Correct. As far as force is concerned?
No.
One moment, Your Honor.
Just a demonstrative.
Just one moment, Your Honor.
Sure.
Sorry, magnitude of force. Let me clarify.
Well, and just to follow up, because I appreciate that question. When you're talking about magnitude of force, are you talking about the forces that would be required, the amount of force, the magnitude of force that would be required as to the issue we've been talking about, the ability of a porn rake to enter the human body?
Right, I would not use that for magnitude.
It's just to show how it's in the body.
You were asked a number of questions by the state on cross-examination. Do any of the questions that you've been asked by the state here today change the opinions that you've offered about the hypothesis that Ms. Mullis's injuries were caused by her falling on this rake?
No, if I had no other hypothesis and that was the only one I tested, everything fits that hypothesis. It is proven.
All right, no other questions, Your Honor.
Mary Cross.
Just briefly, Your Honor, if I may. Drawing your attention to what is reference number 5 for the article, you stated just on redirect that you could pull up the case of Nolan, Hainsworth, and Ruddy forces generated in stabbing attacks just by Googling it, right? Well, I will tell you that we did Google it in permission to place it on the screen, Your Honor, to work with. Is this the article you referenced specifically for the notes and proposition that you evaluated kick and force injuries that were not related to falling or swinging?
Sorry, I've lost my page. This is, so if you scroll down, let me just see here. Keep going. Keep going. Keep going. Keep going, yep. So hang on one second. Yes,
This is the same article.
yes,
Drawing your attention to what is Table 2.
yes,
Do you see Table 2 in front of you?
I do.
In the actions evaluated included a button, push, slap, and punch, correct?
Correct.
Did not include a kicking or kneeing or any sort of exertional force by what we've talked about here previously, right?
Right, and I didn't evaluate kicking for magnitude, as I discussed.
So this article does not support your proposition that it wasn't kicked or otherwise forced into her body in some other manner, for instance.
That's what she said.
Objection, Your Honor.
Misstating
That's, the question is vague as to kicking or other force. I'm not sure what we're talking about.
Would you like to clarify, Mr. Duden?
Along with kicking or forcing into Ms. Mullis's body, the other proffered aspects of your hypotheses testified to today, those are not evaluated according to this article, correct?
So this article was for the two-handed push. The kicking, as you recall, I talked about mechanism of injury. So it wasn't a magnitude
Mixing
discussion.
up the
This article
testimony.
doesn't cover the stomping either, though, does it?
No, I wouldn't, but it's not related to the position, specific position that Ms. Mullis was in at the time of the incident, so it wouldn't list that.
No.
In scrolling down to, well, I think if we did a control find on this, do you believe this article references clothing specifically?
Can you go up?
Sure.
She cited why
This
she
one,
used
I
this
can point
article
to the clothing ones if you want.
push for.
But it's not this article?
Can you move up a little bit? Let me just review before I speak to it. Can you start at the beginning? I'm sorry. And then, thank you. And then scroll slowly. I'm sorry, I can't do it myself. Okay. Yes, keep going. Thank you so much.
Well, essentially, MB, what they told the jury in the trial is disregard what Tristan said because Tristan's a kid, and disregard what Tristan said because Tristan loves his dad, and disregard what Tristan said because he probably doesn't remember because he changed it from no time to a minute 40 to I don't know exactly how much. So disregard what Tristan said. Therefore, by disregarding what Tristan says, Todd could have had all the time in the world to go over there, kill Amy, and come back. But this guy, what he's doing right now is talking about two different questions he asked her. It's two different questions he asked her about the kicking, and then he asked her about the mathematical equation and the numbers that came to and I'm not going to say it, but the max force for pushing. She cited this article for the pushing numbers, and she said, I didn't cite the number because I put this article that states all the standard equations for pushing. And he's like, so this article doesn't talk about kicking, and this article doesn't talk about stomping and running and cauliflower. I mean, like, no, it doesn't. It doesn't have anything to do with that because that's not what I cited it for.
Much. Yep, keep going. Yep, keep going. Thank you. Trauma, stabbing, keep going.
No, he's like, does it talk about clothing?
Keep
She's like,
going.
I don't know. That's not what I cited it for. Maybe it does.
Keep going.
He thinks he's like got one
Keep
over
going.
on her. She's way smarter than he is. I hope the judge sees that.
And keep going. Perfect. Yes, I confirm that this was not one of the ones. I just wanted to make sure it's not the clothing ones, but I have
not.
clothing ones listed.
It's not the article she used to determine the clothing and how that would impact the force. That's what she said. So you just looked at the whole thing. Yeah, it's not. So yeah, this isn't the article I used. Thank you. Like, what are you proving here, douche nozzle?
And then based upon your testimony here today, is it your testimony that you were able to differentiate the degrees of force at issue here by looking at the wounds and their depths or the aspects of the wound injuries sustained by Ms. Mullis?
So location of wound, knowing it's on her back, and understanding that it's a tensile overload.
So it was just merely looking at the wounds and the depths and information provided to you on that front?
So again, clarifying your question as I understand it, the magnitudes are considering the location, the diagnosis of the wounds, as well as the instrument being a blunt object.
And that's based upon the appearance and photographs and the information provided to you by Dr. Cruz and ultimately Dr. Hammers as well.
Yes.
Looking to the discussion section of the same article here, and beginning with the paragraph of, thus based on both of the results of both experiments. So beginning with this paragraph, thus based on the results of both experiments, in the case of a wound tract involving skin and organs only, applying a subjective scale of mild to moderate to severe force in an attempt to suggest to the court that one could differentiate the degrees of force by simply looking at the resulting wound is inappropriate. All that can be said is that minimal force required for a particular implement to breach the skin and cause injury to the skin and soft tissue only has been met. Did I read that correctly?
Yes.
So
Good job.
here, the conclusion by going off of the appearance of the wounds themselves, we can't really say more than the minimal amount of force that would be required to penetrate it, correct? Based on this article's guidance.
Which is what I use. That's why I use a conservative value. So I use the minimum force. And then I use the blunt instrument cross-sectional area. That's exactly what I did.
I don't have anything else, Your Honor.
One question.
Go ahead.
If at any point in any of your work in this case, Dr. Nye, have you have you relied on the idea that you, in your evaluation, can differentiate degrees of force simply by looking at a resulting wound?
I'm sorry.
Sure, I'm going to ask that question in a
It's a
better
lot of
way.
words.
Does your analysis differentiate degrees of force by looking at the wounds that Ms. Mullis had?
That wasn't what I was doing. That paper talks about measuring force if you, depending on how severe the attack is. That's not what we're looking at. We're looking at forces necessary to penetrate.
You didn't reach conclusions about the force that was at issue, that could be at issue in these hypotheses just by looking at the wounds that Ms. Mullis had. Is that right?
Again, I rely on the diagnoses. So looking at the minimum force and the maximum, say, push, then I'm meeting both ends. So if I take the maximum and I take the minimum and it still doesn't meet, then anything after that is met, essentially.
Were your conclusions on that issue based on your full investigation and analysis, and not just looking at Ms. Mullis's injuries?
Oh, it's a complete, like, I mean, yes, the engineering investigation takes a lot of time and consideration and the scientific method that we talked about.
All right, no other questions, Your Honor.
Anything further?
No, Your Honor.
Thank you, Dr. Nye.
Done with Dr. Nye.
Counsel, do you need to address Exhibit 976 before the witness is gone, or is that something she can be released for?
Your Honor, we sought to admit Dr. Nye's reports, and I think there was an objection to that. And I think this issue relates to, the issue about these notes relates to that concept. I think we're seeking to admit it based on this testimony in that respect, but I don't think we need further information from the witness, and we can take that issue up at the appropriate time.
Okay. 285, I think, was the other exhibit.
I believe that's right, Your Honor.
Yeah, okay. All right, so normally I would say this would be a good spot for our afternoon break. Do we have another witness today?
We do, Your Honor.
All right, let's go ahead and take about 15 minutes at this point. We'll plan on picking back up at 3:15. And if you raise your hand, you swear the testimony you're about to give will be true and correct. All right. If you turn the microphone in front of you on, please, there's a button in the bottom center. There you go.
Did I get it? There we go.
Mike,
Oh, I think I have it.
Hi, Mr. Krogman.
Hello.
Can you state your name for the record and spell your last name for the court reporter?
Thomas James Krogman.
so this is older Krogman. I believe his son is the one that testified in the first trial. If you remember, hold on, my daughter's school's calling me. Hold on. Okay, apparently it was a test. They're testing their emergency call system. Okay, whatever. That was weird. Anyway, the first trial, she is sick, so that was why I was worried that they were calling, because she hasn't been feeling good. Because remember, Tiny Human was sick, and now she's sick. So I was worried. That's what I was worried about. But apparently it's a test. Anyway, so nothing to worry about there. Him and his son are the ones that were driving and happened to see Todd pulled over on the side of the road at Krogman's shit. His cousin was the because remember the place they pulled over on the side of the road was under construction. I think he says it's his cousins, and maybe we'll get clarification. But it was some family member of theirs that Todd had pulled into, and where they were doing CPR. So the Krogmans also know Todd and his family, so they pull in, and then the son Krogman is the one who takes Tristan home in Todd's truck, and Dad Krogman is the one that drives Todd to the hospital following the ambulance. So I think we only heard from son Krogman in the first trial. Somebody in chat, if I am wrong, please correct me on any of those points.
1810 200th Avenue, Manchester.
Okay.
And then I can give her address.
Krogmann.
How long have you lived in Delaware County?
62 years.
Would
Forever.
that make you a lifelong resident?
Yeah,
What do you do for work or employment?
I'm a farmer.
What do you currently raise or grow as a farmer?
Corn and soybeans.
What does that matter?
Have you raised livestock in the past?
Yes,
Did that include hogs or cattle?
both.
Thank you,
Are
MB.
you familiar with when farmers in Delaware County typically plant crops?
Yep.
When is that?
Yep.
Last year it was in April till almost the middle of May.
Is it generally spring?
What's that?
Is it generally in the spring?
Yes, excuse me. Yeah. It was a really nice year last year.
Is it dependent on the weather?
Right.
Yep.
When farmers are planting crops, how long are they in the field most days? In your experience?
I see where she's going.
Sometimes 24 hours a day.
She's going into those
When
Google
you plant
searches.
crops, do you have Wi-Fi in the fields with you?
My cell phone? Yes.
Do you have anything else?
Guidance systems on equipment?
And that would be data plans and things that you pay for?
Yes.
Do you know approximately how many years you had livestock?
Probably all of 30.
And are you familiar with farm equipment?
Yes,
Do you also repair equipment?
absolutely.
I want to ask you about a couple of things, and I have a couple of pictures to show you. The first one is going to be Exhibit 265.
Ooh, silly goose. Those
Looks like
people with
the TV went on.
misophonia are not going to be able to handle that.
It's like mine at home. Never works.
Are you seeing anything on your screen?
Yes, I got it now. Yes, correct.
What is it? What is on your screen?
We call that a corn fork.
Corn fork.
Corn rate.
Do you use those terms interchangeably, corn rake and corn fork?
Yes.
What is it for?
It's for raking ear corn out of a crib, or it's just handy to have. It's like I don't know. It's like an extension of your hand. A lot of times you can reach out and pull lumber, bedding, whatever.
Have you
corn
used it
hand.
to clean out a chicken coop?
No, I've never had chickens, but I've used it in farm houses and stuff like that.
And is it a familiar or common object to see around a farm?
It's kind of like an antique. I mean, it's not nothing you'd use every day type thing. Grandpa had it. It's hanging on the rafter, and it's just a cool thing. You don't get rid of something like that.
Would you consider it a dangerous item?
No.
Would you consider it a sharp object?
I don't know. I never really considered it, I guess.
Would you want your grandchildren to stay far away from it?
I'm pretty sure I got one laying around, and I'm pretty sure they probably messed with it.
Okay, so you don't take any special precautions
No,
regarding that?
no.
We've talked before you got here about augers. Can you tell us a little bit about what is an auger and specifically a sweep auger?
Well, it's a shaft with a spiral flighting on it that has usually a drive on the end that pulls your material to the motor and to the front. Let's say you're moving grain into a sump in an auger to load out. At the end of the bend, you would use that. Or silage, you would transport it from one place to another.
Where would you store an auger, a sweep auger?
Well, you should put them inside, but usually they're not.
When you say inside, you mean like in a barn? Or,
Right, yeah.
Are they stored on the floor typically?
Yeah, they're heavy.
Heavy?
Yeah.
Okay,
Have you
so I'm
ever-
noticing. So this is an interesting, just like side comment here. I'm noticing this is the attorney that was doing the direct examination of Trooper Idiot, or not Trooper. Now I see I'm wrong case. I'm mixing up my cases. Deputy Idiot, Sheriff Idiot. And remember, she was smiling at him a lot. She's not smiling anymore. So then I'm like, I'm trying to pay attention to if she does. So that leads me to wonder then, was she doing it on purpose with Deputy Doofus, or was she? I wonder if she smiles a lot in this one. So just something to pay attention to, because if she isn't, then I'm wondering if, one, either she was told, or two, she did it on purpose because Douche Nozzle doesn't like them and she knows it. And so here she is, like, smiling at him so that he can be like, or she just couldn't believe that he is such an idiot and is the sheriff. Maybe she couldn't help but smile about it. So it might have been intentional. This is technically the same day. See, this is because the way we've split it up, it's different, but it's for them, it's the same day. Okay. Someone told her she's got a nice smile.
On one.
Oh, yeah. I'm sure. Well, when it's running? Oh,
No, when it's laying on the ground or in the.
If I get arrested for anything like major, I want you guys to get a hold of Tara Thompson, because I think she's a badass attorney.
Shed.
I can't really say anything happened. Slip, probably.
Would parts of it move?
Oh, probably so. It's bearings on each end and belt drive to a motor.
Okay. Next, I'm going to ask that we pull up Exhibit 311, which we looked at earlier today, to make sure that you and I are talking about the same thing.
Yes, I have it.
Okay. I have this. I apologize. I can't see what you're doing. Okay. Mr. Krugman, can you see a photo on your screen?
Yes.
Do you know what that picture is depicting?
I see a pet carrier and augers. Looks like sweep augers on the floor. Looks like some totes in the background, and I'm not quite sure what the thing that's painted camouflage is. I can't really say.
Okay. And when you were just talking to us about sweep augers, that's what's also in that photo?
Right. Mm-hmm.
Okay. Do you know Todd Mullis?
Yes.
Yeah, Zach does. That's Tara. She's
When
the
did
best.
you meet Mr. Mullis?
I don't think he was old enough to drive yet.
So you've known him for a long time?
Yeah, I think he maybe is 14 or 15.
Okay. Are you familiar with other members of the Mullis family?
Oh,
as well?
yes, absolutely.
Would you consider your family and their family to be neighbors or friendly?
Yes.
Over the years, what types of things would you and Todd do together?
We did a lot of hunting together. We went kayaking, cookouts in the timber. Just things farm guys do, I guess, Had a few beers here and there,
When Todd married Amy, were you at the wedding?
Yes, I was in the wedding.
Did Todd and Amy bring their kids around camping or to barbecues with you?
Yes.
Have you ever seen Todd get into a fight?
No.
I want to kind of orientate you to like 2018 and that fall. Were you still in regular communication with Todd?
Not very often.
Did you see him and did you talk to him about farm work?
Yeah, but I would say in the last, I don't know how many years, life gets busy and we didn't get to hang out. I don't know, he had his things going, I had mine. I didn't really answer your question probably, but.
Do you know if Todd was also planting crops in 2018?
Oh, I'm sure he was.
Do you know if he was harvesting?
Absolutely.
Do you know if he had a hog farm operation in 2018?
Absolutely. I was somewhat in touch with him, you might say. I knew he sold chemicals and just,
When you talk about selling chemicals, are those also for farm work?
Yes.
And
The picture you looked at, or the one that might still be up, the totes that you mentioned, are those for chemicals?
Yes. Mhm.
Do you know if those totes are heavy?
Are the totes heavy? They weigh about 125 pounds empty. I know because I use them for scrap iron and I got to weigh them back empty.
Gotcha. I want to talk now about November 10th, 2018. Do you remember what you were doing that day?
That was the day of the accident. I was, my son and me were about, I'm going to say, a half mile from my nephew's place. And we were loading scrap iron off a farm. And we seen ambulance, or not ambulance, we seen flashing lights to the east on 38. And we're looking and I was like, well, wonder what's going on. And then a town officer, town cop, whatever, he flew by on the highway, which is way out of city limits, which we thought was pretty odd. So we grabbed the binoculars and looked, and we looked to the east where my nephew's place is. He's just building a house there, and we seen like what looked like that's where the activity was. So we hopped in the truck and headed down. We figured, excuse me, there was a skid loader accident or something. They were building a house. You move a lot of dirt, debris, lumber, everything with loaders, whatnot. And what, the whole story?
Well, I'll ask you another question
Okay,
before there's an objection. What was the name of your son that you were with that day?
Michael,
Michael. And what is the name of your nephew who lived on 38?
Brian.
Brian. And so you and Michael both went down the road to where the squad cars or the deputy lights were?
Yes.
Okay. You said that you thought it was an accident. You knew Brian was building a house, and you talked about a skid loader. For clarity of the record, can you tell us a little bit about what is a skid loader?
It's probably the most awesome machine ever built. You can do anything with it. You move dirt, you can mow, mowers,
guy loves
backhoe
farming.
attachments. There's nothing you can't do with a skid loader.
Can I call it a smaller tractor?
No.
No.
It's just not.
What can I call it?
I've never heard them called anything else but skid loader.
Look at Todd.
Is it a heavy machine?
Yes.
Um,
12,000 pounds probably.
Okay. Is it something that you can take on the road?
Your Honor, I'm going to object. This is fascinating, but it's not relevant.
I guess Ms. Nichols-Cook, as far as the relevancy, is there some reason you think it's relevant?
I guess I'm trying to lay the foundation for why he expected there to be a skid loader accident and why he went there so quickly. So I could just ask him why he was worried about a skid loader accident.
Sure.
Okay. Mr. Krugman, when you thought there would have been a skid loader accident at your nephew's house, was that upsetting or alarming to you?
I don't really think it was either. It was just a matter we had to get there and fix the situation.
Were you afraid somebody was hurt?
Right. But they would have called
Could a skid loader accident seriously injure somebody?
very much so.
Have you seen other skid loader accidents?
I've seen it with the same type attachment on tractors where same scenario. They're building a new
I'm
house.
liking these
The
farmers.
wife was
so
down in the
I'm feeling
trench
it. I got
and
you.
the tractor didn't stop and it pretty much cut her in half.
Okay.
And I'm sure skid loader did the same thing. I mean, you don't know. There's a lot of stuff goes through your head when it's at your nephew's place.
Yes, I'm
Really quick too.
Yeah. Have you yourself been involved in any accidents while farming or?
Yeah. And any one of those guys sitting back there been in an accident. Oops.
Are accidents common
Yes.
on a farm?
Yes. It's a dangerous job. I mean, we don't have to play by OSHA or any of that ruling. And we got so much time to get this done and we just do it. And sometimes you lose a finger.
And do some people sometimes die in a farming accident?
Yes.
So when you got to Brian's property, what did you see?
I seen what looked like a car accident.
Did you recognize anybody?
I noticed Todd's truck.
Okay. Did you see Todd?
Yep. He was standing outside. Well, yeah. Yes.
Did you see deputies?
Yes.
Did you see Amy Mullis?
On the ground. Yes.
Was anything happening to Amy at the time?
I don't know if they're doing the chest compressions or what. I can't say for sure.
Was EMS there yet?
I can't say for sure.
And did you speak with Todd?
No, yeah, absolutely.
And did you ask or inquire about what had happened?
Yes.
Travis.
Have you been to Todd Mullis's farm before?
Absolutely.
Are you familiar with a shed between the hog barns and the house?
The red shed, I've been in it. I don't know, 10 years ago, probably I bought a tote from him on the winter day. I needed a tote, but that's the only time I've ever been in the shed.
Sometimes use just the tip of the
Do you
finger.
have any recollection from that time you were in the shed, how much space was in it or what was stored in it?
It was full. I was just helping him out with taking a tote.
So the totes that you identified in the photo were in those type of totes?
Yes, yes.
At some point, did you learn that Amy had been found in that shed?
Yes,
And at some point, did you learn that there had been a corn rake involved?
yes, I did.
Did that strike you as unusual or strange?
I'm going to object as
Sometimes you lose a toe.
relevance. This witness's opinion on whether that's unusual or strange is not relevant to the issues before the court.
Overruled.
You can answer.
Would you repeat it, please?
The information that you learned that Amy had been found in the shed and that a corn rake had been involved in her injury, was that a strange thing to you or a suspicious thing to you?
It was odd. I mean, anytime there's no there's no normal accident. I mean, you've all seen accidents. You can't make sense of it. It's like, why did this happen? So, I mean, I don't know how I should answer that for you.
In your experience as a lifelong, member of this community and as a farmer, did you have any thought that this wasn't an accident?
No. Object as improper opinion testimony.
I'm not asking for an expert opinion. I'm asking in his personal experience, just like if I asked a witness, how fast was that car going?
Objection's overruled. I heard an answer. Did you, Kelly? Yeah, it'll remain in the record.
Thank you, Your Honor. Did you learn at some point while you were in Brian's driveway that Todd had been on the way to the hospital with Amy?
Yes, I talked to Todd.
Have you ever had to drive a family member to the hospital that was injured?
Yes.
Why do you not wait for an ambulance to come to you?
That's not how we're wired. We fix stuff. There's no time to, I think, I don't know how many times I did it. Once I comes to recollection with my brother. He was back in the timber. It was in the spring. You couldn't even walk. It was so muddy. And he was unconscious and his leg was bent behind him, bleeding. There's no way you were going to get him out of there unless we did it.
So in your experience, is it impractical to wait for an ambulance to get to you?
Yeah, there's probably scenarios where not, but in most scenarios, we fix stuff. We don't wait for nothing.
Was Todd with you the day that your brother broke his leg?
Yes, he was.
And did he help you take your brother to the
Absolutely.
hospital?
I think he rode in the back of the truck and held him down.
Oh, dang.
So on November 10th, when you're in Brian's driveway, do you see an ambulance come?
I don't recall seeing this. I guess I really wasn't paying too much attention to that part of it, because they were working on Amy, and I can't tell you if there was 5 squad cars or 50 squad cars. I couldn't tell you.
Did you see Amy leave in an ambulance?
Yes.
Okay. Did you and Todd get in the ambulance?
No, the prosecutor's just going to be like, did you write that in your report? Oh, you didn't file a report. So it's too bad. Go away. Your testimony means nothing to me.
No.
Why not?
Todd rode in with me because I think it was too full. They didn't have room for
Did you make any observations that you can remember about Todd's demeanor or his behavior?
I think he was in disbelief.
Do you know Tristan Mullis?
Yes.
Did you see him on November 10th, 2018?
Yes.
Did you drive Todd to the hospital that day?
Yes.
Did you stay at the hospital?
Yes, I did.
Do you know where you went in the hospital?
Some small room.
Would it be like a waiting room?
It could be, yeah.
Did you stay with Todd?
Yes, I did.
Were you there when a doctor came out and informed Todd that Amy had passed?
Yes.
Did you see deputies coming in and out of that waiting room?
Yes, I did.
Were you present for any conversations the deputies had with Todd or Tristan Mullis?
I don't think so. I don't recall anything.
Did you observe anything about the medical staff's behavior? Anything that you remember about how they acted towards you and Todd?
I'm going to say cold.
Did you feel that was that a concern to you?
I rolled off me pretty easy, but you just got that feeling.
Oh,
Did you recognize? Oh, I'm sorry.
Yeah, go ahead.
Did you recognize any of the medical staff as someone you knew?
No, I didn't know any of them.
Did you know Amy used to work in that hospital?
Yes, I did.
interesting.
Did you see other members of the Mullis family come to the hospital?
Yes, I did.
At some point, did you and your wife Carol then leave the hospital?
Yeah, we left together. Yes.
I'll be right back. I'm going to let this play, but if there's a spot that needs to be fast forwarded, I won't be able to fast forward for a hot minute. I'll be right back.
Before Amy died,
Medical staff.
I know you said you had more limited interactions or time with Todd. At any point, did you and Todd ever discuss Amy having an extramarital affair?
No.
Do you have other friends in the community?
A few.
Do you sometimes hear people talk or rumors about
absolutely.
affairs?
Oh, absolutely.
Did you also talk to Amy directly over the years, or text or call her or talk to her?
No.
When Amy and the family and Todd would come for barbecues or campouts or anything, did you ever hear Amy complain about being unhappy?
No.
Did you ever hear Todd complain about his marriage or about wanting a divorce?
No.
A couple more quick questions on November 10th. I know it was Iowa in November. Do you remember weather-wise if it was cold?
Yes.
Do you know if there was any snow on the ground?
Yes, there was. Because we had commented loading a skid loader on that trailer, how sketchy it was. It's on tracks and I don't like a wet bed that's snow on it.
When you were doing your scrap metal job at the farm by Brian's, were you walking around outside in the snow?
Yes.
Were you leaving prints?
I'm sure we were.
Do you remember a DCI agent coming to your home to talk to you?
Yes, I do.
Do you remember approximately when that was after Amy's death?
It was cold out.
If I told you the report from the agent is December 28th, 2018, would you accept that?
Yeah.
Okay. Do you remember having this discussion?
Yes, I do.
Do you remember the name of the agent?
No.
Have you had a chance to listen to the audio of your interview with him?
Yes, I did.
Do you know where on your property that interview is occurring?
Yes, I do.
Where at?
Right in the shop.
In the shop?
Yep.
Is the shop a large building?
Yes, very.
What do you do in there?
Everything.
Objection is overruled. The answer will remain in the record.
We do everything in there from snowmobiles to four-wheel drive tractors.
Were any of your children or grandchildren on the farm that day with you?
Yes, they were.
Were any of them in the shop?
At one point, they weren't supposed to be, but he wasn't supposed to be there. He was supposed to come back at 5 o'clock, but he was too impatient, so I had to leave my grandkids in the house. So I had to talk to him then. And one of them slipped out. And
Do your grandkids play in the shop sometimes?
absolutely.
Do they ride their bikes or roller skate or?
All of it. Pickleball, segways, I got it all.
Do you remember the DCI agent talking to you about how Amy died?
Vaguely.
Do you remember him using a term that the medical examiner's decision that it was a homicide was gospel?
Yes.
What did you understand that to mean to you?
I didn't really pay too much attention to it, I guess.
Did you have an impression that law enforcement had already decided who killed Amy?
Absolutely.
Do you know who they thought it was?
Yes. They had the finger pointed at Todd the whole time.
Do you remember talking with the agent about your thought that it was an accident?
I'm sure I did because I don't know if you guys want to listen to this or not, but while I was at the scene, Todd told me what happened. And today he will still tell me that same exact story, that you cannot tell that twice. And it has not faltered one word from the day at the incident
Now,
You can't do it.
Mr. Krogman, does it make sense to you that Amy could have slipped and fallen on that corn rake?
That's
Object is relevance and speculation.
Objection is sustained. That answer will be stricken from the record.
Do you recall telling DCI that it didn't make any sense that it was a homicide?
yes, I did.
Do you remember what DCI wanted you to do?
Well, it's pretty obvious what he was out there for.
What was that?
He wanted me to put some dirt on Todd that I didn't have none.
Have you ever seen Todd get in a fight with someone?
No,
Are you aware of any evidence that Amy's death was a murder?
no evidence at all.
In your experience growing up on a farm and farming, do your kids help with farm chores?
And yes, when they were from little on, they did everything.
So would you have a 13-year-old helping you prep a hog barn?
Absolutely.
Overruled.
Would you let a child use a corn rake?
Yeah, absolutely. Yeah, I'm sure they have.
You were aware that Todd was arrested for Amy's murder in 2019?
Yes,
Do you know who Bob Sabers is?
yes, I do.
Did you ever talk to him about your presence at Brian's house on November 10th?
I don't think so.
Did you ever talk with a Jake Firehome?
I don't think I know that person.
Were you willing to talk to Todd's attorneys if they needed to talk to you?
Absolutely.
Did you attend any of Todd's criminal trial in September of 2019?
Yes,
And did you watch any of it online?
I think all of it.
What was your impression of the trial?
Objection, relevance. This witness's opinion of the trial is irrelevant.
Sustained.
Do you recall hearing defense counsel's opening argument in the trial?
Yes,
How did you feel after you heard that?
Objection, relevance.
Sustained.
As a farmer, do you see a lot of life and death?
yes,
Do you also know the anatomy of the livestock you raise?
absolutely.
Is there significant differences between the anatomy or the organs of a body of a hog and a person?
No,
Have you ever had to Google the anatomy of a person?
Objection, relevance.
That was an issue in the Google searches at trial, and this is being presented to show what counsel could have and should have put on at trial to combat that.
However, Mr. Krogman's need to Google something is not relevant to that determination.
He is a farmer just like Mr. Mullis, and it was alleged that Mr. Mullis conducted that search. So I think it's directly relevant.
The objection is overruled. Was there an answer, Kelly?
Have you ever had to Google or search the organs of a body?
no. We've actually done autopsies on hogs. When you have livestock, second nature, you turn into a veterinarian. So when something happens, you open the animal up and you see if that is the reason this critter died on you. And if you don't, then you have the veterinarian.
Just one moment. Over the years of your friendship with Todd, did you ever observe any behavior that you would consider to be mistreatment of Amy or the kids?
No,
Do you know if you told the DCI agent your opinion on how Amy Mullis died?
Objection, hearsay.
I'm asking if he remembers if he told her. I'm
Question.
not asking what he told her.
question was as to the witness's opinion.
If he remembers telling Turbot if he had an opinion about how Amy died.
The objection's overruled. You can answer.
I'm quite sure I did.
Mr. Krugman, when you were with the DCI agent, do you recall any other statements that the DCI agent or like what he was asking you to do in regards to Todd?
I'm sure he was looking for some dirt on him, but I had none. I told him, I said, I'm worthless to you, man, because I have nothing for you.
Do you remember a part of the conversation or the interview where the agent wants you to like sleep on it?
Oh, yes.
Do you remember what he wanted you to sleep on?
I'm kind of fuzzy on it. I really am.
Okay.
I mean, when you tell me, yeah, it comes back to me, but I can't recall all that long ago.
No further questions.
Cross-examination?
Yes, Your Honor, thank you. Good afternoon, Mr. Krugman.
Hello.
Nice to meet you. You were discussing your interview with Special Agent John Turbot on direct examination. I just have some follow-up questions about that specifically. So that occurred in December of 2018. Does that sound about right?
Yes.
During that interview, you indicated to Special Agent Turbot that you hadn't spent much time with Todd and Amy in 10 to 15 years. Does that sound right?
Probably so.
So you would see them occasionally, but not a regular thing?
Not like we did earlier before they had children.
You also described your relationship with Mr. Mullis as you were his best friend. Does that sound right?
Yeah, we were really good friends. Still are.
What was that?
We still are good friends.
Thank you. You were asked to describe Todd and Amy's marriage, and you referenced that there were a lot of oddities. What did you mean by that?
I'm going to object because I don't believe that was the testimony, the oddities in the marriage. Is that what the question was?
Let me rephrase my question then to make it clear. In your interview with Agent Turbot, you described Todd and Amy's marriage as having a lot of oddities. Do you recall saying that?
No, I'm sorry, I don't.
If you had indicated that, what would you have meant by oddities?
Your Honor, if I could object and ask
I don't
counsel to clarify for the record if he's referring to the audio of the interview or the written report by Turbot. The narrative, do you know where it comes from? It's the narrative? Okay. Thank you, Your Honor, I'm sorry.
Okay. Mr. Bakke, I think maybe if you can re-ask the question at this time.
If you had described any peculiarities, oddities, whatever word you happen to use, would there be a reason for that?
I don't think they spent a lot of time together because all he did was work and she worked at the hospital. So I don't think, I don't know, I guess that just seemed kind of odd to me. They didn't have that much time to spend together.
You indicated that I believe that they've been married for a while, so maybe it kind of, sorry, I don't want to mince your words here. But you were aware of some concerns about Amy being unfaithful to Todd, is that fair?
I wasn't concerned about nothing.
Were you aware of it?
I love that. I wasn't concerned about nothing.
I heard rumors. But as far as, I don't know how you want me to answer that. If I believed every rumor I heard, you wouldn't do it.
In the time leading up to this incident on November 10th, 2018, I believe you told DCI agent Turbot that in the 5 years before that, Mr. Mullis had not brought up Amy's name. Does that sound right?
I'm drawing blank. I'm sorry. I don't.
Would that surprise you? Would you have any reason to dispute that?
I don't know how I should answer that. I don't really know what he's getting at.
You don't know who's getting it.
Turbot was getting
So you don't remember much of your conversation with Agent Turbot? Is that what?
Well,
I don't know what you're getting at, buddy.
you know, long ago it's been quite a while, and no, I do not remember everything that was said.
But sir, you remember whether your footprints were covered up were showing in the snow on the day of this incident, but you don't remember your conversation about it?
With him? No, I don't remember it with him, but you're saying that you don't think I had footprints in the snow? I don't remember that, or what are you asking me?
We'll move on.
Yeah, you should.
You discussed what Mr. Mullis had told you about the incident involving Amy that led to Amy's death, right?
Right.
And Mr. Mullis told you that he had to remove the corn rake from Amy's body because the handle is 8 feet long. Does that sound right?
Objection, can I ask the foundation of where this comes from?
Yes, this is from the same interview that we've been referencing.
Can we have just a moment?
Sure.
Oh, I think he feels like he's trying to intentionally confuse him. And so he's like, I don't know what you're trying to ask me. I don't know how I'm supposed to answer that because, no, I don't remember all the things. Are they arguing? Oh, they're like getting mad at each other.
I'll ask you a question.
Hi, Thomas.
Okay, go ahead. Certainly.
Ooh, I wish they had a hot mic.
Mr. Krugman, just to be clear for the record, you were not personally present when Amy Mullis became injured. Is that right?
Right.
You don't know exactly what happened, even though you have your own speculation, right?
Yes.
So much of your testimony today was based on the fact that you have your own hypothesis of what may or may not have occurred.
Yeah, like everyone in here does, has an idea what happened. Yes, exactly.
Fair enough.
Fair enough.
I don't think I have anything further. Thank you.
Any redirect?
Good.
No, Your Honor.
Thank you, sir. You may step down.
Okay, why did whatever she said to him made him back down? Even though he didn't seem like he was going to back down. Like they were having like a little tiffy-tiff. I picked up on a couple words, but I mean, it's just, I'd have no context. She said something about narrative and he said something about we're going to do that. And then they turned off their mic. I don't know. Like, that was interesting. And then he did end up backing down.
Any further witnesses today?
No, Your Honor.
Anything else that we should take up, or are we ending for the day?
We should discuss the schedule tomorrow, Your Honor, but I don't know if the court wants to do that in chamber.
I think we probably can.
Sorry. There's one brief scheduling thing that might be best since we're done a little early that we could talk about in chambers. And then I believe the court indicated it wanted to make a record briefly about discussions that we had on Monday. I don't know if this would be a good.
Objection, can I ask the foundation of where this comes from? Objection, can I ask the foundation of where this comes from?
I'm going to rewind it for a minute. See what they say.
Yes, this is from the same interview that we've been referencing.
Can we have just a moment?
Sure.
He said, "No, this is inappropriate." That's what young boy said. We're going to move forward. She said something about narrative is not.
I'll ask you a question.
Okay, go ahead.
He said, I'll ask any question. I don't know. It's not what we talked about, her first words. Hi, Paul. Was what you heard in the opening argument consistent with what you understood from the interactions the day of Amy's death? I don't know. Yeah, no. All right, let's go to day 4. We got the young female attorney.
Raise your right hand. You swear the testimony you're about to give will be true and correct?
Yes, ma'am.
All right. Microphone is on, so you should be all set. You can adjust the chair if you need to. Whenever you're ready.
Good morning, Mr. Castle.
Good morning.
Can you please state your name and spell your last for the record?
Sean Castle, K-A-S-A.
She was trying to get him to say that he thought it was an accident as well, but she couldn't figure out how to ask it without it being hearsay. Yeah. I live in a small ranch in California. Does that make me a rancher? I think it makes you a mini rancher. Especially if you have like mini horses or like mini cows. Then you're like a mini rancher. All right. So we got, I don't know who this one is. She's we haven't got to hear from her yet. This is your least favorite witness? Okay.
And Mr. Castle, what is it that you do?
I am a digital forensics expert and a network security consultant.
What?
Network security consultant.
What does that entail?
For the past 15 years, I have served as a consultant in the network security industry, specifically in the IT markets, helping dealerships build networks, telephone systems, and helping their network security posture, as well as serving as a digital forensics expert. I have spent a lot of time learning, teaching, and instructing civilians and law enforcement in the sciences behind digital forensics and network attribution.
Does this include analysis interpretation of the digital evidence?
It does. It's the process of collecting, analyzing, and building threat reports as it pertains to evidence contained within digital devices.
So you have professional experience in digital evidence interpretation and investigation?
I do.
Can you tell me a little bit about the training you have in the area of digital forensics?
Yes. So in the industry of digital forensics, there are several software titles that we utilize on a daily basis. They are annual subscriptions for the licensing on those titles. And as a part of the renewal process, I purchased the training.
I feel like my phone is listening to this like us the last couple of weeks, because I keep getting shit about eggs on my phone all the time. And I just got a notification to let me know why eggs are refrigerated in the United States versus eggs not refrigerated overseas. And I keep getting all this stuff about eggs. And I'm like, why? Why do I have all of a sudden so much stuff coming about eggs? And I haven't put it to, for whatever reason, I haven't picked up on it until right now that one came through. And I'm like, it's because of this fucking case that we keep talking about all the damn eggs. And now my phone thinks I give a shit about eggs. Oh, damn it. I blame Thomas. This is you keep getting stuff about rakes? Oh, shit. That's crazy. Like, leave me alone. I want to know about your silly eggs.
Packages that accompany those titles from Cellbrite, Magnet Axiom, Oxygen Forensics, and Xero FTK. I also teach. I did my adjunct work at the University of Nebraska-Kearney under PhD Matt Miller, and I also am a returning guest lecturer and instructor at the Institute of World Politics in Washington, D.C., where I teach specifically in the area of network attribution and threat intelligence as it pertains to signals intelligence, social media intelligence, and open source intelligence.
So you instruct with the military?
I teach graduate students who are going to be employed by intelligence services such as CIA, NSA, and I also instruct law enforcement at the University of Nebraska-Kearney. I teach them means of correlation of data points and give them an understanding of how to build context within correlation of data.
Mr.
It's taking independent data points as it pertains to the evidence contained within devices, building timelines, and understanding how all of those data points come together to understand the full narrative of events or patterns.
Mr. Castle, have you provided any previous expert testimony?
I have. I've testified in state courts, federal courts, and military courts.
Have you ever been appointed as a special master?
I have a couple instances of which I was appointed to a district court judge. The situation surrounding that was the Attorney General's office of the state of Nebraska had received privileged information and pertains to communications between their client and the attorney. So my role was to be a custodian of the data and assist the judge in parsing out that privileged information so that the AG's office could have a comprehensive report of all of the other data contained within the device.
Have you ever been disqualified as a digital forensics expert in any court proceeding?
No.
Mr. Castle, can you tell us what digital forensic evidence, what that term means?
The science of digital forensics is the ability to collect, maintain the integrity of, and analyze artifacts in digital devices such as mobile phones, tablets, computers, servers, and cloud data sources.
Are there standard operating procedures for digital forensics?
Yes, there are industry standards as defined by organizations like the National Institute of Standards and Technologies, as well as the companies who build the digital forensics tools that we use have best practices and standards for procedural aspects of collecting, maintaining the integrity of, and doing the analysis of the data that are contained.
Would this include the investigation and interpretation of the data?
Yes.
Do you follow these standards?
Yes.
Why aren't I getting those?
Mr. Castle, were you retained by counsel for Todd Mullis?
I was.
And did you examine any electronic devices in this case?
I did.
How did you physically examine the data?
I was invited down to the Sheriff's Department in Delaware County to do my own independent collection of multiple devices on site there in September of 2022. And I also visited the Mullis family farm to collect some devices there as well. Specifically on the mobile devices, my assistant and I collected through multiple extraction processes those mobile devices to also include a network security recording device for cameras, which was located on the Mullis family farm, and also a satellite-based Dish Network TVR set-top box, and multiple laptops. I think there were 2.
What do you do first when you examine an electronic device?
Depends on the device. When it pertains to mobile devices, the first thing to do is to isolate that device from any connected network, placing it in airplane mode and making sure that Bluetooth and other similar network connectivity options are turned off, or by placing it in a Faraday cage or bag to make sure that it is unable to talk to any networks for fear of data corruption. At which point we connect those devices to the laptop or machine that we're using to extract that data and process it for further analysis. With laptops, it requires pulling the hard drives out of the laptops, connecting them to a forensic write blocker, which inhibits the ability to modify, tamper, or corrupt the data contained on that laptop, and do an image of the hard drive for further processing later. That same process is also followed with the hard drive contained within the camera security network video recorder, and as well as the set-top box from Dish Network.
Can you explain what exactly you mean by extraction?
So it is the process of collecting the data contained on the hard drive or the memory within a mobile device or laptop. There are multiple extraction methods available to a digital forensics investigator. With mobile devices specifically, there is logical, advanced logical, and physical methodologies available, both through Cellbrite and Oxygen Forensics. That process is similar in nature for both Android and Apple platform devices, and entails different methods of collecting that data within the device.
What software did you use for the phone and iPad extractions in this case?
Cellbrite UFED, which is a Cellbrite Universal Forensic Extraction Device. I actually licensed the title Cellbrite UFED for PC, which allows me to install that on one of my laptops, making it a little bit more mobile or portable as a solution.
Can you explain the 3 types of extractions through Cellbrite?
Yes. The logical extraction process is a simple process of extracting the data as it exists on the file system of the hard drive contained within the mobile device. That is the same for both Android and iOS platforms. The advanced logical extraction process entails both a file system extraction and on the Android platform, an ADB or Android backup process. On the Apple Ecosphere platform, it would also entail an iTunes backup method. And the physical process of collecting the data is very similar to the process of a hard drive contained within a computer, and that it is a bit-by-bit copy of the data contained on the drive within the device. The physical methodology is the most comprehensive and the best method to use. However, depending upon the device, the software version running on the phone, and the software version of the software that I use to collect, it may not be available as a process.
After the extraction, did you do any analysis on the devices?
I did. I ingested the extracted information into Cellbrite Physical Analyzer, which is the software that Cellbrite produces for that process. And I also ran these devices through Magnet Axiom, which is another forensic title
This
available.
would just be like, that's dumb. That's dumb. I don't know why you do any of that. That's dumb.
To me, and a tool that is commonly utilized both by private sector and law enforcement. Using both tools gives a better and more comprehensive overview of the data, as both titles have specialties, meaning that those software companies have spent their resources and money on specific areas of analysis and have special or unique abilities within that software title. As an example, Cellbrite spends a lot of their research and development time finding ways to circumvent encryption processes utilized by cell phone companies, where Magnet Axiom has spent a lot of time developing ways and means to process the SQL-like databases and JSON files that make up the data constructed within a mobile device. So using both tools gives a very comprehensive overview of the data contained.
You mentioned some other electronic devices. Did you do extractions for those as well?
I did.
What software did you use?
For creating the disk image of the network video recorder for the camera security system and the Dish Network set-top box, I used FTK Imager to produce an EO1 format of the disk image. And for the analysis of the network video recorder for the camera security system, I used the same software title that the law enforcement used, which was DME DVR Forensics. It was the same title that the law enforcement in this matter used for their analysis.
Did you generate a report on your analysis?
I generated a couple of different reports. I will be specific of those. A general report of my findings overall was authored, and then I also created individual extraction reports of the data contained within the different devices that I had an opportunity to do analysis on.
I would like to show the witness what has been marked as Exhibit 272. Is it on your screen?
I do.
Do you recognize this?
This is a current copy of my curriculum vitae, noting my professional experience, training, presentations I've done, and some of my history memory.
And you mentioned this is up to date, so there's no additions?
No, I believe this is the most current version.
And can you scroll down to page 4? And what is this, Mr. Castle?
This is the first page of the report that I authored of my findings overall for this matter.
Does the CV and report, or general report, fairly and accurate represent your work and experience in this matter?
It does.
Your Honor, the applicant offers Exhibit 272.
Any objection?
Yes, Your Honor. Beyond what has been referenced, this exhibit also contains an affidavit. The report and affidavit are hearsay, and in addition to that, the report contains what this witness, essentially credibility findings of this witness, speaking about other witnesses that have testified in this case. His credibility determinations and his opinions about the truthfulness of other witnesses is inadmissible, and the report should be excluded for that reason and because it is hearsay.
Would you like to respond?
Your Honor, this goes to what happened in the underlying trial, as well as the evidence that was presented, and it is a full explanation of Mr. Castle's experience and his analysis of the data that he extracted and analyzed. It's about the weight and not the admissibility of the evidence.
272 will be admitted. However, the court will not consider the affidavit portion of that exhibit or give any weight to any credibility determinations made of other individuals. Is a reference throughout the report, certainly to the extent that counsel is utilizing the report in any questioning of the witness, I would ask that you avoid any of those portions, please. You may proceed.
Thank you, Your Honor.
We must have talked major shit about people who testified at trial. because that's the only reason that would even be an issue. But I mean, if he disagrees with what was said at trial, there's nothing wrong with that. So I don't know if I would be very curious. I'm hoping I haven't heard anything back on any more of my FOIA requests, but I really want to see his report.
Depositions or trial testimony in this case?
I did.
And who would that have been of?
The testimony and trial transcripts of former Deputy Travis Hemseth and the DCI agent, Mr. Trebet.
Your Honor, I see the witness is reading from the screen. Is he reading from the report?
He is, and I can put it up on the TV if that's helpful. Maybe.
Did you
Crazy how
also
long
review the
he's on-
testimony and deposition of Ward Crowley?
I did.
Nicole, you can take down Lisa. Did you receive and review the extraction and digital discovery evidence from Mr. Mullis's criminal trial?
I did.
Jeez.
Mr. Kessel, did you review the iPad that belonged to the Mullis family?
I did.
What browser was used on this iPad?
Primarily the Safari web browser.
On this particular device, did the Safari web browser default to Google searches?
The Safari web browser had the Google search engine as its default search engine.
Did you review Mr. Hemseth's testimony regarding the iPad?
I did.
And do you recall that his testimony about the search history on the iPad was falling off?
I do recall that portion of his testimony.
Was this correct?
No.
And why is that?
I'm going to object. This is going into credibility determinations. He can testify about his own findings and whether, and the court can determine if they are consistent with the underlying trial testimony.
May I be heard, Your Honor?
Go ahead.
This is not a credibility issue. This is about the actual issues and what was actually on the iPad and the evidence that should have been presented at Mr. Mullis' trial.
Yeah.
He's essentially on all day, so just heads up. And then end of the day, we get attorney doofus from first trial at the end of the day. So, and I still haven't heard from my husband whether he's picking up kids, so I may be done in about an hour and 15 minutes, or we may be here for another few hours. I will keep you guys updated as soon as I know.
I agree. Objection's overruled. Do you remember the question, sir?
Could you restate it, please?
Yes, just you were about to explain the search history of the iPad falling off.
Yes. Upon visual inspection of the device, there would be a list of most recent searches that a user had done on the device. But upon the extraction and analysis of the data contained within the iPad, it reveals a longer history or a more comprehensive understanding of all the searches that were conducted on the device.
Can you explain what it would mean for searches to be falling off?
Visual inspection of the device, when tapping in the Google search area, it would show the most recent searches conducted by a user of the device. And that would be a short list, just simply because the screen is only so long and it would only represent those most recent searches that were conducted. But that does not inhibit or restrict the memory of the device or the number of searches that were actually conducted on the device itself. That would be revealed upon the extraction and analysis of the data itself.
So the evidence would still, or the search history would still be available?
In two different locations, one on the device and also as a part of the subpoena offered to Google for the comprehensive search history.
Were you able to determine when the iPad was first activated?
I believe I recall that in August 2017, the first user activity demonstrated on the device was a connectivity to a wireless network, representing the first viable activity recognized on the device in its activation time period.
Is there a way to determine how the iPad accesses the internet?
Yes, the Apple ecosphere keeps a fairly comprehensive system log that demonstrates the network traffic that leaves or arrives on the device via its network interfaces. Those network interfaces being the WWAN interface, which would be the cellular radio on the device, or the Wi-Fi radio interface for standard Wi-Fi network connectivity.
Can you have a cellular data plan on an iPad?
There are a couple different models of iPad. One of those models does contain a radio that is capable of 3G, 4G, and now more modern 5G cellular data transmissions.
Are you aware if the Mullis family iPad had a cellular data plan?
It had a radio that was capable of cellular network traffic. The time frame in which it had a data plan attached to it was determined later.
Okay, I would like to show the witness what has been marked as Exhibit 256. Mr. Castle, based on your experience in this field, is this a document that you would normally see?
Yes.
And do you often see activation plans in your work?
As a part of network threat attribution, one has to correlate multiple data points, one of those being subscriber data, to gain an understanding of the traffic that may have arrived on the device, the IP addresses associated with that traffic, and the data plans connected to them. Yes.
Your Honor, the exhibit is being displayed. This was an issue yesterday as well, where exhibits are being displayed where they haven't been admitted. Thank you.
Did you use this document to reach your opinion on whether the cellular data was activated?
It was one of the data points that I used, yes.
Counsel, and I guess I would just say, I mean, with regard to the displaying of the exhibits, again, this isn't a jury trial. And so it doesn't really matter to that end. Normally, we wouldn't want them displayed because a jury would be seeing them. But to the extent the court is the fact finder, that isn't a concern in terms of what's being seen. Obviously, we have spectators and the media viewing, so there is that. But it isn't those spectators or the media that will be the fact finder in this case. So I just want to note that for the record.
And thank you, Your Honor. The one reason I point that out specifically is some of the exhibits that have been filed have unredacted personal information, social security numbers, minors' names. So if it's up before I have a chance to open the exhibit, it's difficult for me to determine.
Well, yeah, and the issue of redacting information is certainly different. There shouldn't have been anything filed with unredacted information. I think there's only been one exhibit that we've talked about that needed to be filed at a higher security level. So that is something that should be brought to my attention. So thank you for that. All right, go ahead, Ms. Steenson. Sorry for the interruption.
That's okay. Thank you, Your Honor. Does this appear to be an activation plan from US Cellular?
Yes.
Is the phone number the phone number listed, the one associated with the Mullis family iPad?
Yes, it correlates to the telephone number represented in the Cellbrite extraction report.
And what day was this plan activated?
I believe it was October 12th of 2018.
Your Honor, the applicant offers Exhibit 256.
Any objection?
Based on prior agreements with counsel that we will not require US Cellular to come in and lay foundation, I have no objection.
256 is admitted.
Mr. Castle, do you know when planting is generally is?
Objection. This is the foundation.
I sustained.
Were there email accounts connected to the iPad?
Yes.
Is there evidence on the iPad that links to Todd Mullis 76 Google account?
Yes.
Is there evidence on the iPad that links to Mullis RN Gmail account?
I'm sorry.
I'll withdraw.
Okay.
That second part of the question?
Yes. Is there evidence on the iPad that links to the Mullis RN Google account?
Yes, there are artifact evidence of both accounts on the device.
And is there evidence on the iPad that links to the Amy Lynn 5810 Google account?
I did not find any artifacts or evidence of that account being linked.
Mr. Castle, you mentioned earlier that you reviewed the cell phones in this case. Did you analyze Todd Mullis's phone?
I did.
And what type of phone was this?
It was an LG older style flip phone.
During the course of your review of the digital forensic evidence, did you review Todd's US Cellular records?
I did.
I would like to show the witness what has been previously marked as Exhibit 373. Can you tell me what this document is?
It appears to be a phone record of a device.
He is really boring.
Noted. This appears to be the
I hope they get to
phone
meet the
Todd
keynotes,
Mullis's
but
phone.
now knowing how long he's on the stand, I'm not sure.
Are the last four digits of Todd's phone number 1114?
Yes, as represented in the document.
Like, I almost rather the Krogman guy come back and just read this document. At least he's fun.
Are these the records that you received from the state?
Yes.
The applicant offers Exhibit 373.
Any objection?
Your Honor, the only objection I have, as stated in our preliminary objections, is there is highlighting added by Mr. Mullis's counsel on the first page of the exhibit. But beyond that, in agreement consistent with our prior agreement about the US Cellular, I have no other objection beyond that.
373 is admitted with the understanding that the highlighting, I guess, was not original to the document.
Yes, Your Honor, and I believe there has been another version filed without the highlighting in it.
Okay, thank you.
And you can take this one. During the course of review of the digital forensic evidence, did you review law enforcement's extraction of Todd's phone?
I did.
I would like to show what has been marked as Exhibit 353. What is this, Mr. Castle?
And this is a page that was a part of the extraction report of the phone, Todd's phone specifically.
And how is it that you recognize this?
First, it notates the extraction report and the model number of the device up at the top. Then it was also labeled Todd's phone. And as far as the data contained within the report, it represents some sent and received communications.
The applicant offers Exhibit 353.
Any objections to 353?
Minimally, Your Honor, there's some handwriting on it. If additional foundation can be laid, just the handwriting where it says Todd's phone, et cetera.
Ms. Stinson?
Yes, I believe that this. Yes. Did this? Did this come from defense counsel's file?
It did. That's not my handwriting specifically on the phone, but as far as the notes on it, I recognize the report as a result of the model number of the device and the communications on it.
But this is what you received?
Yes. Minus the handwriting.
Does that address your objection, counsel?
I'm fine with it being moved on.
Right. Again, 353 will be admitted with the understanding that the handwriting, I guess, is not relevant necessarily to the exhibit.
Mr. Castle, did you analyze Mrs. Mullis's phone?
I did.
And what type of phone was that?
It was a smartphone with a larger screen, a more modern device.
Are the last four digits of the phone number 5675?
I believe so, yes.
Did this phone have access to the internet?
It did, which was in contrary to Mr. Mullis's phone, which the flip phone had internet capabilities, but there was no artifacts or evidence of any internet usage. Where on Ms. Mullis's phone, it did have a web browser that represented artifacts and evidence of web history to include social media.
Would this also included Facebook?
Yes.
So you indicated that there had been internet searches on the phone?
On Ms. Mullis's phone, yes.
Was there any email accounts connected to Mrs. Mullis's
There were
phone?
multiple accounts.
Is there evidence on the phone that links to Mullis RN Google account?
Yes.
Mullis RN Google account?
Yes, there was.
Is there evidence on the phone that links to Amy Lynn 5810 Google account?
Yes.
Is there evidence on the phone that links to Todd Mullis 76 Google account?
Yes.
Was there a recovery number on the Todd Mullis 76 Google account?
There was.
Can we get foundation for what the recovery number?
The objection's overruled. The answer will remain in the record. Go ahead, Ms. Stinson.
Thank you. Can you tell me what a recovery number is for a Google account?
When setting up a Google account, Google wants a phone number that can be utilized to recover the account in the event of a forgotten password or a security breach, so that they can validate the identity of the user, so that they can have some means of validation that the end.
So far, I think that his attorneys have done a really good job at showing essentially the lack of evidence that was presented at the first trial that would have exonerated Todd in front of a jury, or that would have at least given the jury something to think about, which his attorney didn't do, which essentially this is an ineffective counsel claim, which, you know, it is. I do think, oh, I'm on the wrong question. Sorry, Teresa. That was the next question. I think it's going well. I think it's going well for Todd. The biggest thing isn't about how well they're doing for me, and I think I said this yesterday too. It's about the hurdle of law that they have to be able to surpass in order for this judge to either vacate his his sentence and his conviction, and tell the attorney general, like, hey, you're going to have to do this again if you want to do it again, or to vacate it and say, no, this is done with prejudice, so you cannot be bringing any more charges against this guy under the double jeopardy. So that's my thought on that. Are all 5 of those women at his table lawyers? Yes, from the Innocence Project, except for Dina, the lead counsel on the defense. It's weird because he's the defendant, but in a trial like this, he's actually the plaintiff, because he's the one filing, and then the state becomes kind of the defendant, but it becomes kind of confusing because he is the defendant, but not in this case. I hope that makes sense. And I just lost my contact. Shit.
User is who they say they are, have the ability to then get back into the account in the event of its lock or password forgot scenarios.
So you would be able to reset a password for a Google account through a recovery phone number?
Yes, or offer it as a means of two-factor authentication.
So you mentioned that there was a recovery number linked to the Todd Mullis 76 Google account. Whose number was that?
It was a number associated with Ms. Mullis's phone.
No, it's still criminal. It's called a post-conviction relief hearing. So it's still filed under his criminal case.
On the Mullis RN Google account, did you review the search history from this Google account?
I reviewed the search history both on the device and as a part of the subpoena reply from Google.
Did you notice that the Google account included searches about cabins?
I did.
Over the course of your analysis in the forensic digital evidence of this case, did you review Mrs. Mullis's U.S. cellular phone records?
I did.
I would like to show the witness what has been previously marked as Exhibit 374. Mr. Castle, what is this?
This is a representative of some cellular communications and the telephone number associated with Ms. Mullis's phone.
And is this what you received from the state's discovery?
Yes.
I would like to admit.
Essentially, what I'm getting, they're just laying a shit ton of foundation in a very methodical, very good legal way. It's just very boring for us. If you guys remember, we were watching the trial, and I was like, Deputy Doofus should have actually taken the report that he received from the Google warrant extraction, which was just Todd's Google email address, and compared it to the Celebrite report from the iPad. He would have been able to match up which searches were done on the actual iPad. And we were talking about, was I talking about that on here or maybe on Fish's channel? I don't remember now. That they had all the other devices in the house. They have Amy's device. So if they did a Celebrite extraction from hers, they could also, or the laptop or the kids' Kindles or whatever, they would be able to see what accounts were hooked up to this Google email where those searches were performed based on the actual Celebrite extraction reports versus the Google report. So Deputy Doofus could have actually seen what devices made each search, but he was adamant that that's not how it worked. So he just never bothered to do that. So they're laying a ton of foundation now, just telling us that, yes, he did look at this device. Yes, he did look at this report. Yes, he did compare those things. He did what should have already been done in the first trial. More reason for the judge to be like, I don't know what was going on. Like, you got Deputy Doofus testifying that everything's from the iPad, and that means therefore Todd did everything because it's hooked up to Todd's email address. And it was all done in the middle of the night and under the cover of darkness because he was planning on killing his wife. So it's just taking them a long time to get there. So I want them to get to the actual evidence that he's going to present that shows where the searches came from and if we can see who did the searches. So I may start to fast forward a little bit to actually get to the content, because we know he's laying the foundation and we already know that he looked at all the things.
Exhibit 374.
Any objection to 374?
No objection. Just, however, if we can clarify for the record that it's being received from the state through Mr. Mullis' counsel, but otherwise no objection.
374 is admitted with that clarification.
Mr. Castle, did you analyze Tristan Mullis's phone?
I did.
What type of phone was this?
It was also a smartphone with a larger screen or display and had internet capability and connectivity.
Were the last four digits?
So this is Tristan Mullis's phone. It had internet. It was capable. Since I haven't watched this yet, I don't really know how far to go if I fast forward. So I may just kind of do a couple spot checks here because I want to get to their actual evidence.
For SMS communications, so maybe we could have some further explanation, Ms. Steenson.
Over the and what other types of searches were there?
There was some, under the multimedia category, there were some searches for some adult-related content. Under the multimedia game,
Were those Tristan Mullis's phone?
I did.
What type of phone was this?
It was also a smartphone with a larger screen or display and had internet capability and connectivity.
Were the last four digits of the phone number 1864?
I believe that to be correct, yes.
Were there internet searches on this phone?
There were multiple internet searches on the device.
And what types of searches were these?
Ooh.
There were searches for PC games, mobile device games, several multimedia searches, and searches for very specifically military sniper style games.
And what other types of searches were there?
There was some.
This is Tristan.
Under the multimedia category, there were some searches for some adult-related content.
Oh, Tristan's looking up some.
And what type of online games did you find?
World of Warships and other similar combat-style online games.
And when you say adult content, what is it that you mean?
Specifically pornography.
And were there searches for snipers?
Tristan was looking up sniper games and porn at 13. Hot diggity damn. Get it, Tristan. Tristan's in the courtroom. He's probably like, son of a bitch. How embarrassing.
Yes, it was one of the games that was searched for.
Yeah.
Did you create extraction reports of Amy and Todd's text messages?
Yes, I created an extraction report both from Todd's phone and from Ms. Mullis's phone as pertaining to the communications between those two parties.
Right.
I would like to show the witness what has been marked as Exhibit 307. Mr. Castle, what is this?
This is porn.
This is an extraction report of specifically SMS communications between Todd and I believe that Ms. Mullis's phone, or Ms. Mullis's messages.
Probably is. He's probably so embarrassed.
Did you do this extraction report?
I believe so. The cover page is missing. That would give more detail. From my recollection, yes, this is a report that I generated of the data extracted from the phones.
And besides the missing cover page, is this a fair and accurate representation of the data you extracted?
Yes.
I would like to admit Exhibit 307 into evidence.
Any objection?
Yes, Your Honor. I think more foundation needs to be laid about how this exhibit was created. It's been portrayed as communications and text messages between the two. But after, I believe, page 20 on my version of the exhibit I was given, there's pictures, Facebook posts, all sorts of different things that I don't think were mentioned by the witness.
I think I heard the witness say they were SMS communications, so maybe we could have some further explanation.
They
Ms.
probably were
Steenson.
all looking up porn. They probably both were. I mean, Todd admitted it. That doesn't mean that 13-year-old Tristan wasn't looking it up too. He was. He was so cute on the stand when he talked about that.
While you were analyzing Amy Mullis's phone, did you had mentioned that she had Facebook on her phone. Did you analyze her Facebook account?
I did. And the reports that I generated of those devices may have contained more information than just the SMS or communications between the parties. It may have included other artifact evidence that was contained within the device for review by defense counsel.
Amy was out there creating porn. I feel like this is all a bit of a moot point. What would be important if they did a celebrate on Tristan, Amy, or kids' devices and found any of these searches? Since that's not presented, we can assume that's not the case. So do they not actually present that during his testimony here coming up?
Do you see these? Yeah, can you talk? What page is this? Page starting on page 19. Can you tell us what these are?
Kathy, this just aired a few weeks ago. He's in his 20s now, so he's probably just like, whatever. So what? I looked up porn. Still do. Don't care. They don't? That was the whole thing I was thinking would be the point behind this. Is to say, this search is from this device. This search is from this device. Oh, okay. We got a whole day of just him just talking about the...
These appear to be social media posts or the pages represented on their social media containing images and communications or posts on those media accounts.
And is this from Amy Mullis's Facebook account?
If she was slow so I can validate the, yes, this would be from the Facebook account for Ms. Mullis.
Is Exhibit 307 a fair and accurate representation of the SMS extraction you did and also the Facebook post from Amy Mullis's Facebook page?
Yes, this would be an extraction report of her device containing those items.
Your Honor, I would like to renew my request to admit Exhibit 307.
Any objection at this time?
Yes, Your Honor. May I briefly, while you're the witness, just
Right.
answer this? Thank you. Good morning, Mr. Castle.
At 13, you would have been embarrassed.
Up on your screen, do you have the Facebook messages there? Can you look at the bottom of one of those pages in the bottom right? Can you tell me what you see there?
Oh, goodness.
Counsel, I think you probably have to identify a specific page and then we'll have to have.
I'm looking at page 19. In the bottom right corner, it shows a page number. Do you see
I
that?
thought it was going to be to at least show that a different device did it and show that Hemath is a fool. All right, we'll see what he provides, I guess.
Yes.
And what does it say?
It has a page number of a total number of pages noted there at the bottom.
And I believe it states page 877 of 1,453. Is that what you see?
That is correct.
And this total document appears to be 46 pages, including the SMS messages. Is that accurate?
Yes.
So there is not 1,453 pages from Facebook in this document?
In this document, it would appear to be an excerpt or a extraction of specific pages within that more comprehensive report, yes.
And then if you can scroll just to, can you see the top of that page, the very top line on that, on page 19?
Which line specifically are you wanting me to look at?
So right by the e-filing stamp, is the top of that consistent with something that would be printed off Facebook, or is that something that would be consistent with coming from a Celebrite or similar type of extraction?
Can you scroll down just a little bit so I see the bottom of the page? This would appear to be part of a print of a Facebook page. This specific page, not part of the Celebrite extraction report.
Thank you. Your Honor, I would object on foundation, completeness, and relevance. These two mesh of documents are unrelated, and I don't understand this exhibit.
Yeah, I guess, counsel, do you want to respond to that? It's certainly the way that the exhibit is labeled, and I guess my understanding of what the witness did, it would appear that the first 18 pages make sense. I understand how those were obtained and where they came from. The remaining portion of the exhibit does seem to be cherry-picked pages from Facebook. Can you clarify that, please?
Just one moment, Your Honor.
Sure.
So, Mr. Castle, you mentioned that you did an analysis on Mrs. Mullis's phone that included that she had a Facebook account. Is that right?
Correct.
Well, he admits to doing some of the searches, though. He admits to doing the porn search. He admits to doing that him and Amy were both doing the hunting searches for his daughter to do the safety course. He admits to doing some on the farm equipment. He admits to doing the one about the quote, which ended up being the Hemingway quote. So, I mean, he admits to doing some. The other ones, he's like, no, I didn't do that. I didn't search for Zales. I didn't search for wedding dresses. I didn't. Trying to think of what other ones he absolutely denied that would have been like incriminating. The ancient times one, maybe. What happens to cheating spouses in Aztec culture. He admitted to the Hemingway quote. Am I misremembering that? Because I swear he did. He said he was looking up that they were watching or they were doing something and they were looking up this quote about it was from a movie. He said that he said it was from a movie because he said it was from Predator, and they were looking up this quote. He thought it was from Predator, and it ended up being a Hemingway quote. He denied the ones that were incriminating. I think he denied all the Aztec wife cheating spouse ones. And then he also denied all the paternity ones.
Possible to.
Yeah, no, I'm remembering it now. Yeah, for sure. Oh, and the tattoo. He denied the tattoo. Yeah, because I remember him saying it was from Predator. He said it was because they asked him what movie it was from, and he said it was from Predator. He said, but it ended up being a Hemingway quote. But I think it's the Aztec ones, all the cheating spouse, the DNA, the wedding stuff, and the tattoo, I think is what he denied.
Download information from Facebook?
It is.
And how would that work?
There are multiple ways to acquire that data, primarily for the purposes of integrity. Facebook offers a process of a Facebook download in which they pull all the data from their multiple servers that contain account information, posts, messages, those types of things, and combine it within a single zip file that has a report of all that data the user may have posted or communicated via their social media. Secondarily, there are ways to scrape or pull individual posts and pages from Facebook from the computer. This is a couple of different processes that could have been utilized to acquire the information.
Is a portion of your report these Facebook extracts? Starting on page 19.
Objection, Your Honor. The witness has already testified that this is not this extraction. These are prints from Facebook. And I'm going to add an objection under 403 that the exhibit in its current form is misleading because the page numbers continually jump around.
This exhibit does contain a portion of the SOBAR report that I created.
Okay, I apologize, sir. Yeah. I mean, I guess I heard the witness say that these appeared to be pages that were printed from Facebook. It certainly does appear to be incomplete if we look at the page numbers at the bottom. So we're really dancing around that issue. So the objection sustained for now.
This is really crazy that like the state has hardly been able to argue against the actual evidence presented. They just continue to argue about the admissibility of exhibits. Instead of like, we're so sure and have overwhelming proof that Todd committed this murder. Like it's literally come down to the semantics of what is being admitted versus the truth of the matter.
Your Honor, I would like to offer pages 1 through 18 of what has been marked as Exhibit 307 into evidence, which represents the extraction of the SMS phone records.
Any objection to that portion of 307?
Yes, Your Honor, only because this gets back to my original objection with the exhibit, that I believe additional foundation for how because I believe the witness said this is coming from two different phones, so I believe additional foundation of how the messages were combined would be beneficial.
Okay. Ms. Steenson, would you like to lay some additional foundation specifically with regard to the, I guess, combining of the information from the two phones for purposes of creating a summary on the first 18 pages of 307?
Yes, of course, Your Honor. Thank you. Mr. Castle, can you explain how you created this extraction report?
If I'm allowed to look at the previous 18 pages, I can validate. Okay, this Cellbrite extraction report here specifically is from Ms. Mullis's phone, and is not a compilation of multiple devices. The first 18 pages are just the extraction report of Ms. Mullis's phone, and the communications between her and Todd.
I would like to readmit or renew my request to admit Exhibit 307, pages 1 through 18.
Mr. Bakke?
No objection on that portion. Thank you.
The first 18 pages of 307 are admitted.
Mr. Castle, did you create an extraction report of Mrs. Mullis and Jerry Frazier's emails?
I created a report of the communications between those two parties, yes.
I would like to show the witness what has been marked as Exhibit 308. What is this, Mr. Castle?
It is an extraction report representing emails between the two accounts noted in the second column, Amy Lynn 510@gmail.com and Jerry Frasher 70@gmail.com.
Do we get to read them?
What time period do these cover?
It appears to be November of 2018. Is there multiple pages to this document, just a single page?
Do we get to read them? Maybe I'll try a little bit faster for you. And FYI, the husband's picking up the boys, so we get to stay on.
Can you, Mr. Castle, can you tell us how you created this extraction?
This is too fast.
So
Tell
for
me.
this
and I'll
report,
slow it down.
I chose the email communications category within the Cellbrite application and extracted that data specifically into this basic document.
And is this a fair and accurate representation of the report that you created of the emails between Mrs. Mullis and Jerry Frazier?
As they existed on the device, specifically, yes.
I would like to request to admit Exhibit 308.
Yes, Your Honor. This was also raised in our preliminary objections. Many of these email communications, example beginning at page 3, states that the item was truncated due to length. I don't believe foundation has been laid as to that truncation of the emails. Additionally, it states that it contains body files. Those are hyperlinks that don't go to anything. So the messages appear to be incomplete.
Ms. Steedson, would you like to address those concerns, please?
Yes, thank you. Mr. Castle, can you go to page 3 of this report, please?
Oh, that's nice.
Can you tell me what it means to have this what truncate means?
When generating the report, due to the volume of the data contained within that specific communications, it leaves the final portion of that communication off as a function of generating this report. The source data that the information was derived from is complete and in totality. This report just simply pulls the rest of the data out of it.
Well, no wonder this gets so boring. The state keeps arguing about the fact that it's not complete or there's not any. Where did it come from? How did he extract it? How did he get it? And so then he has to keep explaining all the technical shit. I wonder if they're doing that shit on purpose so that we don't actually get to the meat and potatoes of what the problem here is, which is that there all this other evidence that wasn't actually the actual searches and the actual messages that were not brought up at trial.
Between these two parties happened, and this is a overview or summary of the initial communication between the two parties.
Show us the messages. That's what I want to see. Why are they relevant?
Your Honor, I would like to renew my request to admit Exhibit 308.
Counsel?
Thank you, Your Honor. I do object, and I'm going to object on 403 that in its current form, the emails, the truncated version of the emails are misleading, especially with the full content not being available for consideration. Thank you.
May I be heard, Your Honor?
You may.
The state has all of this data. This is just for, this goes to the weight, not the admissibility. We are asking for, this is just an example of it reflects what was sent between, but the state has all the underlying data. And if they want to cross Mr. Castle on this, they are welcome to.
Counsel, do you agree that you have all of the underlying data that was used to create this report?
She's just like, I really
Yes, Your
don't
Honor,
get
it's
it.
likely in the terabyte of information or approximately terabyte of information that I've received. I don't believe it's a discovery issue. It's that the fact finder here is only getting partial. So I think if there's any specific email that needs to be referenced, it would be more appropriate for that full email to be admitted, not truncated partial summaries.
Certainly. I do think it goes to the weight to be given this particular exhibit, if any. 308 will be admitted.
Mr. Castle, can you tell me what UTC is?
It's Coordinated Universal Time Code. It is a universal accepted standard for establishing a uniform way of maintaining a timestamp globally.
Is this standard in digital forensics?
It is standard in network communications as well as digital forensics, a way of establishing a baseline timekeeping methodology.
What time zone is Iowa?
Iowa is in the Central Standard Time Zone, or CDT, Central Daylight Savings Time Zone, depending upon the time of year that it is.
What is UTC time in Central Standard Time?
It is minus 6 hours from the UTC time code.
And does UTC time change with daylight savings?
UTC remains unchanged. However, the offset for Central Standard Time is adjusted by the hour.
When it is midnight in UTC, what time is it in Iowa?
Non-daylight savings time would be 6 p.m.
Is it typical for extractions to be in UTC time?
That's how the data contained within a mobile device is represented, is in UTC time code stamping. It is an option within the software titles to make that calculation or adjustment for Central Time or daylight savings time accordingly.
So there has to be a conversion from whatever uniform standard time is used.
Biomechanics, that was the post-conviction hearing, correct. Nothing like that, no experts, nothing like that was done whatsoever at trial. At trial, Todd's attorney called 3 witnesses. One was Todd's brother, Mike Mullis. The other one was the young Krogman that drove Tristan back to the farm. And the third was Todd Mullis. And that's it. There's a crazy objection that this attorney does in his testimony where she freezes up completely. Did that happen yet? No, I don't think so. I haven't caught on to anything like that. I do have it sped up, so I don't know how long she'll actually freeze since I'm not watching it in real time and I'm watching it fast. But if it comes up, let me know so I can pay attention.
Used?
Correct.
And the reviewer would have to convert to Central Standard Time or Iowa time or the relevant time zone?
The machine will automatically adjust those time code stamps accordingly, making it less prone to mistake or calculation by the end user or the analyst.
Did you review Mr. Hemeseth's testimony regarding UTC?
I did.
Was he correct that UTC is military time?
No.
Was he correct that UTC is Central Standard Time?
Central Standard Time is a time zone based on an offset of UTC, so no, not appear to be correct.
So the times and dates that Mr. Hemeseth testified to would be wrong?
Hasn't happened yet.
Unless the offset was checked against the time code within the report, it would appear to be incorrect.
Mr. Castle, did you review the Dish Network DVR system?
I did.
And did you do an extraction of this electronic device?
I did.
And this is the system from the Mullis home?
It is. The satellite TV set-top box was the device I retrieved and created a disk image of to do analysis on. I extracted specifically some log files from that device to do analysis on.
Based on your extraction, could you determine what programs were watched and stored on the system?
There are 2 log files specifically that will help an analyst understand both the listings that were available to be watched on the device and also the shows or movies that were recorded and or watched by the end users.
Can you give me some examples?
Yeah, there were a number of Arnold Schwarzenegger titles that were viewed, recorded, and watched by the end users, and a number of History Channel shows to include Ancient Aliens, some presidential history documentaries, and a number of military-style historical documentaries.
Oh. So he actually went in and reviewed what the family was watching, what types of shows the family was watching to see how it matches. I wonder if there's any type of documentation that shows when it was watched versus when these searches were done. Because that's what I always say is like, I'm watching TV with my husband. We look up all kinds of shit related to the show or the actors or whatever.
Can you provide an example of some of the shows?
Yeah, that's Crazy Streets.
Counsel, would you like to narrow your question?
Yes, Your Honor. Was there evidence of Sniper Into the Kill Zone show from the Discovery Channel on the DVR system?
Objection, please.
Sustained.
Can you give an example of a Discovery Channel show that you saw on the DVR system?
Objection, relevance, and foundation.
Overruled.
I believe that there were a couple of log files extracted from the device that would represent the shows that were watched and recorded on the device. And if I could reference those log files, I would be able to better assist you in knowing all of those shows.
I would like to show the witness what has been previously marked as Exhibit 369. Can you tell me what this is?
This is a catalog.back file from the satellite set-top box, which is a file that could be used to determine what shows the user watched, recorded, or viewed on the device. It is a list of those shows and programming.
And can you go to page 15, please? And can you tell me what this is?
The daily schedule log is a log file that represents the guide. When you hit the guide button on the remote, this would show you the shows that are available to be watched or recorded on the device.
And how is it that you recognize these files?
They're documented on the Dish Network website as to gaining an understanding of what those files represent.
Is this an accurate representation of the information you extracted from the Dish DVR device?
It is.
And just for the record to be clear, this would be a portion of the extraction you did on the DVR system?
Yes, it is very specifically 2 files contained within the hard drive of that device.
So if there is a show or something listed on the log file, what does that represent? What does that tell us?
It was a show that was available to be viewed on the device as far as programming that was available at that time. And a good way to correlate it would be to compare it to another document that would be representative of the shows available to be watched, such as a TV guide or a newspaper listing of TV shows available.
And I would like to request to admit Exhibit 369 into evidence.
Any objection?
Yes, Your Honor, I'm going to object on relevance and foundation. The witness has already testified that this is only a portion of the extraction. Additionally, this file is comprised of, I'll say computer language instead of gobbledygook. So I don't see the relevance or how this will aid the court.
Your Honor, may I be heard?
You may.
Your Honor, the state has underlying data for this extraction. This is just a portion of the extraction is quite large, and it goes to weight and non-admissibility. This will go into explaining later on the digital correlating with the digital evidence that was presented at Mr. Mullis' criminal trial.
Do I understand correctly that this is just a listing of shows that were available through Dish to be watched? I mean, not necessarily shows that were watched, correct?
There's 2 files here. And one of them is, as you say, it's a list of files that could be watched. The first portion of this report were the shows that were actually watched or recorded by the device.
And how do I tell that by looking at this exhibit?
So at the top of the page of this particular exhibit that we have open, where it says daily log, that is the file, the shows that could be watched, like the guide part of it. The first part of this file, which was the .back file, which comprises of pages 1 through
The witness should really be able to control what they're looking
right
at.
that you see indicates the shows that were recorded or watched, and that comprises of pages 1 through.
Like, let him scroll it on his own.
Your Honor, both is looking. I'm going to add an objection on calls for speculation because I don't see anything in this that indicates when or if these were actually watched.
Well, I mean, that's my next question is the date. I don't remember that there was a specific date provided.
That's the end of the back file right there. So everything preceding that daily log file portion of this report were shows that were watched or recorded. To correlate the date of the actual viewing of those shows, the TV guide listing for the time period of these shows in question would represent those timestamps.
Well, now it's showing when it was recorded, not when you watched it.
Okay, well, the next problem we have is I'm looking at what is page 14 of this exhibit of the document that was uploaded, which does not appear to be the same page 14 of what I'm seeing maybe on the screen. So let's go ahead and take our morning break at this time and see if we can try to sort this out. We'll plan on coming back at about 10:25. Thank you.
I think they need to take it that extra step further of showing when things were watched and how it correlates to any of the Google searches.
I don't know if you want to just step back and just make sure we're all looking at the same thing. That can help.
Let's see them in the. So there's Tristan, Todd's mom. I don't know who these women are back here. Is that Todd's brother? That kind of looks like Todd's brother that I think testified at the first trial. Is that Todd's brother? I can't really tell. Why are we zooming in on his gun? That was weird.
Go ahead and have a seat. All right, Mr. Castle, I'll just remind you that you remain under oath. And Ms. Sneedson, I think we'll pick up maybe with some foundation questions with regard to Exhibit 369.
Yes, thank you.
All right, you may proceed when you're ready.
Mr. Castle, in pages 1 through 14 of this document, you mentioned that this is the catalog.back files. Can you, are these the, is it your testimony today that these are the shows that were recorded and watched on the DVR system?
Objection, leading.
Overruled.
This file represents content that was viewed, recorded, or watched even in part by the users on this device.
Are you able to determine the timing that these shows were recorded and or watched?
With this document alone, and no.
How can you determine that?
Using correlation and aligning it with the TV guide schedule at the time.
And is this something that you typically do in your line of work?
Yes, using multiple data sources to gain an understanding of context and timeframes is important to understanding the scope of the whole thing. Yes.
Mr. Castle, do you know what dates your extraction data covered?
Based on this document, it does not show the specific date range. I happen to know from TV Guide stuff what it may have covered, but this document does not show that.
When you extracted from this DVR, did you extract all the data from the DVR system?
Yes, it was a comprehensive collection of all the data represented on the hard drive, and these log files represent that.
Do you recall what date you collected this data?
Without referencing the forensic image I created of the hard drive, the forensic image of the hard drive I created, I would have a hard time recalling that.
What year would you have done this?
2022.
And so the data included on the DVR system would be from whenever the service plan would have started to when you extracted the data?
I do not know of what the log file's start date is. I just know when I collected the data. I don't know when the family chose to decommission or stop using this particular set-top box.
We'll come back to this issue.
This testimony is taking
Did the state
too
do
long
extraction
for
on
what
the
this guy has to
DVR
offer.
system?
I don't believe so. I believe they only received the forensic image of the hard drive contained and the data from me and reciprocal discovery.
One more, Your Honor.
You guys need to pick up the pace here.
This DVR system, did you look for History Channel TV guides?
Your Honor, I'm going to object at this time under as relevance in 403 that this is a waste of time because, for example, this document from the DVR says the Andy Griffith Show. If this witness is truly going to say that he can identify which specific iteration of the Andy Griffith Show was watched or recorded or whatever show it is, that there was no reruns at any point other than what could conveniently line up with their theory of the case, this is speculative and this isn't worth the court's time in the state's opinion.
I actually agree with them.
Well, counsel, did you wish to respond?
Yes, Your Honor. This is providing contextual information about what was going on in the Mullis home and also provides corroborating evidence regarding the Google searches that were presented at Mr. Mullis's trial. The state at trial presented these searches without any corroborating forensic digital evidence, and we are now able to do so.
Then do it, I think, is the issue. You're taking way too long to get there. do it.
Which relates to the ineffective assistance of counsel claims in this instant PCR.
I mean, as it stands,
Like, this is not a time for her to be practicing her lawyering. Like, let's go. Like this is for real time. Either get on it and show what you're trying to show. Because, I mean, I'm not the judge, and it's annoying me.
I don't have any information about the dates that would correlate to this information, so I'm having a really hard time connecting it to anything that could be considered relevant, at least without that information. So,
Badass.
you know, again, if there's some further foundation that you can lay to tie that in some way, you certainly may do so.
One moment, Your Honor.
Yeah. He's like, oh, come on.
You can. Mr. Castle, based on your knowledge and experience, have you done examination in internet browser-based searches?
Yes.
What is the difference between a browser and a search engine?
A search engine is a program that is built by a content provider that will index and catalog web pages and the data contained on those web pages on the internet. A web browser is a program that is used to view the web pages on the internet specifically.
What would be an example of a search engine?
Google, Yahoo, Bing, web crawler, Excite are all web-based search engines.
What is the example of a browser?
A browser would be Google Chrome, Chromium, Mozilla Firefox, Apple's Safari, or formerly Microsoft's Internet Explorer.
Let's talk specifically about Google. If you were signed into a Google account on a certain browser, does Google track your searches?
It is an option that the user can elect for Google to maintain a comprehensive list of the searches that were conducted in that browser session, and is not necessarily device specific.
And is this typical?
It is.
Can you explain the difference between a device and an account?
A device is a physical piece of compute hardware, such as a tablet or phone or laptop. An account would be the user profile of the individual signing into that device. There can be multiple devices. There can be multiple accounts tied to devices, and synchronization options chosen therein.
What happens if a Google account is logged in on multiple devices?
There will be evidence artifacts of searches across multiple devices represented in the data that Google catalogs. And in the subpoena reply from Google, it will reflect multiple searches conducted on those devices.
Could two people be searching on two different devices on the same Google account?
Yes.
Would this all be saved in the search history for the account?
Yes.
So Google search history is not device specific?
It can be device specific, but it also can be tied to the user account tied to the device as well. So.
And the objection's overruled, the answer will remain in the record.
So if I understand you correctly, just because it is on a Google search history doesn't mean a certain device searched it?
I'm asking you to be a little bit more specific.
So if I had this phone signed into my Google account, and Tara's iPad was signed into my Google account, and I searched on my phone, could the search appear on Tara's iPad?
Yes, based on user synchronization options, absolutely.
Can you explain the difference between a search and web history?
A search is an end user typing a query of word or phrase into the search engine, asking for results. A web history artifact or evidence would be the visiting of a web page or the following of a link from those search results.
Did you review Mr. Hemesath's testimony regarding Todd Mullis 76 Google account?
I did.
Do you recall him saying that there was no evidence of Todd Mullis 76 Google account on Mrs. Mullis' cell phone?
I recall that.
Was that accurate?
No.
Were there indicators that Todd Mullis 76 Google account was tied to or connected to multiple devices?
Yes.
And which devices were those?
Oh, here we go.
The iPad and Ms. Mullis' phone.
Just those two?
Did you review the Google searches obtained from Todd Mullis 76 Google account that were obtained by the state in the underlying trial?
I did.
Mr. Castle, are you aware that Todd's children took a hunter safety course?
I am.
Objection foundation.
Overruled, the answer will remain in the record.
She's like, I don't give a shit about that. Let's just keep going.
I would like to show the witness that has been previously marked as Exhibit 306. And just for ease of reference, this has been made into a demonstrative exhibit M that has been provided to the state. This is sorry. Mr. Castle, what is this?
It is a media document containing information regarding hunter safety.
Did you review this over the course of your investigation into the Google searches?
It was one of the documents used as correlation to understand the searches that were conducted across multiple devices.
And are you familiar with this handbook and how it relates to the Google searches found on Todd Mullis' 76 Google account?
I'm going to object that on relevance, foundation, and speculation. There's been no foundation that this document specifically was used or read by anyone or when, and where this line of questioning is going is the exact same as the DVR.
Would you like to respond, counsel?
Yes, Your Honor. This document will show that the Google searches are exactly verbatim for what this hunter safety course purports in there and with the internet searches. And trial counsel could have found this document and should have known that Todd's children had taken the hunter safety course and would have had access to this information.
Okay, and maybe that's true, but again, as far as foundation for how this witness would know how anything about this would correlate with what he did is maybe unclear at this point. So if you'd like to lay some additional foundation, you can certainly do that.
Mr. Castle, did you review Exhibit 306?
This document?
This document, yes. Your Honor.
I did. During the course of the investigation into the Google searches that were conducted across multiple devices, I noted a pattern that was curious in regards to, they all seem to be related to outdoor shooting activities and firearm safety. Upon further research, I discovered that there was the pattern lined up with maybe an open book test or some type of exam as regards to the hunter safety course.
It's not unfortunate that it's even up for debate. Like, literally, here's the hunter safety course that she took. Here's the date she took it. And look at the questions on the test. And then look at the dates on the Google search. Like, it's so much to get to that endpoint. And I know they have to do all the legal blah, blah, blah. But it's like, the judge can tell that. Like, I think anybody who knows anything at this point knows that those searches are from the hunter safety course.
And did you review the trial testimony of Mr. Hemisap regarding this series of searches?
There seemed to be some question as to the specificity of the searches being of a violent nature. And to get a better understanding of the pattern there, I wanted to see what came about. It revealed itself to be a series of searches regarding firearm safety and very specifically.
I'm going to object, Your Honor. This is speculation and foundation. Once again, this witness has not established that any particular person in the Mullis family or anywhere else has actually reviewed this document, and it's speculative.
That's what Todd testified to in the first
I guess
trial.
I'm not sure how the witness got this information or what his investigation revealed or where he got this particular guide from. The witness can continue his answer.
This is not
During
good.
the course of the investigation, when I noticed that the searches conducted on multiple devices, the laptop, phone, and tablet, reflected a pattern of firearm safety specifically and hunting, there was a timeline that emerged that demonstrated an evening of study in regards to firearm safety and hunter safety.
Your Honor, I would like to also note for the record that the state previously indicated they would not be objecting to foundation or authentication or identification of this particular document.
And while that is true in our preliminary objections, the court did subsequently grant good cause to the state to be excused from the foundational requirements pre-trial. And however that may be, we don't object to the foundation in that we don't need someone to come in and authenticate this document comes from whatever magazine it's from. That doesn't mean this witness has not laid the foundation for how he is aware of this exhibit or how it pertains to this case.
May I ask the witness a few follow-up questions?
You certainly may. I think he had finished his previous answer.
Thank you, Your Honor. Is this document the official study guide for the Iowa DNR safety hunter safety course?
Objection, foundation, leading, speculation.
It's sustained.
My God. This is terrible. Kara needs to just take over.
Your Honor, I would like to enter Exhibit 306 into evidence.
Mr. Bakke?
Again, we do not object to the foundation that this is, in fact, a magazine. I would object on relevance to this case as no relevance has been laid.
And again, on relevance point, I still don't have any information necessarily about specific timeframes, where this came from. I agree. I'm not seeing the relevance yet. It just hasn't been demonstrated by the evidence. if you'd like to continue to lay some foundation, you certainly can.
Come on.
It will not be admitted at this time.
Just one moment, Your Honor.
This is painful.
For this PCR case, in the deposition of TPEM, it does indicate that hunter safety courses were taken and completed. It includes certificates that proves that TPEM and Tristan took these courses and were certified. Additionally, this is the hunter safety course. It is not a magazine. It is this the study guide for this hunter safety course that the DNR utilizes.
And
TPEM's deposition has been admitted into evidence.
And I understand that, and I have reviewed that, and I am aware of that. And I don't think that that's the basis of Mr. Baki's objection. I think his point is that that information hasn't been tied to this witness. I mean, is that fair, Mr. Baki?
yes, Your Honor,
Okay.
we certainly do not dispute that some hunter safety something was completed at some point, but it's the connection between the two.
Your Honor, may I be heard briefly?
Sure.
Mr. Hemseth's testimony at trial has specific searches, a series of searches that indicate this, that are related to the hunter safety course, and they have a specific date tied to them as they are from the Google subpoena, and so they have the actual date of the search. The certificates that also are in evidence that of the hunter safety course shows just a little bit later. There's also additional Google searches that correspond with the field day searches, which includes the follow-up to the online test that TPEM was taking on the day of the Google searches, and this is provided in her testimony, but Mr. Castle had access to the Google searches. He had access to Mr. Hemseth's testimony regarding the Google searches and his own experience on using correlative data to understand evidence and what trial counsel should have done at trial.
I think she understands what she's trying to get in here, but she just isn't understanding how to get it in. And it's just causing such a clusterfuck and a waste of time that that's going to irritate the judge.
Todd indicating that his children had taken these.
So I think Mr. Baki's point, Ms. Steenson, is essentially that all of the factual assertions that you just made in your argument just need to be asked in the form of a question to the witness so that we can get that into the record. If I'm understanding his objection correctly?
Yes, Your Honor, and I additionally noted, just was pointed out to me, that this document is also copyrighted in 2022, which, if I understand correctly, is after this trial.
What?
So are you objecting to?
It just plays into the relevance objection, Your Honor.
Well, and so maybe this
It's not
document being used as a demonstrative rather than an exhibit, and I guess I'm a little bit confused about how you're intending it to be used. You referred to it both as Exhibit 306 and also demonstrative M. So we'll maybe need to clarify that at some point too, but
Jesus Christ.
I guess maybe you want to address that as well, Ms. Steenson. So,
So the study guide they brought in is dated 2022 instead of getting the study guide that's actually dated from 2018. So you can't correlate the searches to this document because this document didn't exist. You need the one that was revised from 2018. He has the longest nostrils like in the world. Did you guys see that?
For the point that you had just asked, this is, the hunter safety course is what has been previously marked as Exhibit 306. The demonstrative has certain pages from the guide included with the Google searches just for ease of reference. So it is not, we're not jumping from exhibit to exhibit. So it is just to make that exam hopefully a little bit more streamlined, Your Honor.
okay, I understand. Those are two different things.
Yes, Your Honor.
Okay. All right. Back then to the issue maybe of some additional foundation for this exhibit. Did you wish to follow up on that?
Yes, I would. Your Honor.
Okay,
Thank you.
go ahead.
Mr. Castle, did you review Mr. Hemseth's testimony regarding the Google searches on Todd Mullis 76 Google account?
And not only did I review his testimony and transcript, but I also had opportunity to review the subpoena reply from Google regarding the searches conducted across multiple devices.
Yeah, but I just don't know if this is the right time for that.
Did you review, based on Mr. Henseth's testimony, the searches that were testified to in August of 2018?
I did.
And did those searches stand out to you?
Yes. The subject matter contained within those searches was interesting and curious in the means that it was discussing firearm safety, and that some of the searches conducted also referenced the Hunter Safety Guide, specifically the taking of an online test.
Have you personally taken a hunter safety course?
Objection, relevance.
Overruled.
In the state of Nebraska, I did complete and take the Hunter Safety Guide, the coursework, took the test so I could become a hunter in my state. That's what gave me the understanding that some of these searches were relevant to that particular topic.
Your Honor, I'm going to lay an additional objection at this time that I'm unclear of what the scope of this expert is at this point. I believe he testified that he's a digital forensic expert, a network security consultant, and I believe he was only certified for those purposes. And now it appears that he's trying to be certified as a hunter safety expert and some sort of sociologist on what the inner workings of the Mullis family, what they're watching on TV, what they're Googling, and why. And it far exceeds the scope of this expert's background in digital forensics.
Your Honor, may I be heard for you?
You may.
Mr. Castle has demonstrated that in addition to being a digital forensic examiner with extracting data and analyzing the evidence, he also uses other evidence to examine such evidence for interpretation and investigation, and in showing how correlates and causes how you can interpret the data. The data used at trial was solely these searches, and was very misleading without this other information surrounding these searches. And that is what Mr. Castle does as his occupation, and he is very well qualified to provide information about what these searches mean with the corroborating evidence.
And briefly, the state likewise believes this testimony is very misleading in that this digital forensic expert is attempting to connect dots far beyond the scope of the foundation that's been laid and beyond the scope of his expertise.
Certainly the court does not consider Mr. Castle to be an expert in hunter safety. Even if he was, that is not an issue that is relevant in any way to this trial. I think we are getting off track and making this issue way more complicated than it needs to be. Certainly the witness can testify about the commonly accepted practices within his area of expertise used to verify data that he extracts from devices or to interpret the data that he extracts from devices. That's where our focus needs to be, I think. And the court's not going to consider him an expert for anything beyond the areas that he is in fact an expert. So Ms. Steenson, if you would like to ask another question, you may go ahead and do so.
Yes, Your Honor.
No, it's not her fault. I don't disagree. I think that they shouldn't have put her on this. The thing is, I think that she's the tech one. I think she's like the tech attorney, and you can tell that she actually understands what she's talking about, because when she's doing the argument to the judge, she's very thorough, knowledgeable. That the issue is her getting the right questions to the right guy at the right time. So, and I'm all for teaching. The problem I have here is this is the last hurrah for this guy. That's where I'm at with it. Like, make sure that you get in what you need to get in to get him his new trial. So this could have all been prepped. These questions could have all been prepped and ready to go.
I would like to show the witness what has been previously admitted as Exhibit 270, and I would like to show page 3.
Right. And I'm sure she probably actually already understands it. She's just trying to make sure the record's clear.
It's waiting for the signal to come up on screen.
I mean, shit, we all understand it.
It's still not being displayed yet.
Okay.
I'm not sure. Did you switch devices or?
Erica, can you turn
If
the
the
TV?
state didn't object so much, the judge probably would not give
So
two
we can
shits
see
about
what the connectivity issue is potentially.
but the state really cares about the
Just
evidence.
discuss, since this is admitted, we're fine with this being to help us.
How the evidence is admitted versus
Okay,
the evidence
270,
itself.
I also have a paper copy. I can just bring up to the witness if that's all right.
That's fine if you'd like, sure. I'm not sure why it's not popping up on the screen. Did you switch devices or?
Yeah.
Okay.
I like this judge too. I didn't dislike the first judge though in the trial. But the other thing is we didn't get to hear all the motions filed pre-trial.
Page 3 of this exhibit.
Okay.
Do you see a series of searches that are dated August 7th of 2018 UTC?
At the bottom of the page, yes.
And then this continues up to searches that begin on August 9th, 2018 UTC?
Yes.
And just for the clarity of the record, do the searches go sequentially from the bottom of the page to the top of the page?
Yes.
The search dated August 9th, 2018 at 17:38 UTC. Can you tell me what that search is?
What fraction of firearm incidents occur in the home?
And based on your knowledge and understanding of UTC time, and your knowledge of, what time would this search actually have been conducted in Iowa time?
So it's in the time denoted in UTC is in military time or 24-hour time period. So it's not denoted in 12-hour time period. So it's 17, 38, 25 seconds. So if you subtract at this time, in August would be daylight savings time, so 5-hour offset. So it would have been 12, 38, 25 seconds. Would have been the time UTC according to that entry in this document.
And what would that be in Iowa time?
Sorry, but in 12-hour, I just gave it to you. The minus 5 hours is 12, 38, 25.
Thank you.
And that's UTC time code. The adjusted for 12-hour period would have been, it doesn't, sorry, 1,700 hours minus 5, 12 hours, 38 Central Standard Time, daylight savings time adjusted.
Yeah, I like her more too.
Is there a search just a few moments later?
Which one specifically are you asking for?
The one just right above.
Search for examples of elbow carry of a firearm.
And what is the next search that occurs?
The search for checking for obstruction in your firearm.
And what time is that search done?
1743.
And now I believe that the exhibit is on the screen. Do these searches continue through August 9th, 2018 at 2021 42 UTC?
They do. And as you can see from the not only just searched but visited web pages, there are references, multiple references to different states under safety guides.
What indicated specifically in these searches to you that they were connected?
The time frame in which the sites were searched and the subject matter visited subsequently. So there would be a search for a topic surrounding firearms or hunter safety, and then there would be a web page visited pertaining specifically to hunter's education.
Can you look at the Google history, same page, August 9th, 2018 at 17:44:16 UTC? Can you tell me what that website that was visited is?
You said 17 what?
17:44:16 UTC.
Visited Quizlet.com, hunter safety quiz, flashcards.
And the visited site right above that, can you tell me what that is?
huntersed.com/Washington/study guide, loading and unloading steps of a firearm.
And a few searches up at 17:48:52, can you tell me what that Google history is?
I'm going to object that this exhibit speaks for itself. This was admitted, I believe, as Exhibit 105A at the underlying.
Oh my God. This exhibit speaks for itself, but I've just been arguing about all these other foundational exhibits. And so now she's trying to lay foundation for him to be able to speak on what the searches actually were for. And he's like, I'm going to object. This exhibit speaks for itself. You know what, Nostrils? Shut it. Shut it. Just let her get the shit in. Let's move on. Your commentary is not needed.
the sticker on the front page. The court can certainly read every search and visited site if it so chooses. The jury would have had this to the Google searches to review for themselves. I just believe under 403 this is a waste of time in the state's opinion.
Your Honor, may be heard briefly.
I'll allow the applicant to make whatever record they think is necessary. If you want to continue, Ms. Stinson, you may, so the objection is overruled.
And do
That did
these
not sound good.
searches based on your, and this Google search history based on your knowledge, experience, and education indicate that they are for, therefore, a hunter safety course, people searching for answers to potential questions?
Objections beyond the expert's scope. The exhibit speaks for itself.
Damn it, shut up.
Yes.
She already
The
told
searches
you.
and subsequent visits to websites would reflect, as far as pertains to digital forensics artifacts and evidence, the viewing and searching for subject matter pertaining to hunter's education and a test therein.
So just for the record,
Oh my
are, do you find this correlative nature of the searches, starting with the first search we mentioned on August 9th, 2018 at 1738 UTC, what fraction of firearm incidents occurred in the home, that is related to the search of elbow carry of firearm?
Overruled.
The searches as reflected in this document show a pattern of a given subject surrounding firearm safety, then a visit to a web page, this is very specifically having to do with hunter's education and firearm safety.
No, I don't think so, Susie.
Can you look at the search dated and timestamps August 9th, 2018, 17:51:53 UTC? And can you tell me what that one says?
It was a search before action to take if one falls into cold water.
And can you tell me what the next search history is for that search?
It very specifically used reference to the search of what action to take when one falls into cold water. There was a visited website directly after that search on boat education, what to do in falling into cold water treatments as a result of that search.
So your expert opinion, is it your expert opinion that the searches from August 9th, 1738, 25 UTC through August 9th, 2018, 20, 21, 49 are all searches that relate to hunter safety course?
Objection, the foundation hasn't been laid for how these
Oh,
can actually be relevant.
Overruled.
Chronologically, in time, they show a pattern very plainly of a search for a topic, and the topic then visited of a web page that directly correlate to firearm safety, hunter's education, and survival of outdoors. The web history and searches reflect that pattern. The correlation of that data seems fairly straightforward with the evidence of these searches and web history visits.
It does. It seems fairly straightforward.
I would like to talk about Mrs. Mullis' cell phone for a moment.
Yeah,
Based
let's
on
get
your
off
review
the-
of digital forensic evidence, do you know that Mrs. Mullis created her Amy Mullis 5810 account on July 19th, 2018?
There appeared to be a new account created on Ms. Mullis' phone, as reflected by the web history, and as well as some unique dial-up codes reflected in her call log.
And is it your understanding that she used this email address to solely communicate with Jerry Frazier?
Objection, foundation. Irrelevance, speculation.
I would like to show the witness what has been previously admitted as exhibit, I believe 308.
Okay. Did you wish to withdraw the question or respond to the objection first?
I would like to place the foundation if that's.
Okay, go ahead.
Can you pull up exhibit 308? And can you scroll to the last page?
Hi, Susie. Yes, all fine. I'm with you.
Does this exhibit show the communication between Amy Mullis and Jerry Frazier?
Amy Pigs. That's what I
The
thought.
document shows a number of email threads as communicated by the amylin5810@gmail.com and an email account of Jerry Frazier70@gmail.com. 70 at gmail.com. And again, as prosecution counsel mentioned, these items are
I
truncated.
don't believe this is responsive to a pending question.
Let's have a new question, please.
Yes, Your Honor. Based on your extraction and an analysis of Mrs. Mullis's phone and her email records, did Mrs. Mullis email anyone else using the Amy Lynn 5810 Google account?
Objection, there's not foundation laid that this is every email ever sent. This is an extraction of a device, I believe, not an extraction of the Gmail account itself, unless I misunderstood.
I guess I understood it maybe the same way. Do you want to clarify that, please, counsel?
Yes, Your Honor. Mr. Castle, did you analyze Mrs. Mullis's cell phone?
I did.
Did you analyze her email address, Amy Lynn 5810 Google account?
As the artifacts or evidence was represented on her phone, yes.
That's what he
Did
testified
you
to
receive
already.
a subpoena response from the state's discovery on the underlying criminal trial of the Amy Mullis email account?
I did.
Based on your analysis of all the evidence and all the data related to the Amy Lynn 5810 Gmail account and the phone records of Amy Mullis, were you able to determine that Amy Mullis only emailed Jerry Frazier through this email address?
I'm going to object on speculation, although I understand that that's all the data he saw. I think it's too far to say that conclusively is all the data that exists.
Your Honor.
So you turned over in discovery.
Objections
You
overruled.
fucktard.
Witness can answer if he is able.
Based on my recollection, yes, this Gmail account created by Ms. Mullis on her device was the primary modes of communication between herself and the account of jerryfasher70@gmail.com.
Once again, it's fucking straightforward. He had all the information from the original trial that the state gave him, plus the extraction that was done on Amy Mullis's phone, and he puts it together, and this email address only ever talks to Jerry Frazier. He's already testified to that at the beginning of this, and now he's objecting to the foundation. Well, the foundation is he already fucking testified to it, and you didn't object, and it's all from your stuff. God, this guy is annoying the shit out of me.
Do you recall a search regarding checking the content of text messages on the phone?
Like, you think he went home that night and he was like, oh my gosh, you guys, you have no idea. I got so many objections in today. Like, it was like a record.
I do recall that search.
I would like to publish what has been argumented exhibit 270 on page 7, which is the Google searches.
Objection, we intentionally didn't turn over info, and so it's too vague. I know. What we gave you is too vague. We don't even know that it's the entire thing. Well, your shit says it was. So you better figure it out. She's doing much better on this line of questioning than she was on the hunting, but she's still not quite there yet.
You may. The witnesses just asked for some water. Maybe if someone, counsel for applicant, would like to grab that. Thank you.
Thank you, sir.
It's like, you guys got me up here talking. Come on.
Is there a search on July 21st, 2018 at 1:43:39 UTC?
Yes, I see that entry. That entry reflects a search for checking content of text messages on a phone.
And was this search conducted in UTC time?
That is what the document reflects.
And what would that be in Iowa time?
What does it matter? What's this? Make the search more important than the search time.
Sorry. The 143:39 is the one wanted, so it'd be 8 a.m. I would believe.
And this would have been on July 20th, 2018 at 8:43 p.m.
Sorry. No, I believe it'd be 8 a.m. If all this is in 24-hour time period stamps, then that would reflect a 1 p.m. UTC time code stamp or -5 hours, 8:43 a.m. time period stamp. If these are all reflected in 24-hour time clock designation.
This is painful, you guys. Like, come on with it.
So this is 1:43 a.m. UTC. So minus 6 hours would be
No,
8:43 p.m. Is that right?
Yes, I apologize for that mistake. That would be
when
correct.
was this search?
And this would have been done on the preceding day of July 20th, 2018, instead of July 21st, 2018.
And
So was it minus 5 or minus
time frame
6?
designation would have been 1,300 hours for a 1 p.m. time frame, so I apologize for that mistake. Yes, that is correct.
Was there any information in the phone records you examined that corroborated this, correlated with this search?
I can object on foundation on that.
Now he's asking if he can object. Can I object, Your Honor?
What appears to be speculative specifically?
I guess I'll withdraw the objection. and
He
see where
was
it goes.
getting a headache too.
Do you remember the question, sir?
She
No, he
asked me
withdrew
if
the
this search correlated with an evidence artifact on the phone records for this device as well.
And you may answer that question.
Yes, it did correlate to an interesting record on the, as an entry on the phone record. Specifically, as a very short phone number that was an incoming artifact.
Terrible testimony. It's like she's just getting her other shit done while this is happening. She's like, I don't have time for this. I'm just going to work on my other cases. You guys let me know what you guys have to say. That's relevant. This is so bad.
So did you review other Google searches connected to other Google accounts, such as Mullis RN Google account?
In my review of all this data, I had opportunity to review the subpoena returns for multiple Gmail accounts. And it was all taken into consideration in building my conclusions and understanding of these events, yes.
And were there similar searches on this Mullis RN at Gmail account to the search presented in Exhibit 270?
Yes.
I'm going to object as vague and overly broad. This is 270 is 12 pages of, I don't want to characterize the number on it, but it's a lot of searches.
Can I ask a more specific question, please, counsel?
Yes. Based on the search we just mentioned about checking the content of text messages on the phone, were there similar searches on the Mullis RN Google account that you saw during your analysis and examination of the forensic digital evidence in this case?
As previously
already
stated,
beyond the
there were multiple
report.
accounts tied to Ms. Mullis's phone. The Mullis RN account and the Amy Mullis 5810 account being tied to the device. There were parallel searches that were conducted with these accounts tied to the device. So yes, there was overlap of the searches as conducted on this device.
Your Honor. Yes, this is, as you can tell from the people sitting at this table, we're having a little bit of a technical problem pulling the exhibits that we need for this witness. And that is obviously the fault of the attorneys, but we're having a little bit of a technical problem doing that. And I don't want to waste the court's time, and I don't want to waste the witness's time. And I'm wondering if it'd be possible for us to possibly take an earlier lunch so that we can get these exhibits pulled, so that we can move through this, so that we can move expeditiously, which I think is our goal, Your Honor.
Certainly, if you think that's the best way to use our time, we can do that. It is about 11:30 now. Are you thinking you'd want to break until 1, or should we come back a little earlier?
I think one would make sense, Your Honor.
Okay, let's take our lunch break. We'll plan on resuming at 1 p.m. Thank you.
Just cut our losses and move on.
To make sure that we accommodate them if possible. Mention this to
Okay, we'll go back on the record. Mr. Kessel, you can return to the stand. I would just remind you that you remain under oath. Sorry.
just more scheduling thing.
Okay.
I just mentioned this to Mr. Mullis' attorneys, but my understanding is there are 2 witnesses who have arrived in the courthouse who are here under subpoena, both from the Des Moines area. I just want to make sure that we accommodate them if possible.
Okay. I guess, counsel, what are your thoughts about then how we spend our afternoon?
We feel the same, Your Honor. Our goal is to finish this witness expeditiously and move on.
All right, we'll plan on that. Ms. Steenson, you may pick up with your questions whenever you're ready.
Thank you, Your Honor.
Mr. Kessel, we were talking before break about the creation of Amy Lynn 5810 Google account. This was the Amy Mullis Google account that was only on her phone and not on the family iPad?
That's correct.
And from your testimony earlier this morning, this was the later created of the 2 Google accounts that you associated with Mrs. Mullis?
Her device, yes.
Do you know when that Amy Lynn 5810 Google account was created?
Without referencing the exhibit that contained that artifact, I don't recall off the top of my head.
With looking at the metadata TXT file from the extraction of Amy Mullis's cell phone, refresh your memory
Yes.
about? Okay, yeah, can you
All right, well, give me 20 minutes to get that prepared for you because I didn't do it already.
I'll show council what we are putting up for opinion. I would like you to just read this to yourself.
Thank you.
Okay, you can move it. Did that refresh your memory about the creation of Amy Mullis's Gmail account?
Yes.
And what was the date of that?
July of 2018.
And
Already
what was the-
testified to
do you
this.
have the exact date?
19th.
Thank you. So July 19th of 2018.
That's correct.
Did you review or extract data from a phone connected to Mrs. Mullis's phone with the last four digits 5678?
Yes.
And 5675, I apologize. I misstated that. The last four digits 5675.
I believe that was the number associated with that other device, yes.
And do you recall when the data on the phone started?
I don't.
Would it refresh your memory to look at a copy of the extraction
Yes.
data? Okay. Just one moment. I will have to bring this up to him. Yes. So.
Okay.
Did that refresh your memory?
Yes.
Mr. Kessel, when was the first earliest call on this phone?
July.
What was the date?
It was the 14th, if I remember looking at that. Was it July 14th, 2018?
Can I
Sorry.
approach the witness again to refresh?
Certainly.
I apologize. It was July 22nd.
Does that mean that there was no data on her phone prior to that date in 2018?
No, there was data on the phone.
But no, what data would be available on the phone then?
The artifacts represent the activation of the device and the new call log beginning.
So the call from, what data then was missing before July 22nd, 2018?
Sorry, I'm having a hard time following your question. You're asking me, first of all, when this number started being used as it was tied to which device specifically?
The cell phone that you extracted.
Okay. And
Let me re-ask the question. Based on the cell phone that you extracted for Amy Mullis, and your testimony today was that the earliest call on the phone was from July 22nd, what does this indicate to you?
the possibility of a factory reset.
Did you receive and review Google search history from a subpoena to Google showing Google searches associated with the Mullis RN Google account?
I did.
And did any of those searches search for the term related to the recovery of a phone?
It did.
And what does it mean to recover a phone?
The end user chooses to possibly reset the phone back to its default configuration due to troubleshooting steps or obfuscation of data contained on the device.
She factory reset her phone?
Is that some? Can you tell me what you mean by that?
So troubleshooting, meaning that the end user was possibly experiencing some problems or issues with the device. And at the instruction of the carrier, they may have reset the device to solve those problems because the factory reset will put the software in a default configuration, which will eliminate a lot of problems. Or secondly, the obfuscation of data, meaning that they reset their phone to hide something.
The search you saw from the Mullis RN Google account related to the recovery of an LG phone, do you remember when that search was from?
I believe it was in the July timeframe.
Do you know the specific date?
I thought it was around a couple days previous to the reset.
Would it refresh your memory to review the metadata files from the search of the extraction data of the Mullis RN account?
Yes.
Okay, I will show.
Why would she be factory resetting her phone?
May I approach?
May.
If you could review this with me, Mr. Council, starting right there.
So if you're here, enter right above it.
I think this is the same time frame.
So
just review it.
Okay.
Do you have an independent recollection based on your review of that?
That she was
Yes, it was
talking
on
about.
the 20th of July, and then
She was
again
talking about being able to get text messages from somebody else's account or something like that.
earlier that day on the 22nd.
I would like to publish what has been previously admitted as Exhibit 374, page 55, which is Amy Mullis's U.S. Cellular phone records. Do you see this?
Yes, I can see the phone records.
Approximately what dates does this specific page cover?
From the 19th through the 26th of July,
In what year?
2018.
And this is, just for clarity of the record, this is page 55. Does,
Sorry, page 55, the exhibit.
well, I'll just represent to the court that this
Oh my
is
God,
page 55 of
you're
the
giving me a
document,
headache.
Exhibit 374. Does this phone record on this page show
Yeah,
SMS
something
activities
like that.
associated with Ms. Mullis's phone?
Yes, it shows both SMS and MMS messages.
And can you tell me what that means?
SMS is signal messaging service for plain text messages received or sent from the device, and MMS is multimedia messages sent or received from the device.
Looking at this particular page, there is an SMS number that is shorter in length. Can you like that? Can you tell me the date and time of that entry?
Yes, it's 3 or 4 p.m. on 7/22/2018.
And can you tell me what a short SMS code is?
It's typically used by carriers or subscribers to do a couple of things. One, either an advertising blast that would be received via SMS, or possibly a two-factor authentication code sent to a device for authentication purposes.
So this potential re-authentication or of a Google account was at the same day as the search on the Google, the Mullis RN Google account about recovering a phone?
Yes.
Did you review?
I don't factory reset my Android.
Mr. Castle, do you have experience with obtaining and interpreting cell tower location data?
I do.
Can you tell me a little bit about that experience?
Yes. In multiple cases that I have either offered affidavit or testified in, I have received subscriber intelligence data as pertains to call data records, per call measurement data, and other similar type signals information that allows me to triangulate and locate the handset of a given subscriber.
I feel like whatever he has to say that's good is getting lost in just this kerfuffle of bullshit.
Can you explain in general terms what cell tower location data is?
Yes. There are several spreadsheets that are created as a result of the subpoena to the carrier, Verizon or AT&T, that are given to the government in response. That data contains multiple items that are used to build triangulation and mapping of the handset. Those are the geolocations of the cell towers themselves and the pointed direction of the antenna on that cell tower. They are in a 120-degree grids, which would make a 360-degree grid array combined. And then with the call data records as applied to the communications coming off the device, whether they be SMS calls or MMS, those signals are used to triangulate the location of the handset in relation to the cell tower at the time of that communication. That's as it pertains to call data records. Now, per call measurement data, which is a specific carrier term, is a measurement that is taken. Radio frequency travels at the speed of light, which is a determinate variable, and can be used to triangulate handsets. It is a more accurate measure of where a handset may be than call data records, as it is a radio frequency transmission communication between the handset and the tower itself. This information is more accurate simply because that measurement is taken periodically as the handset moves. As a general rule, mobile cellular handsets do not necessarily talk to the tower that is closest to it. It talks to the tower that has the best signal strength. So that has to be determined. That's determined by this measurement of the radio frequency and its signal strength in relation to the handset and the tower itself.
So just to put it in a little more simpler terms, can the cell tower location data help an expert determine the location a cell phone was at the time it was in use?
Yes,
Were you, did you review phone records of Jerry Frazier?
I did.
And where did you get this information?
I received it as part of the data I got from the government.
And what did you receive originally?
Originally, I received only a few pages or excerpts from these documents that would typically be turned over by the carrier.
I would like to show what has been previously marked as Exhibit 298.
Yeah. So then the next day she's factory resetting her phone. That's nice.
Mr. Castle, what is this?
This is a part of those batch of documents that I referred to that will be received from the carrier. This specifically talks about the geolocation of the cell tower and the direction that the gridded array would be facing. Correct.
And this was
They asked the farm guy about the Wi-Fi. They haven't really asked him about Wi-Fi on Todd's farm. So
provided to you originally in 2022.
Yes.
You can take that down. I would like to show what has been previously marked as Exhibit 299. Can you tell me what this is?
Again, this is an excerpt of what would have been a total data dump from the carrier containing data as it pertains to, as I stated earlier, the called data records of the CDR and SMS communications coming off of a handset.
And this is what, this also was previously, this was originally provided to you in 2022?
Yes.
Based on your analysis done with these two documents that I just showed you, what did you find?
My conclusions were incomplete because these documents are incomplete. I did not have all of the data necessary to do a proper triangulation or mapping of the handset in question.
Did you have, was there any data on November 10th of 2018?
No.
Did you ever review any other documents regarding Jerry Frazier?
okay, so he's saying that he was trying to figure out the cell phone data for Jerry Frazier's phone based on the information that the state provided. And if you remember, they testified. Oh, who was it that testified? I think it was Turdbutt in the trial testified that they were able to pinpoint where Jerry Frazier was and how he was not in the area of the farm based on that information. And now he's saying there was inconclusive information and he was unable to do that.
At a later date, I was ultimately provided with all of the call data records and necessary information to build a more comprehensive mapping of the data, but this was after I had authored my original report.
Okay. Interesting.
With these documents, these that you were presented later, potentially change your opinion about whether it was possible to determine the location of Jerry Frazier's cell phone on November 10th, 2018?
If the data was not reflected for that date in particular, no, it would not aided me in producing a location of the handset for that particular day. It did aid me in understanding where the handset may have been on all days previous to that.
Interesting. I wonder if anybody's picking up on that.
I would like.
So they testified they knew where Jerry Frazier was that day based on his cell phone info. And he's saying based on the information he was provided by from the state, he could not figure out where Jerry Frazier was on November 10th.
I'd like to publish what has been already admitted as Exhibit 271, page 11.
No objection from the state on that. That's interesting.
Can you highlight the pages? Here at the date of July 2nd, 2018, what is primarily being searched here?
The subject matter surrounding Ohana tattoos.
And were you aware of any communication regarding Ohana tattoos in the digital evidence that you reviewed?
Yes, there was a conversation in the communications between Ms. Mullis and another party surrounding her getting one of these Ohana tattoos.
I would like to publish what has been previously admitted as Exhibit 262.
Yeah, Indiana Girl. Somebody might have to type that in chat to ask Indiana Girl to look because she's probably behind and she won't hear me ask. Perfect. Never mind. Miko's headphones is already on it.
Page 1. And looking at the top of, can you tell us what this document is purports to be?
It appears to be the communications between Ms. Mullis and another party.
And at the and can we scroll to page 7? Can you tell us what the date of this text message is?
This document would seem to reflect that the communications happened on July 2nd. It doesn't state the year and that time date stamp.
Okay. You can take it down. I would like to show the witness what has already been admitted as Exhibit 271 on page 57.
Mr. Castle, you previously mentioned that you knew the iPad was activated on August of 2017. Why was this significant in your analysis?
It appeared that there were Google searches that were conducted previous to its activation.
And in looking at Exhibit 271 on page 57, can you tell us the date of the first search?
The first search that Google has record of for this account happened in March of 2017.
Mr. Castle, did you review the Galaxy DVR security cameras from the Mullis family farm?
I did.
And did you perform data extraction on the security camera system?
I conducted my own independent collection or extraction of the data, and then I also conducted an analysis of the data contained within that hard drive image.
Can you tell me what your analysis and conclusions were?
After the proper procedures followed for the collection of that device, I took the opportunity to extract specifically the system's log file of that DVR, which reflected the communications of the cameras with the DVR unit itself. The cameras were a wireless connection to the DVR and reflected a number of disconnections over a period of time.
I want to break this down just a little bit. Did the system record any footage from October 29th, 2018 to November 11th, 2018?
I did not appear to have made a record of any recordings for that time period.
There you go.
Could you determine whether any video footage was deleted during that time frame?
Yes, I was able to determine by doing analysis on the file system that there were no video files written for that time period, so there would not been any files
There was
deleted.
nothing ever recorded.
And
So
can you
nothing
remind me
deleted.
what program you used for this extraction and analysis?
I used FTK Imager to create the hard drive image, and I used DME's DVR Forensics, the same title the government used.
So this was the same program that was used by the state?
Yes.
Was there any activity on the camera at all between October 29th, 2018 and November 11th, 2018?
The log files reflect that there were a disconnect of the cameras from the unit itself.
Why would a security system stop recording?
Objection calls for speculation and foundation.
Overruled.
The log files represent a connect and disconnect of the cameras, which again were a wireless connection to the base unit. And this connection and disconnection of the cameras to the base unit would be an explanation as to why there was no footage recorded at the time.
Did you learn through your review of the materials where the camera DVR system was located?
I learned from the materials, and also in September 2022, when I visited the Mullis family farm to retrieve a number of these devices I had opportunity to extraction on, I did a site survey to determine what building and office the base DVR unit was located in relation to the cameras that were on the hog barns independently.
And what was significant about having this knowledge?
It gave me a physical awareness of where the cameras were at in relation to the base unit itself.
So how did this impact your analysis and conclusions?
It was a further correlation that demonstrated the accuracy of the log files and their reflection that the cameras had disconnected from the base unit.
Did you review Mr. Hemeseth's testimony regarding the camera system footage?
I did.
Did he testify?
So there you go. So the cameras did not record, and when doing the extraction from the camera system, the main system, it shows that there's no data recorded whatsoever. So nothing was deleted. Like Todd went back and deleted all this stuff from the cameras because he knew what he did. And he's telling you that it logged that it was disconnected. That's the layman's terms of what I just got.
That he could not tell whether the camera
All right,
did or did not
Miley,
record.
have fun.
Overruled.
Yes, I do recall that. He may have not had opportunity to look at the log files that I did.
Was his statements true?
Objection, this is improper opinion testimony.
Overruled.
It appeared that they did not have all the data necessary to make that conclusion.
Is your conclusion based on the data that you extracted?
It is.
And this is also the same data extracted by the state?
They had access to the data. I don't know whether or not they extracted or did analysis on that data.
But they had access to the system log to come to the conclusion that there was no data on the phones, on the cameras between October 29th and November 11th?
Correction leading.
Overruled. The answer will remain in the record.
Can I have a moment?
You may.
I mean, be very honest, since they came back from lunch, things are much, much better. If the entire testimony had gone like this, I think that I wouldn't be so irritated. Well, number one, and probably the judge wouldn't be so irritated. But the lawyer's done a better job. His answering is better. It's much more clear on what is happening, what he's looking at, and how he's getting the information, and why it's relevant to what we're here to talk about.
Offered this opinion, all these opinions?
Had I been retained by counsel for the purposes of analysis in these matters, my findings would be as they are.
Thank you. No further questions at this time.
Cross-examination.
Thank you, Your Honor.
Right?
I'm
And
gonna
be,
pick up-
like, what a perfect time to actually, like, Bob's having Stacey Eldridge on from the Delphi case. Yeah, it's a perfect day for this. I think Tara and baby lawyer had a 90-minute lunch where Tara gave her the questions to ask while they also got all the exhibits prepped better. I just feel like it should have already been done. I mean, they hired this guy back in 2022.
Up where we left off. Your testimony was that your findings would be as they are, right?
With the exception of the satellite, I'm sorry, with the exception of the call data records and the mapping of the handset, yes.
So that means you used the existing software versions that were available at the time of the trial in 2018, and you didn't use any new versions of software, is that right?
I did have a couple newer versions of software that I did not reveal any additional data that I used as part of my findings.
So let's break that down a little bit. So you stated that you use several different types of software. So for example, you use Celebrite, I believe Magnet Axios, and FTK, among others. So we'll use Celebrite as an example. Celebrite comes out with new versions of software as time goes on, right?
Often on a quarterly basis, yes. And on a quarterly basis, oftentimes, yes.
I can give you a quick overview, so I like literally people don't have to sit and watch this guy talk forever. Essentially, we get a couple big things out of this. One, the Google searches match the study guides for the Hunter safety quiz. Like that breaks down like 2.5 hours of testimony. That was a big one. If I missed something, one of you guys will get me. That was a big one. That Amy had Todd's Gmail account and 2 Gmail accounts of her own on her cell phone. And some of the searches, the time frame of when some of the searches from the first trial were done on Amy's actual device, but yet attached to Todd's Gmail account. She created a new Gmail email in order to communicate with Jerry Frazier in the summer of 2018. She Googled something, and I'm not going to be able to quote it correctly. She Googled something on July 21st about, can my husband see my text messages? Something along those lines. And the next day, she factory resets her phone. So, and then it erases everything that was on it. We learned that the camera system on the farm did not record anything. Nothing was deleted, and that the extraction from the camera system on the farm shows that it was unplugged and not recording, and nothing to do with Todd going back and deleting videos to cover up his tracks. We also learned that, what was the other big thing we just learned? And I just said it out loud just a minute ago. Yeah, the SHD email. She had a specific one for SHD. What was the other big thing we just learned? I just said it before I started this. Oh, we also learned that Tristan looked up porn on his phone when he was 13. Oh, they couldn't verify where Jerry was. Yes, thank you. So he also reviewed all the information from the state on the cellular analysis and tower analysis of Jerry Frazier cell phone location on November 10th, and he was unable to figure out where Jerry Frazier was on November 10th based on what the state had given him, and that is the same reports the state used at trial to testify and say that they knew that Jerry Frazier wasn't in the area. That's it. That's what we've learned today. That's what we've learned today. I don't give a shit if he was Googling porn. I don't give a shit if any of them were Googling porn. Yes, that the camera, the other camera, so the one camera, because there was the 2 cameras, the one camera didn't have any recordings whatsoever. They essentially, the entire camera system was not working at the time of the crime. It had not been working at the time of the crime, and there was nothing underwritten that showed that there was any video ever recorded, and nobody went back and deleted anything. Okay. I think, did I cover it? I think that was much less painful. Right? All right. So that's like the big checklist of what we've gotten so far today.
from 4 hours of testimony or whatever it is. I don't know. Don't go back and watch. That my advice, do not go back and watch. Just don't go back and watch. I just gave you everything you need. Don't go back. And that was it was bad. It was hard. Yeah, it was the one camera was never recording. One camera was not working from the 29th of October and the other camera was never recording. Okay, here we go. It was a good refresher. Yeah, okay, here we go. Find me one dude in this country that hasn't good. I don't even know if it's just a dude thing anymore. Streets. I'm thinking like, you know, find me somebody at all who hasn't Googled porn at least once, even if on accident. I'm exhausted, right, Rexy? I'm like, I'm ready for a nap. I did actually. I showed some tiny people videos, and we had a good time talking about jazz hands over here. So there is a spot for that. There is a little laughy. Yeah, nobody's testified to that yet, Paul, but I agree.
For clarifying that. And example, Celebrite comes out with new versions of software as time goes on.
Oh, okay. So what he's asking now is, you downloaded all these devices. You're saying you used all the exact same extraction methods that the state used, but by any chance, are any of those extraction device or extractions that you did you use any updated software from beyond 2018, 2019? Because if you did, it could have given you different information.
On, right?
Often on a quarterly basis, yes.
And
on a quarterly basis, oftentimes, yes.
Thank you for clarifying that. So in those software updates, Celebrite would change how it extracts information from devices, right?
Sometimes, yes.
So for example, it might change what encryptions it can break or new versions of iOS or Android that it can extract data from?
Yes.
And that would be the same for the other types of softwares that you used?
There are often enhancements contained within updates, yes.
And as part of those updates, they're able to extract more information as, for example, Android software gets older, they can find new exploits to look at that information, right?
Yes, that's true.
And if you use a newer version of Celebrite software, just as an example, you might get new or different information than what was available in 2018 based on old versions of Celebrite. Isn't that fair?
I think that is fair.
I guess continuing to work our way backwards through your testimony, you finished, towards the end, you finish off by talking about the Galaxy security camera system. So essentially, you're relying on the logs to indicate that the cameras were never connected. Is that your testimony?
The cameras were disconnected for a period of time over the life of that DVR, and specifically in the time frame I was questioned about.
And you don't know why they weren't connected, right?
The log file represents that the wireless connection, as established between the main unit and the cameras, represented a disconnect.
So you don't know what caused that disconnect beyond that? Is that fair?
Until the physical inspection of the site, that would be correct.
So for example, if the
family said something like, maybe the cameras caught something, you know, maybe we should look at those. And so that's when he went and looked at the cameras, but it wouldn't have caught anything if she died in the shed anyway. I guess what the state tried to say was that it would have caught like Todd running from the hog barn to the shed if they'd been on, but it would not have caught what actually happened to Amy inside the shed, because the inside the shed had no cameras. So yeah.
I guess I'll just say this. You don't know specifically what caused any disruption or disconnection of the cameras.
That's
he doesn't know it was a cat. Yeah.
In the report, you discussed the Galaxy camera software and the extraction done by the law enforcement officers. Is that right?
Yes.
And turning to that section of your report, and do you have this report in front of you?
I do not. I don't know that it was admitted.
Just to move this along, I'll read from it and just make sure that we're on the same page. So on page 11 of your report, you state, and just tell me if this sounds wrong at the end here, according to a DCI examination synopsis report, Deputy Hemiseth attempted to access the security camera system without the proper software or extraction tools. Does that sound familiar from your report?
It does.
Do you now know that testimony or that portion of your report to be false?
Objection.
I asked if he knows.
What's the objection?
It assumes what it assumes what it is saying.
Overruled. You may answer if you can.
I'm unaware from trial transcripts or the report from DCI that former Deputy Hemeseth had opportunity to review the log files as reported that I did.
In preparation for your testimony today, I believe you indicated that you reviewed Ward Crowley's report and his testimony. Is that true?
In part.
So he's trying to say that this guy wrote in his report that Hemeseth did not have the right equipment to download the videos or to check the video system from the farm. I'm not sure how this helps the state though, because so I guess just trying to make this guy like look like a liar. Here, I'll back it up. Because he's like, so now you wrote that in your report, but now you know that's not true. Like you wrote inaccurate information, and he's like, I don't know what that objection was, a terrible objection, by the way. But I think he's trying to say like, no, I actually do think that he didn't have the right equipment to do what needed to be done, or just didn't do it. But also, if you remember in direct, he said that he wrote a report and then was given additional information, but that was about Jerry Frazier, not about the cameras. So I'm wondering how much more he got outside of that. I don't know. I'll replay it.
Fair. Thank you. In your report, you discussed the Galaxy camera software and the extraction done by the law enforcement officers. Is that right?
Yes.
And I'm turning to that section of your report, and do you have this report in front of you by chance?
I do not. I don't know that it was admitted.
Just to move this along, I'll read from it and just make sure that we're on the same page. So on page 11 of your report, you state, and just tell me if this sounds wrong at the end here, according to a DCI examination synopsis report, Deputy Hemeseth attempted to access the security camera system without the proper software or extraction tools. Does that sound familiar from your report?
It does.
Do you now know that testimony or that portion of your report to be false?
Objection.
I asked if he knows.
What's the objection?
It assumes what it is saying.
It assumes what it is saying.
Overruled. You may answer if you can.
Overruled, because that's not an objection.
I'm unaware from trial transcripts or the report from DCI that former Deputy Hemeseth had opportunity to review the log files as reported that I did.
In preparation for your testimony today, I believe you indicated that you reviewed Ward Crowley's report and his testimony. Is that true?
In part, yes.
In what part is it untrue?
I recall reading it. I don't recall the totality of it at the moment.
Were you aware that Ward Crowley specifically testified, which is in evidence here, that this is not what occurred?
In what aspect?
Were you aware that it was DCI Special Agent Ward Crowley who conducted this attempt of the extraction of the security camera system at the Sheriff's Office and not Sheriff, then Deputy Hemeseth?
I do recall that aspect, yes.
Okay, and then your report continues on to say that I'll just read it since you don't have it in front of you. You say, DCI Agent Ward Crowley attempted to assist Deputy Hemeseth remotely while Hemeseth tried to conduct an on-site examination of this device at the Sheriff's Office. Does that sound familiar?
Yes, it does.
That all sounds
And
accurate.
You now know that that's not true based on the testimony and evidence here, right?
Hey, I'm sorry,
What?
which aspect of the testimony?
Well, you say in your report that Ward Crowley assisted remotely, but he testified in this proceeding that he was there in person, right?
What?
Okay. That part of the testimony I must have overlooked. I apologize.
What?
I'm sorry, you just testified that you reviewed his testimony, right?
In part, in that I don't recall every aspect of his testimony.
That misstates his testimony.
Yeah, that absolutely misstates
You're
his
referencing
testimony.
a report here, and testimony is different than report.
Yes, you've admitted to reporting the evidence.
That's necessarily what he's reviewed. And that's not his testimony today, that he's reviewed the report.
Your Honor, I think I can clear this up briefly. I'm referencing the deposition of Ward Crowley, which is admitted into evidence here. Ward Crowley specifically explained how this extraction occurred. If they want to point me to something that contradicts that, I would be happy to revise my question.
No, no. The one that she had an affair with is Keith. It sounds very similar though. Keith Rowley. That's the one she had the affair with. So Ward Crowley is a different guy. So I'm still not understanding what he thinks is misstated in his report, though. The simple fact that Crowley was actually at the scene versus on the phone. Because other than that, like nothing he said is proven incorrect yet. And I don't even know if that, I don't even remember if that's true. Was Ward Crawley actually at the scene? I don't even remember.
Okay, and again, I think her point was that this witness maybe wasn't present at that deposition or wouldn't have that clarification necessarily. Let's just have a new question, please.
Thank you, Your Honor. If I understood your testimony earlier, and I just want to get clarity on this, your testimony on direct examination was that you reviewed the report and testimony, which would only be the deposition from this PCR of Ward Crawley. Is that correct?
I had opportunity to read that deposition. I do not recall the part where he was on site to do the analysis of the log files that were extracted specifically. My report in spirit reflects the fact that the log files about the connections between the main unit and the cameras were disconnected.
And maybe I can help clarify here. Do you recall any testimony from Ward Crawley in your review where he discussed attaching the physical right blocker device to the system?
Okay.
I do.
I hope that the defense actually brings this back up on their redirect, because the issue still remains. Whether Crowley went there, didn't go there, any of that shit doesn't matter if Hemisath testified at trial that he could not tell if it was disconnected or not, when what he's saying is in the log files, you can actually tell. You can see in the log files that it was disconnected, that it was no longer connected. So whether Crowley was there, he's trying to just, what do you call it, this witness? Discredit this witness. That's really what he's doing, because that makes, it ultimately doesn't matter, because the testimony at the trial was the fact that it could have been deleted, it could have been this, it could have been that. When Hemisath, if Crowley was there, this is not good for the state necessarily, because then Hemisath should have known that it was disconnected and not been able to testify that he didn't have any fucking idea what the hell happened to the cameras or the videos. So, I mean, he's really this is all just to discredit this guy, that he wrote something in a report about Crowley either being there or not being there after he said he read this report. Because it's really, ultimately, it should be irrelevant, because, I mean, I guess not irrelevant if you want to discredit the witness, but irrelevant in the terms of what the fuck the point of this conversation is.
Recall that.
Okay, so would you agree that if he was attaching a physical device to the system, he would have to be there in person?
That would make logical sense, yes.
And there was some discussion in his testimony, without getting too granular, where he referenced using a trial version of the software. Do you recall that?
I do. I also recall during the course of that interaction that there was a phone call between the two of them regarding his analysis as well. And that may have been what I was referencing when I was talking to the remote assistants.
Thank you for clarifying that. So you completed a report in this case, right? This is the general report of your findings that we've been discussing?
Yes.
Have you completed a supplemental or updated report correcting any of these discrepancies since this report?
No, I've not been asked to do so.
I briefly want to talk about your background. At the beginning of your testimony, you talked about your background into digital forensics and network security consultant. Is that right?
Yes.
And you referenced dealerships as part of your background. That specifically is car dealerships, right?
Yes, in the automotive industry.
Okay, so your CV, where it indicates that you worked for example, Sid Dillon, Chevrolet, Buick, GMC, Cadillac, Mazda, Nissan, Hyundai. That's the example of your background working at dealerships?
That's one of them, yes.
Okay, and then you worked for other car dealerships?
Yes.
You don't dispute that the Google searches that all of the Todd Mullis Gmail searches that were in evidence had to have come from some device connected to a Todd Mullis Gmail account, right?
Can you rephrase?
Yes, it's poorly phrased. I'll admit that. Just for clarity, we have the Google subpoena results, right?
Correct.
You're not disputing that all of those searches came from something connected to that account, right?
Correct.
And you have no way to know who specifically is on the other side of those Google searches?
Yes, that would be correct. Attribution in its truest form and understanding the patterns of usage and searches conducted. Unless there was someone that could visually witness the searches being enacted, it would be difficult to tell who was responsible for them.
Fair enough.
Yeah.
You had some testimony about the correct meaning of UTC time, right?
Yes.
And although you referenced Deputy Hemeset getting that wrong in his testimony, you also had difficulty converting UTC time today, right?
I did.
No, oh, you little dweeb. No, do not try to characterize that as the same thing. That is not the same fucking thing. He did not have a problem converting it. That little shit didn't know what the hell it meant, and he said that it was Central Standard Time. Facts in his testimony. Nothing about conversion. The guy didn't even know you had to convert it. Thought it was fucking Central Standard Time. What does UTC mean? Central Standard Time?
Just so we're clear on the issue of the Dish DVR, you can't specifically say what show is watched on what day in this case, right?
Oh, I forgot about the DVR.
The correlation of the TV guide and the unit itself, it's still some difficulty in producing the exact date in which some of those videos were watched. You are correct.
And would it be fair to say that shows can be re-aired?
Absolutely.
You had a reference to, or I'm sorry, one follow-up on that. You also don't know who was watching the show that would be on, right?
Correct.
Thank you. If you can just clarify something for me, you referenced based on user synchronization options, the searches can show up on other devices. Can you just explain what that meant?
Yes. When you sign into, as an example, the Google Chromium or Google Chrome web browser with a Google account, you are presented with options. Those options would be to synchronize those searches and history on that account with that browser. So there is a way to opt in or opt out of that synchronization happening across those multiple platforms and devices and browsers.
And are you aware if the user synchronization options were enabled or disabled on the various devices here?
No.
You testified on direct examination that the correlation of Google searches seems pretty straightforward and obvious, or something to that effect. Does that sound right?
The correlation of the Google searches to other data points available to me as part of the investigation does outline a pattern.
So if it's straightforward and obvious, we wouldn't necessarily need an expert to tell us that part?
I would agree with that.
You spoke about Ms. Mullis's phone possibly being reset, but you don't have any firsthand knowledge of why the phone was reset, right? In other words, you weren't personally there to know why?
Correct.
And because I believe you testified that it could have been for a variety of different reasons, right?
Correct.
So you can't say definitively why it was reset without speculating, fair?
The analysis of web history and searches happening up until the point of that reset would offer some insights into the possibilities.
You also testified about your experience working with cell phone records, extractions, location data, that type of thing, right?
Yes, I did.
And you described for us what SMS and MMS messaging is?
Yes.
Would it be correct in saying that SMS actually means short message service?
It's another acronym that's synonymous with the messaging style, yes.
Looking at the VOLTE records for Mr. Frasher, would it be fair to say that there would be a tower code in the column of those documents?
Without looking at it again, I'd have to refresh my recollection.
I can try to do that. Give me one moment.
I'll be right back.
I guess I'll speak generally without getting specific. Would it be generally true that that CDR records might have a column that indicate what tower was being connected to?
Oh, absolutely.
And based on that tower code, would you agree that anyone, if they know what website to go to, could figure out where that tower is with some effort?
As far as like just putting the latitude and longitude coordinates into a browser to determine its location?
Going the other direction, is it possible to take that, say for example, just hypothetical here, that we know someone connected to a US cellular tower and we have a tower identifier. Is that something someone can take and figure out where that tower is?
It depends on the public records release of the carrier for those locations.
Is it possible?
In this random number generator of a universe we live in, anything's possible, sir.
Fair enough. I want to direct your attentions. You discussed doing in addition to your general report, you did reports of various extractions of devices, right?
I did create reports with specific communications or data points out of some of the devices I did extractions on, yes.
And one of those reports that you did, I believe you titled New Conversation or New Convo Report. Does that sound familiar?
It does.
And would that be in reference to Mr. Mullis's cell phone?
Without referencing the document itself, I'm not recalling specifically which communications those are referencing.
And I can attempt to plug this in here so you can take a look at it. And this will be just for the witness, Your Honor. Yeah, it's the instruction. Let me know when you can see my screen here.
I see a source extraction under data in regards to a phone.
And this is your name up at the top here, is that right?
Yes.
Okay, I'm going to scroll through this briefly. I just want to make sure we're talking about the same document here. What would you need to see to identify what device this was from?
So it mentions the selected device name underneath the device name and the manufacturer. And it also, oops, I'm sorry, the document, sorry. So it gives a general idea of the device name there and the brand. Is there another page that gives more specifically the IMEI or some other unique identifier for the device itself?
I'm sorry, I was being asked just a clarification question from counsel. Can you just state that again? I just want to make sure we're on the same page.
Okay, so it shows a device name and it shows a brand. It doesn't show the specific serial number or unique identifier for the device itself that I can see here.
Okay, I'm going to scroll down to the content, see if that helps us get on the same page.
Okay, I'm sorry, I still don't see anything that uniquely identifies the device that this came from.
Okay, let's look at but you agree this is a report you generated in your investigation and your analysis?
It was an extraction report, yes.
Okay, I'm going to scroll down just so we can move on. So what we're seeing now are various messages that have been created as part of your report. Is that fair?
Yes.
Your Honor, I'm sorry, we're just trying to find the document that counsel's referencing. I just need a minute to make sure that we have it.
Certainly, and I can help with that. This is the report that resulted in the state's Exhibit E, proposed Exhibit E. And I think it's identified with more specificity in the exhibit list. If you need a minute to find it.
Just give us 1 minute, Your Honor.
Sure. Just let us know when you're ready, please.
Yes. We're pulling the data, Your Honor.
Your Honor, I'm just going to share the file with them just so they don't dig through the data. So if we can have just a moment, just I want to make sure they're seeing what I'm looking at too. And the luxury of an extra laptop, unfortunately.
He looks tired.
Introduced to us in discovery, but I agree it's from a large amount of data.
Screen shared again?
Yes, Your Honor, thank you. Can you see that in front of you again? Or let me know when you can see it.
I can see it now.
All right, so we were looking at this. I'm going to scroll down to page 2, and beginning at the bottom of there, there's messages. So this would be extracted from a device and then is output in this report. Is that fair?
Yes.
So I'm going to draw your attention specifically to the bottom of page 5, which I'm going to scroll you there. So I think it's conversation or line number 11. Do you see that? And I can zoom in.
I do, I see it.
So if the first column says phone, what does that mean?
The device type.
Okay, and that next column, it says Todd, and it has a number ending in 1114. Is that the number you testified earlier that was Mr. Mullis's?
Your Honor, I truly apologize. I'm not sure what page number we're on.
Oh, I said 5.
Come on.
Page 5, line 11.
Look at the view from back here. Oh, I'm sorry. It's so bad. I'll be nice.
Did you locate where we're at, Ms. Thompson, Ms. Sneedson? Okay,
Thank you, Your Honor.
okay, Mr. Baki?
I apologize, I don't recall if you answered, so I'm just going to ask it again. That 1114 number, I believe you testified earlier, that was Mr. Mullis' phone number, is that right?
That was the telephone number associated with his account and the device that he had, yes.
And I'm going to scroll up for just a second so we see what that column is called. And at the top of that page, I can scroll there.
Objection, Your Honor, this was not an exhibit that was presented before trial. This in the state's exhibit list, they just had an extraction from an unidentified phone extraction. And so this was not disclosed to us which extraction was being used. And also it was not disclosed, this entire report was not disclosed that they were going to use this as an exhibit.
He's laughing.
Your Honor, if I may respond.
Go ahead.
This is a report from their expert who they called as a witness from a message from their client. And we filed the actual message as an exhibit and they objected to authentication and foundation for that exhibit. So that is why I'm having the witness go the long way through the actual report to confirm it was in his full report before we work with the actual exhibit. And I believe in reference to our exhibit list, we confirmed that it was in a report sent to us from Sean Castle's digital extraction on the physical drive produced by applicant during discovery. And if there had been any question as to what report or where in that data it was, we would have been happy to provide that, but no such clarification was requested.
Just,
May I please speak for a moment? I can probably clarify this. They gave us a one-page document. May I please?
go ahead.
They gave us a one-page document. First of all, it doesn't have the same information as what we provided to them. We have no idea who did that actual extraction. And even more concerning is it doesn't have the same information that's on the report that we gave them. So I think maybe if we confer for a second, we can maybe figure it out or approach, but we've never seen what they're reading before.
Your Honor, I think I can simply have the witness lay foundation of how reports are generated in Celebrite from a Celebrite reader file, and he can explain to counsel how those are generated and printed, or we can substitute it with the full report if they want the entire thing that they produced and gave to us.
Well, okay, counsel, I can give you a couple of minutes to visit if you think that will put an end to the objections. Certainly, it would seem to me that the full report could come in if it's something that this witness generated. Now, I don't want dozens more pages of information that maybe isn't relevant or, shouldn't need to be reviewed. If we can whittle it down to one, that would be great. But, so again, I don't know what's different on the proposed one page from the full report. I haven't had a chance to compare those. If you think a couple of minutes to confer would be useful, I would suggest that we do that. Why don't we go off the record for a few minutes? Let me know when you're ready. The court will recess while you do that. Give everybody a chance to stretch their legs. Mr. Castle, you may step down.
Okay. So he's using a report that he's saying was sent to him from Todd's attorneys as a Celebrite extraction. They had previously tried to admit an exhibit based off of that extraction. Then Dina, who is the lead attorney on Todd's team, pipes in and she's like, no. We know what that report is, but what he's doing doesn't match the report we sent him. And then little Mr. Smarty Pants over here is like, well, if I could lay foundation and the witness could explain how a Celebrite report works to the attorneys, maybe we wouldn't have this issue. So that was a little condescending, but we'll see what they come up with at the after their break. Let's see. Come on. They're talking, but there's no sound. Come on. You're not going to let us hear it?
Seriously? We're not getting to hear anything about it now. So I have no idea what ended up happening. That sucks.
An unknown reason, they were not able to fully process the data. Therefore, the DVR was submitted to my office for further examination.
What? DVR? What happened to the phone?
Can I have just one moment? Certainly.
If that Indiana girl let me know, but I doubt it. It'd be a blue camera. Get a lip reader in there. We don't even know what ended up happening with the argument. That sucks. Now we have sound and nobody's fucking talking. Seriously?
The states, first of all, can you hear me? We'd like to read just the full content of that message that the state just read to the record, or the full message in response to it, so if I can do that. Or we'd like to offer again the text message between Todd and Mullis that give the full content of that message, because this is just a snippet of the extraction, not the full extraction. So we would just like to provide the full context of what that message is about or not.
Your Honor, I apologize, but I'm confused. I believe the exhibit I read from is already in evidence. Is counsel intending to read from a different portion that's already in evidence? I'm unclear.
I guess I'm not sure. Are you planning on reading or asking to read from 307?
What the heck did the message say?
And I guess for just clarity of the record, briefly, I wasn't intending to testify when I read that message in. It was only because it was obstructed from an exhibit number and the e-filing stamp was the only reason I read it that way.
Well, and is the reading attached to a question for this witness or not? Sure. I mean, is it being read because there's a question that goes with the reading, or?
I think our argument is that we just want to have the real completeness, that the whole text conversation is considered as a whole instead of just that one isolated text message. And so,
well, okay, and so that's my job in reading the exhibit, which I will do. You know, we've put this witness through a lot of hours of testimony, and so I think right now we need to focus on what questions we have for this witness. And so he doesn't need to read that whole exhibit unless there is a question for him.
Yes, Your Honor.
Okay.
May I resume?
Yes.
Based on your review of the digital forensic data, were you able to determine that multiple devices were logged into Todd Mullis 76 Google account?
Son of a bitch. We're not even going to get to know.
Yes.
And so would this indicate that the Google search history presented at trial could be from multiple devices?
Yes, sir.
What a load of shit.
One moment, Your Honor. Sorry.
Between verdict and sentencing.
Shit.
The judge did not issue a.
Thank you.
You remember testifying in your.
I knew him from there.
Oh my gosh, I'm so sorry, you guys. I don't know what the hell. I just hit the button and just made a disaster out of the whole thing. I am so sorry.
And
Right to credit junkie. Tammy. Yeah, he used to work with a guy that had a comb over. He used to say bald spot was a solar panel for a sex. What? Oh, wait. I think you should just say that picked up on closed captioning.
Your Honor, I just wanted to clarify for the record, we will at a later time renew our motion about the DVR records, extraction records. However, we will not use Mr. Castle's time any longer. So no further questions on behalf of the applicant.
all right, any recross?
Nothing additional, thank you.
Okay, thank you, Mr. Castle. You may step down.
Thank you.
Further evidence on behalf of the applicant?
Yes, Your Honor, we will call Mr. Carter.
Okay. That was fucking painful. That was painful. All right, we're going to get his defense attorney on the stand now. His defense attorney from the original trial. This now should get fucking better, I hope. I'm so pissed that we don't get to know what that text message situation is. I want to know what that text message said. There's a reason that these two knuckleheads over here wanted just that one single message from Todd to Amy in. And there's got to be something in it. And then they're arguing like we should have like rules of completeness. The entire conversation should be. Okay. Here we go.
Sure.
Oh no, not Nichols. He's a slow talker. Great.
Good afternoon, Ms. Firehelm. Good afternoon. You've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
I do.
Go ahead. Take time. Have a seat there. Feel free to adjust the chair and the microphone so they can sit comfortably. Ms. Nichols-Cook, whenever you're ready.
Good afternoon.
Good afternoon.
Could you please state your name for the record and spell your last name for the court reporter?
It's Gerald Burton Firehelm, F-E-U-E-R-H-E-L-M.
And do you also go by Jake?
Yes, prefer that.
Have you previously been deposed regarding your representation of Todd Mullis?
Yes,
And did you previously sign an affidavit regarding this case?
yes,
No, Susie, he had a different guy for his
Have you,
appeals.
and are you an attorney?
I am.
Have you always practiced in Iowa?
Yes.
What area of law do you generally practice in?
Almost exclusively criminal defense.
Oh God, that's terrible.
In general, how many years have you been practicing?
She's got the weird smiles again. I don't know. She didn't have it with the last one she did, but now she's got it again.
46, 45 and a half.
46 years.
Has the type of evidence in a criminal case changed in any way between the time you started practicing in criminal law till today?
Yes, lots of technology.
And are you employed by a firm or do you have your own firm? Where do you work?
I'm a PC, but I'm the solo attorney.
Okay. Have you ever had a legal assistant or support staff person work with you?
Yes.
When you represented Todd Mullis in 2018 and 2019, did you have an assistant?
Yes.
What was her name?
Christy Klein, Klyn.
What types of things would Christy do for you?
Everything from answering the phone, scheduling appointments, accumulating and organizing discovery materials. Pretty broad section of what she did.
Over your decades of experience in the criminal law area, have you represented individuals charged with Class A felonies?
Yes.
Do you know approximately how many of them went to trial?
8 or 10.
In your experience, have you ever consulted with an expert witness for the purposes of representation of a person charged with a Class A felony?
Yes.
Have you consulted with an expert about determining cause of death?
Yes.
Have you consulted with an expert regarding digital forensic evidence such as cell phone extractions or cell tower data?
Both.
How often have you used an investigator on a Class A felony?
I would say about half of the cases.
Do you belong to any bar associations?
Iowa State Bar Association, Iowa Association for Justice, and the National Association of Criminal Defense Lawyers.
And are you aware of the American Bar Association?
Yes.
Are you aware that the American Bar Association has issued a defense function standard?
Yes.
Would you agree with me that the prevailing standards for defense attorneys recommend that you continue to reevaluate your need for investigation or experts?
That sounds correct, yes.
I'm going to turn now to your involvement with Mr. Mullis.
Okay.
How did you come to meet Todd Mullis?
An attorney in Dubuque, I believe. His name is Joey Hoover, who practiced in Polk County, and I knew him from there. I don't know how he knew Mr. Mullis or was connected to him, but as I understand it, Joey had contacted a friend of mine, Roger Owens, who I've tried Class A's with on several occasions, and wanted to know if Roger would be interested in getting involved in Mr. Mullis's case. Roger contacted me and said he didn't want to take a case so far out of Des Moines. Thank you. And encouraged me to call Joey about it, and that's how it came to be.
Thank you. At the time that you learned about Mr. Mullis's criminal case, do you recall if he had been arrested or not?
I believe he had.
Did you meet with Mr. Mullis and enter into an engagement letter or anything like that?
I think the first thing I did is I made arrangements with his sister and brother to go out to the farm and have them show me the location of the incident. And I talked to Lynn about whether or not they wanted to retain me. I had not yet met with Todd.
Do you know Lynn's last name?
It's Todd's sister.
I'm not sure.
If I told you it was Lynn White, would you?
That was going to be my guess.
Was there another attorney that you worked with on Mr. Mullis's criminal case?
Bob Sabers from Dubuque.
Had you ever worked on a case with Mr. Sabers before?
I had never met him.
Never even met him.
No.
How did you communicate with Mr. Sabers as co-counsel?
Probably equally phones and emails.
Thanks, Connie.
Do you know how often you talked to Todd Mullis while his criminal case is pending?
I really couldn't even guess.
Do you know if Mr. Mullis would call you from jail?
I believe he did.
And was your office set up to accept those types of calls?
Yes.
Do you know if Mr. Mullis sent you letters or wrote notes to you?
Letters mostly.
And I think you mentioned earlier that one reason you got the referral was because it wasn't that close to where your office was, or it wasn't that close to Des Moines.
Well, Roger Owens didn't want to get involved because this location was, he didn't want to travel that far to represent somebody, and I was willing to do that.
Do you recall what county Mr. Mullis was being held in?
Independence, I believe. I think that's Buchanan, maybe.
Did you have a regular practice or policy of how you communicated with your clients that were incarcerated?
I prefer meeting them in person, and the jail over in Independence accommodated that, and those phone calls.
Did you speak to Mr. Mullis once a week or once every 2 weeks? Did you have any sort of regular schedule?
I don't think we had really a schedule. I think it would be like if something came up on my end, I would set up a phone call, or if he sent me a letter that had some request or a question in it, I'd respond to that either by a visit or a phone call.
Do you recall ever writing Mr. Mullis letters and sending them to the jail?
I don't think so.
Was it your practice in this case to take internal notes about visits or phone calls with your client?
I'm sure I did, and maybe not every time, but yes, I did.
And did you provide your file to subsequent counsel?
Yes, I just gave everything I had to Aaron Hamrock and Tim McCarthy.
I think you have seen some of these letters in your deposition, but just so that we're all on the same page, I'm going to ask that we display Exhibit 233.
All right.
Are they showing?
No.
Okay. And we can scroll for you when you're ready. I think that one has several pages. I don't want to rush you, but do those documents appear to be letters from Todd Mullis to you?
I believe they are, yes.
Do you recall reviewing these letters during your representation of Mr. Mullis before his trial?
Yes.
And am I understanding correctly that your response to any questions Mr. Mullis had would have only been relayed to him in person during a visit or a phone call?
I believe so.
I want to just look at the very bottom of page 1 of 233, the last paragraph. That should be bottom of page 1.
You short letters?
Do you see a paragraph at the bottom of page 1?
Is there any expert that starts out?
Yes.
Yes.
Do you recall Mr. Mullis asking you about an expert to be used in his defense?
Well, that is posed as a question there.
Okay.
Yes.
And at this time, what was Mr. Mullis's position as to how his wife had died?
He believed it was an accident.
And could this paragraph in this letter be him asking you to get an expert to show it was an accident?
Your Honor, I'm going to object on a couple things. This is one of the exhibits specifically that we had objected to: authenticity, accuracy, identity, or foundation. The letter's undated. It specifically has no identifying information as to the date, time, or otherwise. And also it's hearsay because Mr. Mullis' statements are not statements of a party opponent and therefore being offered directly to in violation of Rule 5, 802, and 3.
Yeah. You want to get in with
If there
Todd?
are-
Put Todd on the stand and make Todd say what he said.
Objections to the exhibit, it should probably be admitted before it's specifically referred to. Would you like to respond to the objections?
Sure. Thank you, Your Honor. We laid some foundation that Mr. Firehelm received letters from Mr. Mullis from jail. He identified these as being letters that he remembers receiving. I could ask Mr. Firehelm the dates of his representation. I do think the record reflects when Mr. Mullis was arrested and when he went to trial. And I guess I don't see how 802 and 803 would prevent a request from a client to his attorney when that is the claim on post-conviction of ineffective assistance of counsel that we have the burden to show. And I have to elicit evidence about what Mr. Firehelm did or didn't do.
I assume these are being offered to show the effect or lack of effect, perhaps, on the reader or recipient. 233 is admitted.
Thank you, Your Honor. Mr. Firehelm, did you understand Mr. Mullis to be asking you to hire or retain an expert to determine if you could provide evidence that Ms. Mullis died in an accident?
I don't know if excuse me. I don't know if I characterize it as a request. It reminds me, that paragraph, of a number of times when, to me, it was like Todd was kind of like shotgunning or spitballing ideas of what about this, what about that, and so forth. So I don't know if I would say that that was a specific request, more of a what about this, or how would this be something to think about or talk about?
Did you contact any experts regarding the manner of Amy Mullis's death?
No.
Did you review any literature or do any investigation into an accidental manner of death?
I reviewed discovery material, which included the manner of death, to allow me to assess whether or not it was an accident or homicide.
And outside of the discovery materials provided to you by the Attorney General's office, did you do anything else?
No other materials or individuals, no.
We can scroll to page 2. In the middle of the page, there's a sentence that refers to looking at the clothing.
Yes.
Is this a request for you or a question for you about examining Amy's clothing that she was wearing when she was injured?
I guess my answer would be similar. I don't know if it's a request or just an idea.
Okay. Did you ever go look at the physical items of clothing that Amy was wearing on November 10th?
I did not. I don't know if Bob did or not.
Okay. I would never ask you to tell me what Bob said.
Okay.
Why would you not look at the evidence? This is so crazy to me.
And what did you understand that there were 3 items of clothing that the state medical examiner had looked at during her autopsy?
I think that's right.
If you go down a little farther, on the bottom of page 2, there's a reference about iPads and Amy using the iPad. Do you see that?
Yeah, yes. Where am I?
It's kind of a highlight in the very, like, it's not a paragraph, but towards the very end of the letter.
So he
Amy
didn't.
used that iPad.
He didn't really care what Todd was saying. Todd was just saying these things in these letters. You should look at the evidence. You should get an expert to look at this. You should do that, or we should probably look at this. And he's just like, yeah, Todd was just spitballing ideas. We're just spitballing ideas back and forth. I didn't really care what Todd had to say, so I just didn't do any of those things.
Is this page 5 of the exhibit? Yeah, thank you.
Do you see the portion I'm referencing, Mr. Fireholm?
Yes.
I apologize. I am definitely fighting off a cold. Mr. Fireholm, was the iPad a piece of evidence at Mr. Mullis' trial, or the data from the iPad?
I think the data was.
And what did you do when your client brought up the issue of the iPad and who used it to investigate that?
Well, here where he was mentioning multiple people using the iPad. I believe that's something that Bob and I either talked about or traded emails about. I think I saw one where Christy maybe responded to one of Bob's questions about that.
Did you interview any witnesses about who had access to the Mullis family iPad?
Just Mr. Mullis, I think. Maybe Len and I may have talked about that too.
Did you take any steps to learn about the password to the iPad?
I don't recall.
Just one moment. I think I'm done with 233 and we can take it down. Mr. Fireholm, you mentioned you spoke with Todd's sister, Lynn. Do you remember how you communicated with her during your representation of Todd?
I'd say the vast majority was by phone, and there were some emails.
Was she also in communication with Todd while he was incarcerated?
I think she was, yes.
Do you recall her reaching out to you with requests to meet with Todd?
Lynn was good about reaching out to me after she talked to Todd about either him wanting to talk to me or see me, or maybe even a specific thing he wanted to look into or checked on.
I'm going to represent to you that Todd was arrested at the end of February 2019. Do you know what your first task was after you were retained and began representing Mr. Mullis?
I think my trip to the farm to meet with Mike and Lynn was the first thing.
And then did you file any motions or take any action in court?
From the get-go, there was a lot of effort put into trying to get Todd out of jail with bond review. I spoke with the bail bond company in Des Moines that I was familiar with and had worked with, talked to Todd, Lynn about resources to acquire a bond.
And would that work have been separate from investigating the charges against Mr. Mullis?
Yes.
Do you recall a time where you requested discovery from the state of Iowa?
I don't know the time, but that probably would have been one of the first things that I did.
When discovery came into your office, what was your process?
I would review it, at least scan it. I don't mean scan it like to copy it, but to look at it, and then talk to Christy. And then Christy was great at organizing, setting up tabs, indexing things, that kind of thing. And then I'd go back and go through it after she had that organization completed.
Are you a paper guy? Do you like hard copies?
She called me the tree killer. Yes, I prefer
I'm sure
paper.
she meant that with all the love.
No, I prefer paper.
So did Christy handle compiling discovery that was tendered to you in an electronic format and making it into paper for you?
Yes.
At the time that you went to trial in September of 2019, did you know if the state had withheld any discovery, or did you identify anything that was missing?
I did not identify anything, and I was assuming the state had produced what they were supposed to.
We can put up exhibits 201. I believe you saw these in your deposition. I'm going to show you 201 and 202.
What is it?
Just let me know when you have had a chance to look at 201.
Okay.
Do you recognize that document?
I believe Angela showed this to me in my deposition, and I don't think I do.
And do you remember testifying in your deposition that you've never seen it before Todd's criminal trial?
I think that's correct.
And we can scroll through it if you like. It's only 2 pages, but does this purport to be case log notes from the state medical examiner's office?
Ooh, what?
Yes, it looks like it.
And I believe 2122 already admitted. Did you learn that the state medical examiner had made comments to DCI that Amy Mullis's manner of death could have been accidental or a fall?
Counsel, I guess, would you like to rephrase your question, or do you take the position that that's an accurate summary of the statement that was made?
I can withdraw the question and ask another one if you like.
Thank you.
Let me just find the spot here.
He's saying that there was these documents that the state, that he thought that he just essentially trusted that the state had given him everything, but come to find out at his deposition for the post-conviction relief hearing, there's a case log document from Kelly Cruz that he never saw.
Okay. If you look at the bottom of page 1, there's a paragraph under November 14th, 2018. Do you see that paragraph?
Right now, the witness has page 2 in front of him. So
page 1, please.
What date did you say?
It's towards the bottom of the page, November 14th, 2018.
Oh, yeah, I see it.
So if we go down towards the bottom, there's a sentence that begins, Agent Turbot stated.
Yes, I see it.
If you read that, is that new information to you about what DCI was telling the medical examiner?
I think it is, yes.
And is that type of information that you would have wanted to know for your cross-examination of the state medical examiner?
Sure.
Discovery violation.
Could it have explained where she was getting her information?
From Turd Butt.
Yes. But in other homicide cases that I've been involved in, I've seen this type of exchange between the medical examiners and like a lead investigator. But I just don't think I saw this one.
Okay. We can go to 202. And Exhibit 202 has also been admitted, and it is 2 pages. If you could review that, I'll just ask that we scroll slowly. Mr. Firehome, do these also appear to be notes about conversations with the state medical examiner?
That's what it looks like.
Okay, and does this, we can scroll for you if you like that, contain information obtained from the autopsy about injuries?
It appears so.
Does it indicate how long Ms. Mullis would have survived after her injury?
I don't see anything like that on page 2.
It might be page 1 at the very bottom.
Yeah, it says, it's so hard to tell how long she was alive, at least minutes she was alive, not immediately fatal.
Not immediately fatal.
Would you have wanted to have these notes available to you at trial to cross-examine the DCI agent, Mr. Turbot, who provided this information or made these notes?
Yes.
Does it also discuss whether Amy Mullis's injuries could have been from a fall, or if so, why not?
There's indications in there about whether it was accident or intentional.
So essentially, they're saying that she was alive, obviously, after being struck. So, which is also interesting. If his whole purpose was to lure her there to kill her, he chose the corn rake and then didn't even make sure she was dead before he ran back to work at the hog barn.
And Mr. Firehome, the first time you saw these documents was during your deposition in 2023?
I believe so.
Okay, we can take that one down. Do you remember the name Deputy Keith Rowley?
Ooh. I don't recognize that.
Have you learned, I'm sorry, let me start. Do you recall the state filing a motion in limine pre-trial to limit the use of a deputy's name who had a prior affair with Amy Mullis?
I'm pretty sure I remember that, yes.
Did you ever learn who that deputy was?
I I think we knew the name, yes.
Did you ever receive any documents or information that Deputy Rowley was cleared as a suspect from being involved in Amy Mullis's death?
I don't ever remember seeing any documentation.
Do you remember hearing anything in depositions about clearing Deputy Rowley?
There might have been, the only thing I remember specifically about depositions in that issue was how the case was assigned within the sheriff's office for investigation.
Do you recall seeing any patrol logs for any of the sheriff's deputies from Delaware County on the day that Amy died?
I do not.
Ooh.
Do you recall seeing them during your deposition?
The one of my deposition?
Yes.
I don't recall.
The state would just say that's not exculpatory. Doesn't matter.
Just a moment, I'm going to pull those up for you.
Sounds fun, Thomas.
I lost the number, so I apologize for the delay. Okay, should be exhibit 323. Okay, 209, I'm sorry. Let me know when you have a chance to look at that, Mr. Fairham. Mr. Byron, if you could scroll through 209 a little bit, it's 12 pages, and when you're ready, let me know what you see.
It looks like a log that a deputy would maintain about activities on their shift.
And at trial, I'm sorry, in preparation for trial, would it have been helpful for you to know whether other people were near the Mullis farm November 10th?
It's helpful to have as much information as you can, and that was something that we talked about.
Okay, we can take that one down. Did you hire an investigator to help you investigate or to represent Todd Mullis?
Did not hire one.
Oh my God.
Do you remember who Jerry Frazier is?
Yes.
Before trial, did you know or investigate where he was on November 10th, 2018?
Yes.
How did you know that?
From discovery material in his deposition.
Okay, I want to show you exhibit 212. It should be Frazier cell phone record. Oh, I'm sorry, we don't have 212. 213 and 214. Let me know when you've had a chance to look at 213.
Yeah, that's the cover page of the report.
Have you had a chance to review that?
Why would you not hire an investigator?
Okay. Do you recall being asked about cell phone tower records or cell phone records for Jerry Frazier in your 2023 deposition?
I think Angela asked about that.
Do you recall saying that you were surprised to hear testimony about Frazier's location by cell phone tower?
If that's what I said.
Would you like to review your deposition?
He doesn't remember.
Sure, I don't remember that question and answer.
If we could pull up 323 and scroll to the bottom of 42. You can review page 42 and 43.
So interesting side note, because earlier you'd asked me about if it was a civil case or how if it was like a civil suit, and I was saying no, that it actually falls under the criminal side. So interesting side note, because as I'm reading here, and you might not be able to see it, but at the bottom it actually states for law and crime that they're proceeding with a civil bench trial. It is not civil. It's actually not, it's considered. So I'm like, I'm gonna fucking research that, because it's not civil. It's considered a collateral action. So it actually doesn't fall. So they're wrong and I was wrong. It doesn't fall under the criminal conviction or a civil case. So it's a distinct avenue for relief within the criminal justice system called a collateral action. So I thought that was interesting info for people who like to learn stuff about the, law. It's not either one. And even they're saying it's a civil bench trial, but it's not. It's not civil. I don't know if it's closer to either one, because what I am reading, it's literally all the rules that apply to both criminal and civil procedure are not in play here. So it makes it, that's why it's called a collateral action. So I just thought that was interesting, and I wanted to correct that since we had talked about it earlier.
Okay. I can remember this now, yes.
Okay. Do you recall at Mr. Mullis' criminal trial making arguments?
He lost 2 appeals. He lost his interlocutory appeal in 2019, and then he lost his appeal with the Iowa Supreme Court in 2020. Hey, Mav. So far, we're essentially hearing that there might be some documents that should have been delivered in discovery that may have not been. This attorney is now stating he's never seen some of these.
That Amy could have been killed by Jerry Frazier because of their affair?
I don't remember that specifically, but I could have.
Do you recall your closing argument at the criminal trial?
Not any details, no.
Do you recall whether you argued to the jury that Jerry Frazier was the perpetrator, not Todd?
If that's what the transcript says, I would obviously deny it.
Okay, let me ask a different question. In your mind, leading up to Todd's trial, was Jerry Frazier a suspect in Amy's death?
I don't remember.
I would say yes.
Oh, there you go.
And
Purple, essentially, from my understanding, after a little bit of research, it seems that she can vacate. Well, she can just maintain everything the way it is. Say, nope, sorry, you didn't have enough. Your sentence is still in effect. She can vacate his sentence and conviction and say, state, you did everything wrong. If you want to do it again, you can do it again. Or not even state you did everything wrong, but Mr. Jake here, that you were ineffective counsel and the state did things wrong, and now you can either retry him or let it go. Or she can say, nope, done, he's released, he goes home, there's nothing to see here. I don't even think he wrote anything, Susie. I think he just went up there and winged it.
if you look at 42, page 42, line 22, the question asked of you is, okay, but would it be fair to say you were surprised to hear a state witness say they had conducted cell tower analysis and verified Jerry Frazier's location by cell tower analysis? And then at the top of 43, your answer is, I would have to say that would have been a surprise, yeah. Do you recall giving that testimony?
Yes.
Okay. If you had had information that Jerry Frazier was not on the Mullis farm November 10th or near it because of cell phone tower data, would you have still argued that he could have killed Amy?
I think you could because of the relationship that they had.
Did you consider that?
I agree with him.
The state had evidence giving Jerry Frazier an alibi for the time that Amy was hurt?
I don't know.
I want to move on for Mr. Frazier. Do you recall deposing Dr. Kelly Cruz?
Cell phone towers track cell phones, not people. So one can infer that the cell phone is with the person, but that is not always true. But if he has an actual alibi where he's seen on camera at another location at the same time of her death, then that's different.
From the state medical examiner's office?
Yes,
Do you recall being asked about reviewing that autopsy report in your 2023 deposition?
I think so.
And what actions did you take after you reviewed that autopsy report to investigate it or to verify the opinions within it?
I don't believe I consulted anybody other than talking to Bob about it that I recall.
Do you remember testifying in your deposition that it was your personal opinion that you agreed with Dr. Cruz?
What?
I think it did, yes.
And you don't have any forensic pathologist training, is that fair?
No.
Okay.
You just said he agreed with Kelly Cruz?
Okay, I want to talk a little bit about the Google searches that were offered at Mr. Mullis' trial. Do you recall that evidence?
Yes.
Do you recall who testified about the Google searches?
I can't remember which state witness did.
If I told you it was law enforcement, would you accept that?
I think I would, yes.
Did you do any investigation or take any steps to determine if those officers are qualified to testify regarding cell phone data extractions?
They may have mentioned it in their depositions, but I don't recall specifically.
And did you contact your own digital forensic expert to review the data?
No.
Oh my God!
Do you remember testifying in your deposition that the Google searches were harmful to Todd?
Yes.
What?
And
yes, Chris.
do you recall if the Google searches were being, how the state was using those in their case in chief?
Well, I think they were trying to show that some of the searches were rather specific about harming someone, cheating spouses, that kind of thing.
Would you characterize that as motive evidence?
Sure.
If you had evidence that Todd did not conduct those searches, would you have used that at trial?
Yes.
Do you recall Todd writing letters and having discussions with you about those Google searches?
It came up in letters, it came up in meetings at the jail, phone calls. Yes.
Did you present any evidence in Todd's defense that he did not make those searches?
I recall during cross-examination of some state's witness, it would have been law enforcement, that there were some obvious searches that, like looking for a dress or something like that, or jewelry, that kind of thing. So I felt that the point was made that not all those searches were done by Todd.
Did you do any work to determine where Todd was on the day of the most offensive searches? The ones that you referenced earlier about unfaithful women?
I don't think so, no.
Do you recall researching or drafting a motion to limit the admission of those Google searches because they were not close in time to Amy's death?
I don't think so.
Did you consider that if searches were being done in May, where Todd would have been at that time?
I didn't try to make that connection, no.
Did you know that your client, Todd Mullis, was a crop farmer?
Yes.
And as a lifelong Iowan, do you know when planting season usually is?
Yep.
When is that?
Depending on spring, sometimes it's April into May.
Oh my God.
Do you recall discussions with your client about his kids taking a hunter safety course?
Yes.
You did bring that up at trial.
Did you take any actions to determine what that entailed?
No.
I didn't research. I relied on what Todd told me about it.
If we can show the witness 306, but not publish. Mr. Byron, can you identify the document? Tell me what the name of it is.
It's titled Today's Hunter, Hunter. And down below it says a guide to hunting responsibly and safely.
Do you know what topics a person needs to learn about to get a hunter safety certificate?
No, I don't. I grew up hunting, but I never took a course.
If you had reviewed this guide before trial and it included information about hypothermia and organs of the body or things like that, could you have used that to explain the Google searches the state presented as motive for Todd to kill Amy?
I think that's reasonable, yeah.
And did you understand that Todd was charged with first-degree murder, which included premeditation or planning, right?
Sure.
If I could show you 223. Do you remember discussing with Mr. Sabers about whether you should hire a computer expert? and I'm showing you an email from May of 2019. If you could tell us when you reviewed it and identify it for me.
It's going kind of fast, but yeah, it looks like an exchange between myself and Bob and Lynn White.
And did you ever consult with a computer expert or digital forensic expert?
I don't think so, no.
We can take that one down.
Fine.
Do you remember evidence being tendered to you that included text messages between Ms. Mullis and friends of hers?
Yeah, I think so.
Did you interview any of those friends about those messages?
No interviews, no.
Do you recall deposing some of them?
I think we did, yeah.
Did you seek to issue any subpoenas for cell phone records as part of your defense investigation or preparation?
I don't recall doing that, no.
Do you recall filing a motion in limine before trial asking to prohibit witnesses from testifying to hearsay, especially relevant to the friends of Amy and what Amy had told them about Todd?
I think there was a motion, yes.
Do you recall getting a ruling on that before trial?
Yes.
What was that ruling, if you remember?
Not favorable to our request to limit the evidence.
Do you recall discussing this with Bob Sabers?
Yes.
Oh, I'm sorry, can we show the witness exhibit 219, an email with Mr. Sabers? Do you recall this email exchange?
Not specifically, but I'm not saying I didn't get it.
I don't know.
The judge did not.
I tried. I've said people who are really who follow Delphi, people who follow Karen Reed. Like this is like such a big deal in the cases that people are all gung ho about. Like this is exactly what happens, and I don't know how to get people to actually pay attention to a case that isn't in like super mainstream media. It's crazy to me. They don't want to learn or see it. I'm like, this is, if anything, like this is the perfect example of what people who are adamant about Delphi or adamant about Karen Reed. This is the perfect example of what you're looking at. Well, I should watch this live chat on Law and Crime. You ain't changing people's mind. The state is never wrong. It's impossible. Oh, I don't even want to. The state, I have people message me telling me that I'm wrong, thinking he's innocent. I don't know. I can't. This isn't even a fence thing for me. I've never been on the fence. I've always thought this guy was innocent. I'm like, let me try to figure out if what the state says even makes sense. It's just never made sense to me. I can't wrap my mind around it. I don't. There's not really I just don't think he did it. I don't know. There's not even like really I can't even get to offense. Like I've tried to even get to offense to be on, but the guy just didn't do it. Like I have no issue whatsoever saying that he is 100% innocent. And it's crazy to think that he has spent the last 6.5 years in prison for a crime he did not commit. And nobody, it just doesn't become big enough because he's not, it's not mainstream. But I don't know how you make cases bigger besides just talking about him. So here I am talking about it because I absolutely believe in his innocence, and I'm just going to talk about it. That's all I can do. I don't really know what else I can do. I don't know. Yeah, right, Angie, I know. Here we keep going.
Issue of ruling on your motion in limine and reserved it for trial. Would you disagree?
Not specifically, but I'm not saying I didn't get it.
If the docket reflects that the judge did not issue a ruling on your motion to eliminate and reserved it for trial, would you disagree?
What motion to eliminate? I missed it. Did you? What?
This with asking to prohibit witnesses from testifying to hearsay, especially relevant to the friends of Amy and what Amy had told them about Todd.
I think there was a motion, yes.
Do you recall getting a ruling on that before trial?
Oh.
Yes.
What was that ruling, if you remember?
Not favorable to our request to limit the evidence.
Do you recall discussing this with Bob Sabers?
Yes.
Exactly, purple. Getting harder and harder, Rick.
Oh, I'm sorry, can we show the witness exhibit 219, an email with Mr. Sabers?
Okay, so he filed a motion to eliminate to make it so all that hearsay that we watched at the trial, where all her friends were coming in and being like, oh, yeah, she said that Todd's going to kill her and all this stuff, all those comments, he filed a motion to eliminate to keep that out. He says it was denied by the judge, but from what I'm gathering, it seems like maybe the judge never even ruled on it. Well, let's keep going.
Do you recall this email exchange?
Not specifically, but I'm not saying I didn't get it.
If the docket reflects that the judge did not issue a ruling on your motion to eliminate and reserved it for trial, would you disagree?
Yep.
Without certainty, no, I wouldn't disagree.
Are you familiar with making hearsay objections during a criminal trial?
Yes.
If you made objections, would those be reflected in the trial transcripts?
Sure.
Oh. We know you did.
Do you remember a statement by a friend of Ms. Mullis's, Terry Stainer, to the effect of, look for me in the timber if I go missing?
I remember that specifically.
Was that one of the statements that you intended to address with your motion to eliminate?
That and others like it.
Why that statement and others like it?
Well, it indicated Amy's state of mind and her fear that Todd would harm her.
Did you consider those types of hearsay statements to connote a guilty inference that you would have wanted to keep out of the trial?
Yes.
Why did you object?
Do you recall if you and Mr. Sabers discussed what your roles were going to be at the trial?
I don't recall a specific discussion, but I think throughout it, I was the lead counsel and he was taking notes and making suggestions and talking to Todd and that kind of thing.
Do you recall if he passed you notes during the trial?
He did.
I apologize. Excuse me. Do you recall if you read them?
It's difficult to do during a trial. You glance at them, talk about them during the break, that kind of thing.
Ooh.
Did Mr. Sabers
Remember?
handling it?
Remember when we were watching and we were saying the other attorney, he had the red tie on that day. I remember specifically we were like, he does not agree with whatever this guy is saying. We could tell by looking at him he didn't agree.
This is at this trial.
I don't think he did, no.
Do you recall any discussions about who was going to do the opening statement?
I don't think we ever discussed it.
Yeah.
Did you draft an opening statement to review with your client before trial began?
No.
I normally have, I don't know if you call it an outline or notes, but not really a draft, word for word. And I don't recall sharing with Todd about the content of the opening statement before we went to trial.
Do you remember what the premise of your opening statement was?
That Amy was murdered, but not by Todd.
What evidence did you plan to present to show that?
The focus was on Tristan and his testimony about the events of that morning, of who was where.
Did you have any other witnesses or evidence that you planned to present?
I think we called a couple witnesses that had contact with Tristan after, that took him home from the hospital after this had occurred.
Did you have an alternate suspect or another person in mind that you were going to suggest was responsible for Amy's death?
No, I think I talked about that with Todd and Bob, that it wasn't our job to find out who did it. It just cast doubt about Todd being responsible.
Did your client, Mr. Mullis, ever agree to your decision to make that statement in your opening statement?
I never asked him if I could, and he never told me I couldn't. Or I think going clear back to early on in the case, I made it clear that I did not believe this was an accident, and that she was murdered.
And that was based on your own personal opinion or evaluation of the autopsy report?
Yeah,
Autopsy report, police reports, life experiences.
You believe she was murdered.
And you don't recall writing any letters to Todd explaining that or asking him if he was in agreement?
I'm sure there weren't any letters. Again, we just generally talked about our theme of the trial.
Do you recall that Tristan testified via closed circuit television at this criminal trial?
He did.
Do you recall how old he would have been?
14, I think.
And I think you testified a little bit earlier that part of your plan was to focus on Tristan, right?
Yes, significantly.
Did you consider Tristan to be Todd's alibi?
Yes.
Do you recall there being an issue between Tristan's pretrial deposition and his trial testimony?
Yes.
Did you do any investigation or take any steps to learn more about the slight change in Tristan's testimony?
If I'm recalling the events accurately, Tristan testified in a deposition, and he gave testimony about the amount of time he would have been absent from a location in the hog barn where he could see Todd. And he gave a time frame that was relatively short. And then afterwards, he met with his attorney, and that attorney came back and said that Tristan said he had made a mistake.
And I guess my question is, did you take any action to look into that?
The action I took, and I believe it's indicated in an email, is that I contacted Todd about this development with Tristan and suggested that we needed more time to do that. But Todd was adamant that he did not want to continue the trial. So other than that, Lynn had provided me with some drone photographs of the hog barn and the shed where Amy was found and that kind of thing. So we used those to show the significant distance between the barns. And if Todd did leave Tristan's eye shot, even for the longer time that Tristan said, I think it was 30 seconds, I don't know what, it would have been impossible to leave the far end of the hog barn, go to the shed, do whatever happened there, and then get back before Tristan missed him.
So that covers everything that you did do.
Yes.
To corroborate or to investigate Tristan's testimony?
Yes.
Do you recall why you called Mr. Mullis to testify at his trial?
One reason is that so many times when I've talked to jurors after trials, my conclusion was they expect to and want the defendant to testify that they didn't do it, even though you tell them that in voir dire and so forth that they don't have to. And as late as the night before the beginning of the trial, when we met in the Dubuque County Jail, I'm not sure we had decided for sure if Todd was going to testify, but I left that meeting that night with the understanding that we both agreed that he would.
How did you prepare Mr. Mullis to testify?
In those meetings.
Did you ask him questions so he could practice his response?
I don't know if it was questions or answers. We just talked about topics that he would expect to be asked about.
Did you practice any potential cross questions that the prosecutor might ask him?
I don't think so.
Do you remember discussing with Todd that he needed to testify to rebut the Google searches?
I think that is one of the things we talked about, yes.
And was that in part because you didn't have an expert or anybody else to testify about whether Todd made those Google searches?
I don't think that was the reason, no.
Did you cross any other state witnesses about whether Todd Mullis could have done those searches?
There was cross-examination about some of the searches that seemed obvious that Todd would not have done. I can't remember what state witness that would have been.
Did you consider Todd's credibility to the jury after your opening statement?
I take that into account throughout.
Were you concerned that you had told the jury that Todd was wrong when he told investigators Amy died in an accident?
Would you repeat that, please?
Were you concerned about Todd's credibility in front of the jury when you had told the jury in opening that Todd was wrong when he told investigators Amy fell on the corn rake and it was an accident?
I don't think that comment was undermined his credibility. I think Todd honestly thought that when he said that thing. I just said, as we researched or prepared for trial, that was wrong.
Do you remember the 911 call in this case?
Yes,
Do you remember it stipulating to the foundation or the admission of it at trial?
I think so, yes.
Did you ever take the 911 call to the jail so Todd could listen to it before trial?
I think we had a transcript of it, but I don't ever recall playing the audio for him in jail.
Did you have intended a transcript without it been in the discovery?
Yeah, I think so.
I'm just clarifying you didn't have a transcript made.
No, I don't think so.
Do you remember the prosecutor playing the 911 call during her cross-examination of Todd Mullis?
Yes.
Do you remember two comments towards the end of the call that the prosecutor emphasized?
I do.
Had you ever heard those before?
No.
Were those undisclosed statements made by a criminal defendant?
Objection calls for speculation or conclusion that's well beyond the actual terms of what he can testify to. The evidence speaks for itself.
Overruled. The witness can answer if he's able.
Could you repeat?
Yeah, I'll rephrase. Are you familiar with rules of evidence
Yes,
that require the disclosure of statements made by a defendant?
Yes.
Before the cross-examination where the prosecutor played that call, had those statements ever been disclosed to you before? Purported statements. So sorry.
Well, the whole 911 call was, we always had that, the whole thing. But the contention that he said certain words, no.
And weren't those phrases highly inflammatory?
Sick.
Yes,
Did you think Todd made those statements on that call?
I did not.
And you don't recall seeing them in any discovery or anybody telling you about them in a deposition?
No.
Have you made a motion for a mistrial before in a trial?
Yes.
Boom.
Did you do so in this case?
No.
Why? Exactly what he should have done.
We have just one moment.
Now, his original lawyer, I don't think his original lawyer necessarily believed he was guilty, but I think he did believe it was a murder. I think that's kind of the general consensus, is he agreed with the medical examiner that it was a murder. So he just went with what he believed. He might have, but that's not what they haven't said that. He might have thought he was guilty. But he did not advocate. I agree. He did not advocate. He did not advocate. He's ever made a motion for a mistrial, to be fair. He absolutely should have asked for a mistrial right there. Which doesn't surprise me, because Tristan is the other one that's on the farm. And I mean, I'm not going to lie. I've wondered, if Todd's not the one being asked if he ever didn't have Tristan in his sights. You know what I mean? Like, so I've thought about it. It just doesn't make sense to me. The only thing that makes sense to me is an accident. But he should have immediately said, I want a mistrial. The jury cannot unhear what that prosecutor just fucking said. But then the prosecutor covers her ass and she's like, what I say is an evidence, and what he says is an evidence. You guys go listen to it for yourselves and you determine it. But I mean, he should have at least put it on the record that he was requesting a mistrial, even if the judge said no. He didn't even object. No.
Do you recall the prosecutor telling you off the record that she was going to ask him about these specific statements?
I'm certain that she did not.
Do you recall taking any investigative steps to determine who would have been present at the time of those alleged or reported statements by Todd?
No.
If I'm remembering correctly, the 911 call ended there on the gravel road when law enforcement first it was law enforcement people showed up. And that's about when supposedly he made these statements that the prosecutor brought up.
If you had notice of these reported statements, could you have investigated or attempted to discredit that cross-examination question?
Yes, I actually took the 911 call after the trial was over and had it enhanced to try to see if I heard what supposedly was said.
Did you ever learn how the state came to make that argument?
I was told by the prosecutor.
Did you get your own transcript of the call for post-trial motions or anything?
Because of the change in representation, I wasn't involved in the post-trial motions.
When did your representation end? I should have asked you that.
Between verdict and sentencing.
So you did not get a transcript of the call before your representation ended, am I right?
I think you're right. I'm not sure we ever had a transcript of it.
Well, in this case, it was the prosecutor, so it's still a state agent, but. And then she was all proud of herself. So when it comes to that 911 call, they played it for a witness. They went through the 911 call. Somebody from online that heard the testimony and heard the 911 call played contacted Deputy Hemisath and said, hey, you should really review this part because this is what he says. Hemisath took it to the prosecutor, and the prosecutor did not disclose it to anybody, and instead just threw it at Todd while Todd was on cross-examination.
Nicole, can you find 294 to show Mr. Firehome? And I'll move on for a moment and come back while you're doing that. I don't think I warned her I was going to do that. Mr. Firehome, during your 2023 deposition, do you remember being asked about a Greeley EMT who had filed a report about her response to the 911 call for Amy's injuries?
Yeah, I kind of recall something about that, yes.
Did you do any investigation or take any steps to determine whether the first responders' actions and or CPR could have caused some of Amy Mullis' injuries?
I vaguely recall whether it was the ER doctor at the hospital or possibly during the medical examiners, but I'm not sure of that. I'm sorry.
Did you talk to any of the Greeley EMS first responders before trial?
No.
Do you recall the Mullis family telling you that Greeley EMS was there and that you could contact them?
I don't recall them telling us that. It was pretty obvious from the reports. They might have.
Did you ever do any follow-up to get the Greeley EMS reports before trial?
Not unless they were in the general discovery.
Did you ever learn that law enforcement was suspicious about how Amy sustained her injuries at the hospital on November 10th?
I honestly can't say when the suspicion began.
Do you recall doing any investigation or interviews with people about that?
Again, and I might be wrong about this, about whether or not that hospital doctor talking to law enforcement, that it may have started then, the actual day.
Did you take any steps to learn about potential conflicts of interest or bias in the investigation?
No.
And were you aware that Amy Mullis had worked at the same hospital where she was taken when she was injured?
Yes, I think we did know that.
And were you aware that some of the witnesses the state called to elicit those hearsay statements worked at that hospital as well?
I think we were aware of that, yes.
Are you ready, Nicole? Okay. 294. The record to reflect that we're showing the witness exhibit 294. And if you could take a look at the first page and tell me what it is, and then we are happy to scroll through it for you.
It's still dark.
Still loading. It knows that it's 4 o'clock right now.
Yeah, not showing it's connected. I'm not sure if you need to try again.
Can you identify the document for me, Mr. Farrell?
And he still doesn't have it yet.
Oh, I'm sorry.
Sure.
Sure.
On Mr. Baki's computer?
Yes.
All right, let's try that one.
Do you see a transcript of 911 call?
Yes.
What date?
The date of the call?
Yes.
November 10th, 2018.
And does it identify who made the call?
911 call by Todd Mullis.
And if we can start scrolling. Page 15 of the PDF. Could you review that for me, Mr. Fireholm?
Yes.
I want to direct you to line 5. Can you read that for me?
Deputy Luke, here, comma, Todd, let me.
Do you know who Deputy Luke is?
No, not specifically.
Thompson.
If I told you that was Delaware County Sheriff Deputy Luke Thompson, who testified at trial, would you disagree?
No.
Objection. We're reading from a transcript, not an evidence that the state would object to its admission and consideration in the first place.
If I can ask 2 more questions and then I'll move to admit again.
Well, again, if there's an objection to it, we should probably admit it before we get too far in the weeds. I mean, do you think you can get it in through this witness?
Just a moment. Your Honor, it's a certified transcript by a court reporter. I'm not sure what other foundation the state would like to have. Page 17, I think, is where Kimberly Blink does her certificate.
I mean, counsel, any response in that respect?
While we agree that this is a certified transcript of a 911 call that, according to that same certification, is done merely to the best of the court reporter's ability, based upon heavy breathing and inaudibility, this is not a transcript from a court proceeding. It constitutes hearsay. This witness hasn't seen it before, and while it's certified, that may go to its authenticity and to its identification, but it certainly doesn't go to its admissibility outright. So the state objects on lack of foundation, objects also on hearsay, as it falls under the rule and doesn't meet any criteria or exception. And 432B as prejudicial more than probative, given that the Court of Appeals have already addressed this, and a footnote finding that the jury could listen for themselves and believe or disbelieve the arguments of the prosecutor as presented at trial.
Well, I think that certainly Ms. Nichols-Cook, you can ask your questions about the timing and the presence of the deputy in relation to when these statements were made or not made. Without the use of the transcript, we can address the possibility of this coming in maybe at a later time. I don't think this is the right witness necessarily to do it if it is going to come in, but why don't you proceed? We do need to end at 4:30 today, and I suspect we're not in a position to do that, so go ahead.
Okay, thank you, Your Honor. Mr. Fireholm, if you could just read through page 15 and 16 for me.
You can just tell me what's page or line?
Page 15 and page 16.
Oh, okay. It's kind of covered up. I think this is 15. Line 2. Oh, excuse me.
Just tell me when you want me to scroll since I'll do the technological.
Could you let me see the top? Okay, that's good. Line 2 starts out, she's cold.
And right now, you're just reading to yourself, sir.
Oh, I'm sorry. I'm sorry. Scroll, please.
Have you been able to review page 15 and 16?
Yes.
Okay. In your review of this transcript of the 911 call, do you see the 2 statements the prosecutor asked Mr. Mullis about on his cross-examination?
I do not see those words.
Okay, thank you. We can take it down. Mr. Firehelm, are you aware that the state misrepresented the source of the Google searches at the criminal trial?
Objections to categorization of the state's statement, and also under Rule 5430. Also good.
Sustained.
Mr. Firehelm, I'll ask a different question. Are you aware that evidence exists that would have rebutted the evidence presented at trial that Todd Mullis alone made the Google searches that the state presented?
I'm not aware of any technical research or document.
Are you aware of digital forensic experts that could examine the iPad and determine information that could potentially contradict the evidence presented at trial?
That's pretty broad. Yeah, I assume an expert could examine it and give an opinion to that. Whether or not it would confirm it or not, I don't know.
If there was evidence that contradicted the state's presentation about the electronic evidence, would you have used that at trial?
If there was evidence?
Yes.
Yes.
If you were aware of evidence that contradicted the state medical examiner's determination that the manner of death was homicide, would you have presented that at trial?
Yes.
Okay, I think I have one last exhibit to show you. It will be 245.
Yeah, he didn't have his own expert look at any of the data. He didn't have his own expert
Mr. Farrell,
download
do
or
you
extract any
recognize
of the
the document
data.
on your screen?
No.
If we can scroll a little bit, and let me know if you do recognize the handwriting or content.
I don't know.
Okay. We can take that one down. Do you recall taking any steps to investigate Amy Mullis's medical condition at the time that she was injured on November 10th?
We were aware that she had a medical procedure a few days prior.
Did you obtain medical records about Ms. Mullis's procedure or medications that she was on?
If it was in the discovery, yes, I don't recall specifically.
He didn't do anything to find any.
Did you do any investigation into whether Ms. Mullis would have been dizzy on November 10th due to her medications?
No.
No research, no other than what Todd Tristan said.
And did you issue any subpoenas to get medical records?
I don't believe so.
Did you have any medical records that you did receive in discovery reviewed by an expert?
No.
Do you recall a letter from Mr. Mullis asking you to, or stating that he wanted to get a 3D demonstration of the injury to show that it was a fall?
No, I don't recall that specifically, no.
If we can pull 233.
Well, no, he wouldn't do that. He thought it was a murder.
And we're going to go to page 11. 233. 233. Is it in front of you, Mr. Firehome?
Yes.
Can you read page 11, 12? Do you see any drawings or diagrams in this letter?
It's not very clear, but I can tell that there's something there.
Look at page.
That one, yes.
We can scroll to page 13.
Your Honor, I object to this exhibit isn't in evidence. It's hearsay. It hasn't been adequately authenticated. I do believe 213 was admitted into evidence, and 233 was admitted in full at this time. I apologize. I withdraw my objection, Your Honor.
Thank you. Mr. Farham, have you had a chance to look at page 13?
Yes. Excuse me.
And we
Right,
can scroll to
Donnie.
14 as well. Do you see additional drawings regarding Amy's injuries in this letter from Mr. Mullis?
I do.
Did you take any steps to investigate the information that Mr. Mullis provided to you?
I don't know what the date of this is.
Do you recall taking any steps at any time to investigate the
No,
information in this letter?
no forensic experts or witnesses or anything, no.
Okay. Your Honor, I think this is a good place for me to stop. Unfortunately, I think I still have a few more questions for Mr. Firehome. I don't know if the state would be agreeable to, I think we have potentially an expert in the morning, and Mr. Firehome might not be able to get back up here until tomorrow afternoon.
And maybe we can have some off the record discussion about scheduling briefly. Okay, we'll do that before everybody takes off, but we're planning on recessing until 9 o'clock in the morning. I have been informed by the clerk of court that they're bringing a crane in tomorrow to move something. So whatever the parking situation was this morning, it's going to be even worse tomorrow, to the extent people want to know that. They may need a couple extra minutes to get here. See you tomorrow at 9. Have a nice night.
Thank you, Your Honor.
There you have it. This has got to be stressful for him to be challenged like this, but he's so monotone and no change in his attitude. I think I see his Ty doing a little heavy breathing. I feel like he doesn't, he's not stressed at all. He's just like, yeah, sure. All right. So then they bring in another witness. So we have 2 days left of witnesses and testimony. We'll be back tomorrow to do that. I wanted to see when Bob's live is tonight, but that's fine. Hey, young black economist. Yeah, so we'll be back. We'll come back tomorrow. We'll start fresh on day 5 of the post-conviction relief hearing, and see what happens. I don't think I'm going to be live tonight because Bob's live with Stacey Eldridge, and I really want to watch that. And I don't have any idea how long it's going to be. Oh, he's live in a half hour. Okay. Oh, then maybe later. I don't know. I guess we'll have to see because I still have stuff to talk to you guys about on other cases. So we'll see. We'll see what happens. Been lurking and working. Yes, we'll be back tomorrow, same time, same place. I'll see you if I don't see you live tonight, I'll see you around the YouTube streets, but I'll definitely be at Bob's to watch Stacey Eldridge on there. for the Delphi case. If you guys are wanting to watch that, what did I think of Erica? I think Erica and I don't know if it's Christina or Christina. I think they're both well intentioned. I think that there's a lot of emotional baggage that is attached to what's happening for them right now. If you want my opinion on what they should do, I think they should both take a step back and stay off social media. Or if they're adamant about being on social media, they are not violating any gag order. There is no protective order on the information they have. They did mention something last night about being under an NDA. That would only be with the defense attorneys. That typically has an end date. I don't know when that is, so that would be up to whatever their contract says. But if they're adamant about coming out, then I think they just come out and say whatever, say it all. Like the half out, half in, I think is confusing and not worth my what would I say? My time isn't the right word. It'd be more like it's just not worth the energy to try to decode what the hell is happening. That I don't want to be a decoder. I just want somebody, if you're going to come out and just talk, I just want you to come out and talk, or say these are the categories I can talk about. These are the categories that and that's all, and that's all I'm going to say. I just feel like there's way too much emotional baggage to go to be doing it right now for them, and I don't mean that in a mean way. So I hope nobody takes it that way. I just feel like maybe it's just too close to that time frame. It's the same thing I kind of thought about, like the interviews on Court TV and whatnot. It's too close to the time frame, and I think there's just too much emotion under it. So then I think if you're gonna not talk, then just don't talk. If you still are obligated with your NDA and you still feel that it's you have a contractual obligation to this defense team or a current defense team or anything along those lines, just don't talk. Or be like us and be like, I'm going to come on and I want to speculate about stuff, but I don't have enough energy and time to try to decode the message. I think that was my struggle last night. I just really wanted a very simple clarification on because if you don't talk, you get attacked for billions of hours every day. I disagree with that because nobody knew who they were. Nobody knew who those two women were until they came out and talked. So I don't necessarily agree with that. And if you mean from this point forward, I would just simply say I'm no longer going to speak on this, and when I can, I'll come out and tell the full story. You can respect it or not respect it, but that's the bottom line. You can't. I would just say that. That's where I'm at with it. So I have no personal issues with either person. I just think that right now with Delphi, things are very convoluted with how people are reacting to one, each other, and then two, any type of release of evidence. Like we the public require transparency. We can't get it from the state. Somebody working on the defense side of things decides to put out things for the purposes of transparency, and then it just causes more internal fighting. I'm like, but if the state sends it in a thumb drive, all of a sudden we believe it. Like, I don't fucking trust them either. Yeah, Rexy, that one. That's why I'm like, I have no personal issues with either of the investigators. I just think you kind of have to pick a lane. Once everybody agrees with my theory of what happened, we can all begin to heal. Agreed. I felt like I spent a lot of time trying to figure out what the purpose was of this breaking of the silence when I'm not sure that there's ever been silence. So that's kind of where I was at. Like, where are we at with the whole thing? I just wanted clarification, and that's kind of where I was. But like I said, I mean, people that are, fighting for somebody's, freedom and to continue to fight for their innocence, more power to you. I got nothing but love for you. Just try to make it as clear as possible. Hi, Kat. There have been a lot more threats and attacks from the psycho trolls. That's part of it, I think. But I think that the problem I have with this, again, Miku, is nobody knew who they were. Nobody knew who they were. And yeah, there's definitely, I mean, there are people who get mad at me all the time. People who think Richard Allen is guilty get mad at me. People who think Richard Allen is innocent get mad at me. I just don't, I just don't really care. I mean, it gets tiring, but so take a step back. There were people who were fed info from the state new as well. Yeah. Am I gonna I haven't decided, Chris. I haven't really decided. There's a part of me that feels like with Lori Vallow, I'm done. But then I still go watch all of her hearings. So then I'm like, I'm obviously not done. I do want there to be justice for Charles. I think that's extremely important. I'm frustrated that she's representing herself, because then it turns into like an entertainment value versus anything to do with justice for Charles. And I don't know, I feel like I almost kind of closed that door once the Idaho stuff was done. But then I obviously, that's why I'm like, subconsciously, I obviously haven't, because I still go watch all of her shit. So I don't know. I don't know. I don't know. I do plan on covering. I got some Idaho stuff I want to talk about, especially now that even more shit came out. I do have some Delphi stuff that I want to talk about. I'm not really in the headspace to do that currently. And then Karen Reed. I think Karen Reed will be the next big thing that I kind of cover. That's going to be more time consuming. I still have an entire presentation on the Flora fires that I wanted to do with you guys. I have, after that, we've got Crystal Rogers. I mean, there's just so much. I know a lot of people are covering Adelson, or it's what I watch, but I'm not really invested in the outcome, I guess. Like emotionally, like you get attached to certain cases and you don't get attached to other cases. Like, I don't know how else to explain it. Like, it's just not one that I'm like overly attached to her outcome of her trial, but I like the creators that cover it. So I may watch some of that. Anybody that goes pro se is worth a watch. My thing is about the Delphi thing. Did I miss a question? You want to do a stream where you say, I'm not mad for hours and then attack someone? LOL. I'm sick of the drama and personal attacks ever. That's kind of, yeah, I don't care to do that. I just don't care if people don't like me because of my opinion. Fuck, everybody's got one. I mean, we can go through that whole thing. Like, my thoughts and opinions on stuff like pisses people off. Well, guess what? Like, your thoughts and opinions on stuff pisses me off, and who gives a shit? Because sometimes we will agree and sometimes we'll disagree. I just don't care. I just don't care. People really, really want me to care, and I just don't. I can't make myself care. I just don't care if we agree. I will state my opinion, you state your opinion, and we all live happily ever after, because guess what? At the end of the day, you're going to go home, I'm going to go home, we're going to go live our lives, and that opinion about that case or opinion about whatever isn't going to be relevant. But if we sit here and start just attacking the shit out of each other, it just becomes like the main focus, and I don't want to do that. I mean, fuck, you guys all know there's people out there on the Delphi streets that I just do not like. I just don't like them. I just don't watch them, or I won't listen to them, or I just try to stay away from them until they try to involve themselves in my life. which, Delphi, that does happen. So that's why I'm like, I get it. I get like that there are people who do the threats. I get there are people who are just nasty on the internet and will say really fucking mean things to the investigators. There's got to be a point where you either just say, fuck it, I'm going to say what I know, or I'm going to say what I know I can, or I'm going to fucking bounce. Shaking the Diaries of a Fence Sitter. Ain't that a fact? Ain't that a fact? I'm not a fence sitter anymore, though. I don't think I am anyway. I mean, there are definitely things I sit on the fence with, but I disagree with almost everything my husband does, and I still love him, and I even sometimes like him. That's my life, too. The footnote feels they didn't. Oh, hold on. Let me see what Brianne asks. I'm tired of the opinion gatekeepers, the come on guys, we feel. Yeah, I think that's more it. Like, you're not allowed to think anything different than me, and if you do, you're just you're an idiot. You're stupid as fuck. You're just, bottom of the barrel trash cans. I'm like, why do I need to be degraded because I don't agree with you? Like, whoopity-doo. Who cares? You've got people who agree with you. I've got people who agree with me. And then that shit changes every case. Mine too last night. Very vague and no information. Yeah. Where was I going? I'm trying to decide. Oh, yeah, I do. That one was tough. I didn't go knocking on her door asking her questions. She coordinated a live under the title that she was breaking her silence, then was taking pauses before answering and asking things and saying things like, I'm trying to decide if I want to die tonight. That's kind of where I was at. Like, I really wasn't understanding the purpose of it. I wanted some more clarification. I finally got a little bit more clarification throughout the live. When chat became more involved in the questioning of things, it was just, I don't know. It wasn't the end. The end of it just wasn't really. I didn't stay around to the end. I had other stuff to go do, but I just didn't really get the. I didn't get to underlying reasons of what. I don't think there was like a full purpose. Like, maybe an outline might be better. Maybe an outline or a rewritten script. I don't know. But once again, I'll say the same thing. That's just my opinion. So who gives a shit? It's like guilt posting. I disagree with somebody was talking. Who was it that was talking about the knife? The knife. Do I think that in Idaho they proved that he bought the knife? I think that what they did so far was introduce that they are going to have proof that he bought the knife for himself, even though it was under an account that belonged to his dad. But hopefully we can talk about that on an Idaho live. So, what in the world are you talking about? Kind of talking about everything, Law Junkie. Talking about it all. I bet she launches a YouTube channel of her own in 6 months. It was you. I thought it was you, but then I couldn't find it. We've got the forensic pathologist now starting a podcast. Speaking of podcasts, I'm going to start some drama on a podcast. No, I'm not going to do it. You are one of the few I respect. Critical thinking and common sense, not so common these days. You got it, girl. Truth and justice matters, baby. Well, thank you for that. I appreciate it. I really do appreciate it. I try not to be a dick. Sometimes I'm a dick. Sometimes I get feisty. Sometimes I'm in a mood. I'm a fucking human being. Things happen. It is what it is. They bought a knife, which they found at his house, apparently. That's the word on the streets. But we will see. Lots of... Wait. You're saying that the K-bar that was bought on Amazon that they actually found in his house? Is that what you're saying? There's lots of evidence. That's just going to be, whether you think he's innocent, he is innocent, he's not been proven guilty, but whether you think he's factually innocent or factually guilty, at the end of the day, that trial is going to be incredible to watch for the legal expertise and just the insights and hopefully some clarity on what actually happened in that case. But as we all know, you can't count on the fact that you're going to get all the information. We now know based on all the motions in limine, they are not going to be introducing anything to do with the IGG. So look, we've spent 2 years talking about IGG, and that was it. Like, and it's gone. It's not going to be talked about. So not everything, we're not going to learn everything, but I think it's just going to be one hell of a legal trial to watch. But I kind of feel like they're really pushing for a plea deal. But that's my opinion. They have that knife which he purchased. Yes, I heard on Jules last night for where I heard that they actually have the knife. All right, I'll go listen to Jules. I love Jules. I am hooked on, even if we don't agree on everything. If Gray Hughes left like you, I'd actually bother to watch him. The thing with Gray is he's so smart. He really is smart. He just is sometimes just so mean. He's just so mean. So people just don't like to watch him because if you don't agree, it becomes very hard. But I actually think maybe that's part of the thing, is maybe he is. Anne does say he's innocent. He's very full of himself, but he is. I mean, he's intelligent. So to say like, hey, I'm intelligent, I know what I'm doing when it comes to XYZ, but then it's just like, yeah, all these other people are idiots and they're so stupid, and I don't know. It makes it really hard. So, but to say that I won't say that I don't watch Gray, because I do. There's certain cases he talks about that I watch, certain ones I don't. And he's a huge advocate, he's a huge advocate for IGG, and has done a lot with like Fitzpatrick and her organization, and identifying John and Jane Does. That's something that's really important to me. So there's like a love-hate thing there, I think. You know what I mean? He's always asking why no one's chatting, and that's because people don't want to get yelled at. Yes. Evil doesn't take time out. Ain't that a fact? What are you doing to my phone? Oh, I already showed you that. Okay. All right, you guys. I'm gonna wrap it up. I'll see you guys in the morning. Yeah, well, we're gonna stick with Todd Mullis for right now, but I do, like I said, a ton of stuff happened with Idaho that I do want to talk about, so I'll have to do like a little catch up live, and then eventually here I'll do Delphi and we'll talk about some things. Other than that, yeah, Adelson's just not for me, I don't think. And then Lori Vallow, I don't know. I'll go back and forth on it, and then I'll make a decision probably based on timing. And yeah, disagreed with me on the rose petal case. It made it more interesting. We didn't walk away like, oh my God, I hate you, you're so dumb. Or you saying like, she's such an idiot. I mean, maybe some days. We know everything in it. Yeah, that's just not a case for me. So probably Lori Vallow based on timing of what ends up happening with her case. She's like refusing to give up her right to a speedy trial, even though she wants a bunch of things done in order to, represent herself and defend herself. But that's just not how reality works. And she just she has no give. So, yep, I will see you guys over on Bob's. I am excited to watch his interview with now I wanted to say Stacey Adelson, Stacey Eldridge, who was the defense's expert on the extractions on the phone data. I can't wait to hear what she has to say, especially now that we have this video that is stated it is from Libby's device, and the metadata shows that it was from February 13th. So, oh yeah, and Andrea Burkhart, who I love. I love Andrea Burkhart, and I don't agree with her on everything. So, just shows you. Okay, go enjoy the rest of your Thursday. I will see you guys in the morning, and or I'll see you guys on the YouTube streets, and I'll see you guys in the morning. Thanks for hanging out with me today. It was a long one. So, hasta mañana.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one the unknown.